There's nothing in there.
No, there's not.
So you, throughout this process, sent out all of these text messages that are represented by your exhibit number 147, which has been introduced into evidence. And throughout that level of correspondence between you and Mr. Hyder, you never once indicated to him that you expected that D2 Properties would own the plaza or the shops. Is that right?
We never talked about that over text.
Okay. But you did talk about it. You did talk about it on the first day you went out there. And Donnie told you that he was going to keep the shops.
We talked about it on the first day we went out there, and we may have talked about it again on a subsequent visit, but right around that time. But I think most of it was on the first day.
Okay. So tell me this, what writing, if you have any, that indicates that Mr. Hyder, at any time during this process leading up to the closing of that transaction, sometime in the mid part of July, or the latter part of July, whenever it happened, indicated to you that D2 would own the plaza or the shops?
The discussion we had was that he would own the shops, as he was not putting any money towards it. I didn't see how it was even possible for him to own any land in this transaction.
Okay. So you will agree with me then that Donnie Hyder never represented to you that he was not going to own the shops. It was just your interpretation that because he wasn't putting any money in, that he would not own anything in the deal. Is that correct?
I just want to clarify, because when you say shops, what I hear are the buildings. And what I think you might mean is the buildings and the land. And as I explained yesterday, in my understanding of that was different. And so we were on a different page from the very beginning of that. And so when you say shops, and I just want to answer your question correctly, I think of the buildings on top of the land. So if you want to say shops and land, then that would be clear for me.
And what was the term that Donnie used?
Shops.
Okay. And when he said the shops, your understanding was that he only meant the buildings and not the land?
Yes, like the tissue box on top of the desk thing.
But you have no doubt that his understanding was that he meant the building and the land.
At this point, after this, well, actually before this litigation, sometime around March 2017 is when I realized that he had somehow conveyed that land to himself.
Okay, but what I'm asking you is, you understand at some point in time before March 2017 that Donnie Hyder meant buildings and land when he used the term shops.
That is not correct.
That's not correct.
I understand as of around March 2017, that's when I was looking at these parcels, that's when I realized, because I was looking up the tax records, that's when I realized that somehow that land was conveyed to Mr. Hyder.
Right.
To Bristol Consulting specifically.
I understand that. But I'm trying to understand what point in time, if any, before March of 2017, you understood that shops meant building and land per Mr. Donnie Hyder.
I didn't have that understanding prior to March 2017.
Okay.
Or about that time.
Now I understand you're not a commercial real estate professional, right?
Correct.
But you have had, at least in one instance, experience at developing a commercial property, which is your own practice's medical building. Is that right?
Correct.
And where is that building located?
2061 Peachtree Road.
Okay. And that's in like the Buckhead area, right?
That's right across from the Shepherd Spinal Center near Piedmont Hospital, Atlanta.
Okay. All right. Lower Buckhead.
Yeah, I guess. I'm going to say upper Midtown, but yes, lower Buckhead.
How much is that building worth? Or how much did it cost when you guys built it?
So we acquired the land for right around 2 million or 2 point some million. And then we built the building, and I think we were in it all for about think it was somewhere around like 10 to 12 million. I don't remember the specifics. I didn't look at any of those details in preparation for this case because it doesn't seem relevant to me, but.
Okay. Well, it's relevant in this sense.
Okay.
You don't need to explain why it's relevant. You can ask
I'm
questions.
sorry. Well, 10 to 12 million dollars all in.
And yeah, and the reason it's a little bit hard for me to say that is because then eventually we had a land acquisition loan, we had a construction loan, and then we had a final financing package, and that was through Fidelity Bank because they happened to be a tenant in the building that our development partner had leased up space in there for them. And so I think that note was at 16 million, and the building had to have a valuation of, or maybe the valuation for that note was 16 million. The low was a little bit lower, but it's something around that number.
Okay, now tell me if I'm wrong, but you were in partnership meetings leading up to the building of this particular medical building, is that right?
Correct.
And you played a role in the discussions regarding the building of this building, is that right?
I did.
And you participated in decisions that were being made on this building, is that correct?
It is.
And you guys hired an architect, is that right?
Yeah, we did.
You had a developer, is that correct?
I had a development partner.
You had a development partner. And this building is a multi-tenant building, is that right?
It is.
And how many square feet are in this building?
50,000.
50,000 square foot building is valued at somewhere around at least $16 million.
Yes.
Okay. Do you know if Donnie Hyder had any type of experience that's comparable to your experience in developing that building as a member of your medical partnership?
I don't know what Donnie Hyder's experience is prior to 2015.
Okay. Do you think Donnie Hyder, prior to 2015, had any experience developing a multi-tenant commercial building of 50,000 square feet worth $16 million?
I have no idea what Donnie Hyder did prior to 2015.
And you didn't ask about anything that he did prior to 2015?
We talked a little bit about his portfolio and that sort of stuff, but he just really wasn't open about that information. He kept it private.
So you didn't see fit to ask him about it or not?
It didn't come up at that time in 2015. And then in 2016, around the Verbena properties, at that point, it was simply, this is what I do. I've got this. This is how we get this done. That's how you do it if you go to traditional financing. This is how we do it. I have experience in these situations and these projects.
Well, when he said that, let me ask you about that. Let's break that down a little bit. When he said, this is what I do, was he talking about this is how I operate with people and put deals together on these residential deals? Or was he specifically talking about, oh, I'm a multifamily housing developer of 277 units apartments?
Oh, he conveyed very confidently that he could do the financing and rehab of those. And he was talking about doing the rehab himself. It wasn't like I'm going to hire like a big construction company. I mean, he dropped names every now and then of some big construction companies, but he was going to do it and he was going to run the subs and he was going to do all of that. And he conveyed that to me. And that's in emails.
Okay, are there any emails wherein Mr. Hyder says that D2 is going to own the plaza or the shops or the retail portion of this project?
There's no emails discussing the shops and land either way.
Okay, and the only document that you ever signed regarding the Verbena situation in terms of a contract was a document we looked at yesterday, which was our exhibit number 5 and your exhibit number 5, the standard offer form.
Correct.
Okay. Now, we touched on, or at least started to touch on, the two reiterations of what the contract agreements were, as you understood them. That was first the standard offer and purchase, which we talked about, exhibit number 5. And then that deal expired on June 30, 2016. And at that point, you guys had engaged the Victoria group. They didn't come through. And there was an email that you sent out or a text message you sent out to Donnie saying, hey, let's get our money back. Deal is done. And then at some point in time, you and Donnie had a conversation, a verbal conversation on the phone, right?
Yes.
And at that point, you guys rearranged the deal somewhat. Is that right?
We did.
Okay, tell me what your understanding of the rearrangement of the deal was.
So Donnie was still talking, or he was texting me that he was talking to the Victoria group as of July 1st. So after the expiration of the contract. And then within a few days, he contacts me and we'd have a conversation on the phone. And he's like, how about your buddy, Robin? And you think he can come through? And I'm like, well, I don't know. And he's like, well, if he can come through at $2 million, then we can use that money and we can use it to purchase the land at 1.2 million. We can use it to pay off the loan that Dr. Fowler has already forwarded, which is $230,000. We can use it to cover carry costs, closing costs, and then we can use the remainder of the money to carry the property. It wasn't, and then we'll use the remainder of the money to put in my bank account. That was not the deal.
Well, but didn't you sign off on a settlement statement that gave him $457,000?
Yes, and prior to doing that, I confirmed via text message that that money was to be used for carry costs.
Okay, and who was that text message to?
It was to Donnie, and he replied, absolutely.
That was a text message.
It was a text message on either 7/11 or 7/12 is my understanding. I can find it though.
And you're talking, is that the text message where he said something to the effect of, let me earn my money?
If you give me one moment.
Text message, 147.
The text message is on page 54 of our exhibit 147. It is on 7/7/16. And I began the conversation about what account is the money going to go into, Crystal, and he replies, Crystal Kimbrough, the attorney, the attorney. And then I go, in escrow, after all closing costs are paid, where is the balance going? To me, of course. So, and then you'll be paying carry costs from that money, if there are any. His reply, absolutely. And then he says, but John, let me see some fruits of my labor. Let's try to get that stuff on the back if we can. Hopefully in 30 days or so, we can pay principal and interest and all fees when credit union comes through. Another promise for the credit union, which never materialized. That was it. But let the note be for minimum 6
I'll let Mr. Kendall go. You've answered his question. You've pointed to evidence in the record. Back to you, Mr. Kendall.
Thank you. So the sole understanding about that $457,000 is contained in these text messages. Is that right?
That is not. It's between a conversation that we had before I even approached Dr. Fowler. And it's also embodied in a communication to my brother via email in which I stated the same thing about what that money would be used for, and a communication to either Sam McGuire or Robin Fowler or both in an email regarding the same exact thing, that this is what that money would be used for.
And what email is that?
Yesterday, there was an email, I think it was one of our exhibits, in which it was a conversation between my brother and I, and he said, what's that money, the Bristol Consulting money? And I said, that's for carry costs.
Well, if it was for carry costs, wouldn't it have been wise to have placed that money in escrow of some sort?
So there are lots of places where I was not wise, and this is clearly one of them.
Okay, but where is the fraud on behalf of Mr. Hyder based on these emails that I'm looking at right here?
The fraud is that his assertion that he would use those monies for carry costs and then his failing to do so.
Well, I read this as being somewhat ambiguous.
So your interpretation isn't what we're here with.
I need to preface my question to him with that interpretation.
Well, ask it differently.
Is this not ambiguous? These text messages that we're talking about right here, where he says, you say, where's the money going? Where's the balance going? And he says, to me, of course.
And then I confirm, and then he says, absolutely. And that word absolutely is not ambiguous to me.
Okay, well, but let's deal with the first part. To me, of course. What does that indicate to you?
That I need to ask a clarifying question, which I did in the following text.
And then you say, and then you will be paying carrying costs from that money if there are any.
Correct.
Okay, now what is the definition of carrying costs?
Carrying costs are all those pre-development costs, such as insurance. It could be interest payments. It wasn't in this case. It could be water, electricity, could be surveys, could be architectural plans, all the things that are part of developing that property.
Well, the term carrying costs, Mr. Dalton, does that not mean interest carry?
It means more than interest carry. It's all the costs associated with the ownership of the property.
Did you and Donnie ever discuss carrying costs as to what was expected of him in terms of paying carrying costs?
We did not go through a litany of a list of things that were going to be in that category or not in that category. No, we did not.
So there was no agreement in writing that talked about him paying any carrying costs. Is that right?
That is correct. There is no agreement in writing except for these text messages.
Except for these text messages.
Correct.
Okay. And because he didn't pay what you consider to be carrying costs going forward, you have filed this claim on him for fraud.
Correct. That and other things such as misrepresenting himself.
Let's just deal with that that's part of your fraud claim.
That's part of it, but it's a multi-part claim.
Okay. All right. Well, we're going to get to those as well. So these 5 text messages starting at 7/7/16 at 20:10 a.m. Where you say in escrow, after all closing costs are paid, where is the balance going? He responds, to me, of course. You say, and then you will be paying carrying costs from that money. And then the next text says, if there are any. And he says, absolutely. But John, let me see some fruits of my labor. What does that mean to you?
I was unclear because we never ever discussed what that would mean either. So I would assume it means that some monetary compensation for getting the property across the finish line, but we never discussed that.
You never discussed an amount.
We did not.
So when he says, let me see some fruits of my labor, you admit that meant some payment to him.
I assumed it would mean some payment to him.
But you didn't think it wise to go back and say, well, okay, let's have an agreement about what money you actually get out of this closing.
If you refer down the page a little bit more, I say, I absolutely want you to see the fruits of your labor, but let's not lose sight of the bigger picture. Brian and I are tapped out of cash. We will all have plenty of fruit soon enough.
Okay. So does that in any way resolve the issue?
Neither Donnie nor I continued on that line of discussion. And certainly I did not feel that the fruits of his labor at that point were worth $457,000.
Okay, well, I understand you may not have felt that way, but he may have had a different feeling.
Yes, you're right, he may have.
Okay, so my question though is, because you've made this an issue about the $457,000. In fact, you said it's fraud. So I'm trying to understand, based on these series of text messages, where you and Donnie Hyder came to a clear understanding that he made a misrepresentation to you that induced you to go into this transaction by receiving that $457,000.
When he texted the word absolutely.
So you take out of all these words that are in here, his text of absolutely is the word that's the most operative word in this text.
I believe so.
Okay. And even though you also use the word, I absolutely want you to see the fruits of your labor. And you stated here today that to you that meant that he was to get some money out of this.
I did. We all were to get some money out of this.
Okay, but then you say, but let's not lose sight of the bigger picture. Brian and I are tapped out of cash.
Correct.
Okay. We will have plenty of fruit soon enough.
Correct.
Okay. But you believe that based on these texts, 1, 2, 3, 4, 5, 6, 7 texts, that Donnie Hyder committed fraud. By use of the word absolutely in response to your text about where is the money going.
It also calls for a legal conclusion. Sustained.
I asked him, what did he believe?
Next question.
Do you believe that this text message indicates that Donnie Hyder committed fraud?
Same ruling.
Tell me, Mr. Dalton, if you can, any other communications that you had with Mr. Hyder regarding the use of that $7,000 that he was paid at the closing of this transaction?
We had multiple communications about that via phone conversations. And we had arguments about the use of that money. And I talked a lot about those yesterday. And then his refusal to do so. Initially, he was like doing a little bit, and then he was doing half, and then he was doing none. And that was over a period from the closing to October. And then there's the half on the architectural fee. And then there's the none starting in November and December.
Now, how many phone conversations did you take of Mr. Hyder?
34 conversations.
34 conversations. And how many hours do these conversations represent of time?
I don't know, but I think I heard my counsel say yesterday it was 12 hours, but I would be guessing.
12 hours of conversation. Now,
that's a guess.
Yeah, okay. And yesterday, I think I heard your counsel say that you're going to play 10 minutes.
I'm not sure how much we played yesterday.
So of these 12 hours of conversations that you taped, now, did you ever tell Mr. Hyder that he was being taped?
No, I did not.
Okay. So you so repetitiously taped him. He didn't know he was being taped.
That's correct. He did not know.
Okay. So out of that 12 hours of tape conversations yesterday, you played 10 minutes. What about, are there any other conversations in that 11 hours and 50 minutes where Mr. Hyder talks about that $457,000?
And so I need more because I don't know what part of the form troubled you.
A lot of the parts, but he hasn't indicated that the $457,000 were ever part of the tape conversations. The question is asking the witness to comment on whether something is in audio tapes, which are in counsel's possession. And so it's not, wasn't there. I mean, I understand the purpose to set up to impeach if he gets it wrong. The question wasn't asked.
So ask your question again. And now that I understand what the concern is, I think I can rule, but if you repeat your question.
I'll try to remember it.
Well, as close as you can. You know where you were going.
Out of the 12 hours that you say were taped, you played 10 minutes yesterday, I understand. The question is, in the remaining 11 hours and 50 minutes, are there any discussions about the $457,000?
All right, before you answer, that's an appropriate question. And if you know the answer, you can provide an answer.
Okay, thank you, Judge. There are no discussions about that $457,000.
Out of the 12 hours of taped conversations that you did so repetitiously of Mr. Hyder, are there any discussions about D2 owning the plaza, shops, retail portion of this project?
There are not.
Now, I think we also started talking about the second phase of this deal. You said that, I got a couple of questions I want to ask you about that. You said that after the deal did not close on June 30, you and Donnie had a conversation sometime in the first part of July. Is that right?
Correct.
You okay? Do you want to pause for a second? No, okay, keep going.
After that phone call, you guys changed the deal up. And you agreed that $3 million was a strike number. Wagner was due 1.2 million. The closing costs would be paid. The $230,000 that had been borrowed from Fowler Financial would be repaid. And the rest of the money would be due to Donnie on the back end. Is that your understanding of the agreement?
I think you left out the carry cost, but if
Yeah, carry costs,
yeah,
whatever that meant.
yes. There was money due to Donnie on the back end, and I think you described it correctly.
Okay, and that he would have a 25% interest in the project overall.
Correct.
Okay. Now, after that deal closed through the use of the $2 million that Mr. Fowler injected into the deal, which was a 6-month loan, right?
Initially, it was to September of 2017.
Right, which,
I think that's like 3 months or something like that, a couple of months.
no,
So sorry, September 2016. I think the first modification was sometime around to September 2016, and that pushed it out.
now I'm asking about the original term in the loan.
I'd have to refer back to it, but I'm pretty sure I had to go to the Fowlers in September of 2016 to get an extension. But either way, we got an extension and got an extension and got an extension.
Right, you got 3 extensions
Correct.
and you paid money for those extensions, 2 of them.
I did pay money for 2 extensions.
All right, but you never paid any interest on the loan.
The terms of the loan were that the interest was going to be handled at the end of the loan at final payment.
Right.
So it was accumulating during that time.
Okay. So in 2017, and I think we looked at your extensions, the last extension, I think, took you to June of 2017. Is that right?
That is correct.
And as of that particular date, no financing had been procured. Is that right?
That is correct.
Now, your testimony throughout has been that it was Donnie Hyder's responsibility to provide the financing. Is that right?
It was.
But you've also stated that there's nothing in writing that confirms that. Is that right?
There's no direct contract as to that, but there's lots of stuff in the text messages and through phone calls, but nothing. The text messages is writing, I guess, and emails about I've got this guy. So he was doing that work, I guess.
Yeah, he was you acknowledge that he was working on getting financed.
I don't know what the extent, like the hours were put into it, but for sure he was definitely presenting different, hard money lenders.
Okay, so he was out beating the bushes for the money.
I don't know the extent of the hours he put in to do that, so I'm not sure what beating the bushes means. But I'm not sure if it was an all day, all night thing, or if it was, okay, this one fell out and I'm going to go down the next list. I'm going to call this one guy and say, send me a letter. But my question is this. Do you have any doubt that Donnie Hyder was sincerely trying to find the financing for this project? I didn't have any doubt about that until the November deal, where when he we had already lost the property in November 2017. He comes back to me with a
No, I'm talking about before you lose the property.
Oh, before you lose the property?
Before you lose the property, you have no doubt that, do you? If you do, tell me, and I want to know if you got anything in writing that kind of indicates that. But up until you lost the deal in September of 2017, excuse me. Up until you lost the deal in September of 2017, did you have any doubt that Donnie Hyder was putting in his best efforts to try to find financing for this project?
Up until June or August, September 2017, I believed he was working to try and get the financing done.
And that was after he had already closed on the deal and been paid $457,000.
Tell me, what about the objective form? Isn't an actual evidentiary objection? That may be a deposition thing, but I can never sustain, I won't say never, I typically won't sustain an objective form. You don't have to apologize. I'm just going to always say, you need to tell me more. I don't know how Mr. Kendall would necessarily even know, but tell me the concern.
I tried my last trial in a different state, and that's all we were allowed to say.
Wow.
And then the judge would ask for further questions, and so now I got to untrain myself back to Georgia. I apologize.
It's okay.
I object to the form of the question because it assumes facts, misstates facts, and misstates the
What was the last part? There was a jail door closed.
It misstates the claim.
Okay.
Said Mr. Hyder was paid, and that's the whole point. The claim is that he took.
Okay. So if you don't mind asking the same question, but say received, maybe we'll clear that hurdle.
Okay. Mr. Hyder, do you have any doubt that after the closing of this transaction in mid-July of 2016, after Mr. Hyder was dispersed $457,000, that he continued to use his best efforts to obtain financing on this project?
I do believe that.
Okay. So he didn't just take the money and run, right?
He took the money and ran. Didn't run in that he wasn't still doing some work. He just took the money and it went away. So I don't know if I ran. I think that money's not anywhere near where I can get to it. So that's taking.
Mr. Dalton, after mid-July 2016, this property was 100% owned by D2 Properties, right?
When you say this property, what do you mean?
I'm talking about the Verbena Street property.
Yeah, I was under the impression that all of it,
Okay.
but actually only the apartments were.
Acknowledged. I understand that. But this, you understood that this property was in the name of D2, which is owned solely and singly by you and Brian Dalton.
Correct.
Mr. Hyder had no ownership interest of your entity, right?
So we're getting into he's testified a bunch of times. His understanding of what he owned and maybe your clients is different. So we're going to get objections to form because
I acknowledge that. I acknowledge that there's a distinction between what he thought he owned and what Mr. Hyder may have thought he owned. I acknowledge that. But whatever he owned, you owned it 100%, not Mr. Hyder.
That's part of the issue here is that there's a debate about whether some of it was owned 100% by D2 or by, I don't remember which entity, if it was Mr. Hyder.
All right, let me rephrase the question. D2 is owned 100% by you and Brian.
Correct.
Mr. Hyder does not own D2.
Correct.
Okay. So the financing that Mr. Hyder was attempting to obtain was for the financing of the apartments, right?
It was for the financing of what I'm calling the Verbena properties. Because there seems to be a distinct disagreement on if it's apartments or apartments plus a retail plaza. I was under the impression that those two things, and I've labeled those things just to define my terms as Verbena properties. And so that financing was to be for the Verbena properties, and that was my understanding up until about early 2017, around March.
Right. So the financing would have included the apartments.
Correct.
Which there is no dispute that D2 owned the apartments, right?
Correct.
Okay, and after the closing in which Mr. Hyder was dispersed of $457,000, he continued to work to obtain financing for the Verbena properties, including the apartments.
Correct.
Okay. One of those parties that he tried to obtain financing from was the Victoria Group. That failed, right?
Correct.
He was also working with several other potential financiers that you are aware of. Is that right?
Correct.
Because he would ask you to provide financial documentation on you and your brother and D2 in order to submit to the various potential lenders that he was then presenting financing proposals to. Is that right?
Correct.
And that went on after the closing in mid-July of 2016.
Correct.
And you participated in those requests that he made to obtain financing. Is that right?
Yes, we did.
And then we saw some text messages and maybe some emails yesterday about a credit union. Do you know who that party was?
I do not. I do know that Mr. Hyder, prior to or during the phone call regarding the restructuring of the deal and approaching Fowler Financial, mentioned that this credit union was ready to go. We just had to get the final commitments. And there's a text message later. I mean, first off, there's a text message we've kind of read about already this morning. There's another one a little later in which it references a credit union again.
Okay.
That's the one where we're supposed to not turn over the $230,000 yet, or not supposed to ask for the $230,000 back yet, because we haven't gotten the final confirmation from the credit union.
Right. And then there was another financier yesterday that I think he kind of indicated that he did not want you guys to disclose that money had been borrowed. That was another financier, and you explained that yesterday.
That was also the Victoria Group's people.
All right. Now, there was an email, I think you mentioned, getting back to the 457 for a second. I think I'm gonna need exhibit number, let's see. Well, let's go to 63. I want you to look at what we're gonna try to put up here as exhibit number 63.
This is plaintiff 63,
Plaintiff 63.
already in evidence.
No,
It is.
I'm sorry, defendants 63.
So don't put it on a screen yet if it's not in evidence.
That's true. Let's look at defendants number 63. See that document?
I do.
Have you seen that document before?
I have.
Okay, can you explain what it is?
It's a non-disclosure agreement between Bristol Consulting, Donnie Hyder, and Robin Fowler.
Okay. Now, Robin Fowler is your friend that you described yesterday, who's an anesthesiologist, right?
Correct, Dr. Fowler.
And Dr. Fowler was the one that made the $2 million loan to D2.
Through Fowler Financial, correct.
Fowler Financial, yes. So why is, well, first of all, can I move? I want to move to introduce this document.
Because this isn't with my client, it's with Mr. Hyder and a different person and entity, so I don't think my client's the proper witness.
He says he's familiar with the
So
document,
hearsay.
he's seen the document before.
It's hearsay from my client. He's seen it, but you can't authenticate it because he wasn't a party to the terms.
Is there a different witness through whom you ought to admit this?
I can admit it through any number of witnesses, including him. He says he's seen the document. I want to ask him questions about it. He's familiar with the document. That's all I need as far as authentication.
Ooh, how is it not hearsay? It's not his business record.
I'm not asking him for the truth of what's in the document. I'm just asking him about his understanding of the document.
Okay, well, why don't you ask him? I don't know that, certainly, we're not going to publish it right now, but I'll let you ask him questions about it.
Okay, the question is, why, to your understanding, would Mr. Fowler and Bristol be executing a non-disclosure agreement?
Okay, so I don't see a date on this, so I don't know. I'm familiar with this document through this litigation.
Now, the first line of the document,
Okay, so,
non-disclosure agreement is entered into as of December the 6th, 2017.
okay, so this is the time when, around the time when Donnie had come up with a final attempt, ends up being the final attempt at financing. And so in order to do that, we had to get the property quote unquote under control. And so this is, I assume, a document around that situation.
Okay, now this document, which is dated December the 16th, 2017, is after the property had already been foreclosed on, right?
It is.
Because the property was foreclosed on in September of 2017, right?
Correct.
So did Mr. Hyder approach you about some other deal post foreclosure?
After foreclosure, he did approach me about a deal sometime in November or about that.
And were you in agreement with pursuing his proposal?
I agreed to pursue it, but I was incredibly wary because this happened just after the demand for that $100,000 of extortion money and right around the time of me making that first $50,000 payment. So I was very wary of anything, and I certainly wanted to honor my side of that extortion, if that's even a word, honor of.
Judge, I'm going to object to Mr. Dalton referring to a payment he voluntarily made as extortion. Extortion has a criminal context, and I don't think it's appropriate for him to characterize this is not a criminal courtroom. So I don't think he should be referring to that payment that he voluntarily made as extortion.
So, ladies and gentlemen, this is not a criminal case. No one in this case is being charged criminally.
Are you gonna instruct him to stop?
I am not.
You're not.
I am not.
So he can continue to claim that Mr. Hyder committed a crime in front of this jury.
No. You're ascribing that meaning to it. Next question.
Okay. You said that you were not in agreement with the proposal, or you were in agreement with the proposal?
I agreed to move forward, but after that payment demand, and I'll change how I describe it, I'm happy to do that. After that payment demand and my decision to capitulate to that demand, then I just wanted out. And so, but I also understood that Mr. Hyder had made very clear his intent to sue my brother and I if for any reason he felt it was okay. And so it wasn't clear to me what his reasons would be. I was just trying to keep the peace. And so if he wants to give it one more try, I had zero faith in that. And I also came to understand through that dealings that there was an ulterior motive there.
And what was the ulterior motive?
He was trying to vindicate his friend and attorney, Crystal Kimbrough, from this, issue with her title insurance, and trying to get Sam McGuire to release this claim on the title policy, and that is documented in multiple emails.
Is there anything in this document that indicates that?
So the contents of this document aren't in the record right now, because this isn't a witness who can get this document in.
No, I would also object to this witness, all the contents.
One reason why this document's not in the record right now.
Okay. I also want the record to reflect that I take exception to that ruling. So how did this proposal end up, Mr. Dalton?
Which proposal are you referring to?
Proposal that you said Mr. Hyder presented to you and to Mr. Fowler that had the ulterior motive.
You're referring to the one November through end of December 2017?
Yes.
It did not come through.
Okay. Now, at the same time, you were negotiating with Mr. Fowler for a redo on the project as well, right?
I approached Dr. Fowler in November to see if we could get the property back under control. And from that point forward, I had no further negotiations with Dr. Fowler regarding this property until this deal had gone away.
Now, that was an email that you sent. I think I'm going to need number 72. 72. This is going to be, well, I'm sorry, number 73. Number 73. Can you look at number 73, please?
I have it.
Okay. Have you seen that document before?
Yes, I have.
Is that a document that's addressed to you?
It is. It's an email from Sam McGuire to me.
Okay. And it was sent on what date?
February 10, 2018.
I'd like to move to admit document number 73.
Defense 73 is admitted.
Now, this is a document regarding your discussions with Mr. Fowler about you continuing to pursue the Verbena Street properties. Is that right?
Correct. This is part of those discussions.
Can we publish them?
You are free to do so.
Yeah. Now this is approximately 5 or 6 months after the property has been foreclosed on. Is that right?
Correct.
And the subject line says discussions regarding Verbena, correct?
Correct.
And this is Sam McGuire. Sam McGuire is the attorney for Mr. Fowler, right?
For Dr. Fowler, yes.
With Dr. Fowler, yes. And it says here that he's thanking you for your calls over the past several weeks regarding ideas about Verbena and its future. So how many calls that you made regarding Verbena and its future after the property was foreclosed on?
2, 3, maybe 4. I've reached out both to Sam and to Robin regarding it. So I'm not sure if he's referring just to the calls to him or to the calls to Robin also.
And was Mr. Fowler, Dr. Fowler, I'm sorry, receptive to your calls about the Verbena property and its future?
Well, there's a story behind why I started making those calls in the first place, and I'm happy to tell that to you if you're interested.
Well, I'm just asking, was he receptive to your call?
To part of it, he was open to some ideas that I presented.
And what were those ideas?
So Donnie and I had discussed the problem that Donnie had, this paranoia, I guess, that the Robin Fowler and Sam McGuire were acting either individually or in concert to develop the property, and that they were going to do that under our noses, and that was basically stealing money from Donnie, and that my buddy Robin isn't the guy who I think he is, and he is clearly trying to screw me too. And so I reached out to Robin Fowler, and I told well before this email, 2-3 weeks before this email, told Mr. Hyder that I was going to do so. And because I was like, I don't think he's developing anything. Mr. Hyder had these certain assertions because Dr. Fowler had cleaned up the property. He had put up fencing. He had put up some power poles. So he brought some power into the property for security purposes and lighting. He then made a verbal inquiry as to whether or not Mr. Hyder was interested in selling the retail portion of the property. With those things, and Mr. Hyder felt that Fowler and or Sam McGuire were going to develop that property, and he felt that was ingenuous to us as Donnie and John, and also not good for Donnie and not good for John. So, and we have these conversations, and they're taped, and they begin on or around 1/22/2017. There's another on 1/24/2017, and another around 1/29/2017, all before this email. During those discussions I had with Donnie, I was like, Rob has told me he's going to sell the property. That's it. He's going to sell the property. He's not interested in developing it. In fact, we had approached him in September of 2016 and later in March or so 2017 to see if he would help us fund us to develop the property, and he declined. So he's like, I don't want to be in this. This is not my business. This is not what I do, and I'm going to sell the property. Donnie also said he had some very sensitive information. He kept calling it sensitive information. He didn't disclose it, but it's in the phone calls and those dates that I mentioned. I think towards the end, like the 129 phone call, that he has this sensitive information that he knows that to be untrue, that they're going to develop the property and basically steal it out from under us, even though it was their property. So I say, well, I think that's not true. And once again, I'm just trying to get out of this thing. And at this point, Donnie is like, you need to sue Robin and Sam. And I'm like, I'm not suing Robin. So I don't. And during that, he's like, well, if you don't, I'm going to sue you. So I'm like, well, how about this? Let me prove to you that this development's not going to happen. So I go to Robin and I say, Robin, you can develop this? He's like, no, I don't want to develop this thing. Well, I go to Sam and say, Sam says to me, Robin has no intention of developing this property. And I say, well, how about this, Donnie? How about I get them to cut us in if they do develop it? would that show you that they're not out to screw us? That if they develop it, that they'll consider cutting us in. And this is in those conversations. And so I go to Sam and I say, Robin, and I'm first Robin, would you consider, I know you want to sell it, would you consider cutting us into the deal if you develop it? And he says, I would. Let me talk to my attorney about it. He talks to Sam. Sam and I get on the phone eventually, and he's like, let me put something together. Then there's these series of text messages that are in 147. Or like, when are you going to have this deal from Sam and Robin? This is all prior to this email, just early February 2018. The text messages say, when are you going to have it? I'm like, they told me I'm going to have it on Thursday. Now I say Friday, and we get it on, I guess we get it on, is this a Monday? It doesn't say on the email, but whenever we get it, we get, this is the deal. And so when I get this, what do? Donnie and I have been talking about it the whole time. So I forward this to Donnie and I say, this is what they want to do. What do you think? Okay. And the first paragraph of this email says that, I'll stop if there's a question.
Yeah, you've answered my question. So you propose this deal to satisfy the concerns of Mr. Hyder that Robin Fowler and Sam McGuire were going to work together to develop the property. So you wanted you and Donnie to at least have something in writing from Mr. Fowler's representative, Mr. McGuire, that if they develop it, you guys would be able to get a piece of the action.
I knew that Robin Fowler and Sam McGuire had no intention of developing the property if at all possible. The only way they would develop it is if they could not sell it. So Robin's just bleeding money, and the only way is for him to partner with somebody so that he can stop hemorrhaging money. And that's made clear in this email. And so that was my understanding. But Donnie kept coming at me with this whole paranoia thing, threatening to sue me if I don't sue Robin. So I had to try and appease Donnie's paranoia. You
told me that you told him that you were not going to do that.
I was not going to sue Robin.
I'm sorry, you were not going to do what?
Sue Robin. You said that multiple times, that you told Donnie that you were not going to do that.
Correct.
Okay. Now, let me ask you about this last paragraph here. Can you explain what the last paragraph is about when Mr. McGuire says to you that he's received several emails that include Verbena and Donnie? Please refrain from sending any further correspondences to Robin as this type, and only send to me, because they impute distorted responsibilities on Robin and false illusions of action Robin is firmly rejecting will no longer respond to or will discuss. What is that about?
I am not privy to the exact emails that Mr. Hyder sent to Robin Fowler, but my interpretation of that paragraph is that Sam is asking for all correspondence to go through him and not through Robin, as there may be some misunderstanding as to Robin's responsibilities here.
Okay. Now, let's dial back a little bit. Put up exhibit number 72.
If it's not in evidence, don't put it up
Oh,
yet.
I'm sorry. Got it. I want you to look at exhibit number 72.
Yes.
Can you identify that document?
It's a text message
To you?
to me
From?
I know it's from Donnie Hyder, but I can't see that on the screen.
From Donnie Hyder?
Yeah.
It says from Sam.
No, so that from Sam is Donnie Hyder writing from Sam, then cutting and pasting a text from Sam to me. And it's actually part of my 147 if you want me to find it. I can find it pretty quickly. It's got a date on it.
So wait a minute, let me understand what you just testified to. You just testified that this document is not from Sam McGuire.
So this document is a photocopy of a text message or printout of a text message. And in the body of the the text message under June 28, 2017 at 10:57 a.m. In the little bubble, it says from Sam, then there's a paragraph break, and then there's a text message. So
you're not saying Sam McGuire didn't write this?
I don't know who wrote it because I can't see, but that's my understanding. If Sam McGuire wrote it, he wouldn't write from Sam in his text bubble. You don't text like, if I was going to text you, I wouldn't write from John and send it to you, right? So I don't know who this is from. I think it's from, it says John Dalton Investor on top. So I don't think the person that would call me that would be Mr. Hyder.
Okay, where in 147 is this text?
Let me look and see if I can find it. It might be there.
June 27th.
Oh, you know what? It's from me, isn't it, to Donnie?
June.
He's found it.
Give me too much credit, Judge.
139.
Thank you. I'm sorry. It's to me. It's to Donnie from me. That's what it is. That makes more sense now. I was confused.
All right. So this is a text message that Sam McGuire sent to you that you forwarded to Donnie Hyder.
So the body of that bubble is the my forward. So this is a text between me and Donnie. That's what this is.
Right.
And that body of that bubble is what I cut and paste from Sam's message.
Right. So you received this document from, you received the body of this document from Mr. McGuire.
I did.
Okay. So I'm going to move to admit this particular document, number 72.
Any objection?
No.
It's admitted.
Can you scroll up, please? Okay. So per your explanation, the body of this document was sent to you by Mr. Sam McGuire on June the 28th, 2017. Is that correct?
Correct.
And you then forwarded this document over to Mr. Hyder.
Correct. This is my text to Mr. Hyder.
Okay, and in this text from Mr. Sam McGuire, he's addressing this text message to you. He said, in order to protect Robin, who is his client, Robin Fowler, Dr. Robin Fowler, I had to move forward with the friendly he's got in quote foreclosure.
Correct.
Now, did you have any discussion with Mr. McGuire about this particular text?
So that day was the day that we were kind of working through this foreclosure and trying to get to this extension. So I was trying to contact Mr. McGuire all day. And I don't know if we talked once or twice that day, but eventually we did talk. And then we texted, I was texting him and calling him, leaving messages on his machine. So.
Okay, did you ever actually reach him?
I don't specifically remember if we communicated wholly by text or on a phone call, but it could have been a phone call too.
Okay, so you were trying to contact him to request that he not go forward with the foreclosure?
Correct.
Because he had already sent you a foreclosure notice, is that right?
Correct.
Sometime earlier in June, is that right?
Maybe that day or the day before.
Okay. And in response to your inquiries and attempts to communicate with him, he sent you at 10:57 a.m. this particular text message.
Correct.
Okay, and basically he's telling you that Dr. Fowler had decided to move forward with what he quotes as a friendly foreclosure.
Correct.
Now, did you ever talk to him about what he meant by friendly as an adjective to the word foreclosure?
Yes, we did.
What did he explain to you that meant?
That meant that he simply wasn't going to come after Brian and I's personal assets for any difference between whatever he could foreclose the property for and whatever Robin was in it. Because, Robin was in it, the $2 million plus the interest payments, plus whatever else he felt he was in it. So you get into this, you could probably come after us personally and our company. And he said he wouldn't do that.
Okay. And the next sentence there says the main purpose is to wash the title clean and transfer title to Robin, minus any and all possible liens that may be out there and not shown on record. What did you understand that to mean?
So there was all this concern about this Brandy Harris lawsuit. This is the one that preceded Donnie and I's involvement in this property that was against the property. And it was the one that was involved in Crystal Kimbrough losing her, ability to write title insurance for this one company. And so this was a big crux in it. And so my understanding was that stuff like that whatever Sam thought that was, plus whatever else might be out there that's yet undiscovered, because he didn't know about that until I think September. Or sometime after the closing.
Okay.
And when I said September, I meant September 2016.
Okay, that's when he found out about the judgment against Abe Wagner.
I don't know specifically when he found out that, but that's about the time that I'm aware that became part of the public record.
Okay, now, did you also realize that by him foreclosing, the promissory note that was also encumbering this property that was owed to Mr. Hyder at the time would be extinguished?
So a couple things. One is that promissory note, I didn't believe was actually a promissory note on the property. So I didn't provide Mr. Hyder any money with regards to that. So I didn't even consider that. And as to whether or not it gets extinguished, it's not even valid and was found and actually dismissed in this court. So I didn't even consider Mr. Hyder's promissory note, but I had a deal with Mr. Hyder and I'm good in my word. And that we continued kind of past this text into August, into September, and then again in November and December to try and get this deal off the ground, or at least I was cooperating with Mr. Hyder at the time.
Okay. Now, this next to the last line, well, the last two lines, he mentions that the buyer is still investigating, and once he appears again, I will bring you into the discussions. I have another buyer I am pitching in Miami too. Now, had you and Mr. McGuire talked about the foreclosure going off and some buyer would come in and buy the property and then there would be a split of the money back to D2?
No, that's in reference to discussions we had that are documented in emails, which begin back in February and March, maybe March to May, where I approached Sam McGuire and said, can you help get us in some contact with anyone that you have contacts with that may help us in getting this property moving? Mr. Hyder was aware of those emails because I copied him on them. And what Sam pointed out to us was like, I have this contact, this person does multifamily finance, let me get you in contact with her. And so along that time, he also was looking at people or coming across people who were offering to buy.
Okay, because those are the words he uses here in these two sentences. He says he has a buyer. The buyer is still investigating, not the lender, but a buyer.
Correct. And so during that process of him reaching out to his contacts to see if he could help us out, then he came across both lenders and buyers, much like Mr. Hyder did.
Okay. Can you turn over to exhibit number 96?
Mr. Kendall, we're gonna need to take a break in a little bit. All right, when is a good stopping point for you? Stopping meaning pausing, not wrapping up.
This is a good point.
Okay. Well, why don't we take a break, ladies and gentlemen? It's a few minutes before 11. I'm gonna try to get you back in here around 11:05. But if you would head with the sergeant over to 8E, we'll take our morning break. Don't talk about the case while you're over there, and we'll see you soon. Thank you for your attention. Okay, Ms. O'Neill, anything before we break?
No, sir.
Mr. Kendall?
No, sir.
All right, how much time do you think you have left in your examination of Dr. Dalton?
Probably will take us up to lunch.
What time do you think lunch is happening?
Oh, I'm assuming it's at 12.
Okay. And Ms. O'Neill, you still have one witness remaining as best you can forecast.
I have one.
Okay, all right, I'm just trying to manage the whole Fowler McGuire thing.
Short redirect.
You sure can, and there may be a recross. We'll see what happens. And of course, the jurors are going to have questions. They've asked for more note cards. So we'll finish Dr. Dalton when we do. I just wanted to forecast. Thank you, everyone. We'll be back. Be back here by 11:05, please. Ready to go.
Yeah. It's not a it's sure
All right, everybody's fine, everybody's good?
Yes.
What did you think about using, his position, whatever, asking about, wasn't guaranteed you would be, you thought it was a long shot.
You want to take this?
What did you think about, unfortunately, the fact he said in his deposition that he thought the deal was a long shot, that, he knew there was a guarantee.
Yeah.
I showed you that, I didn't know what your thoughts were.
Yeah, that's the first part of the definition. Okay.
Okay, here's one that says, he said, I can get this done, okay, but he never said I can push the guarantee. He didn't guarantee. That's about 2 points long shot, like he didn't think it was.
Yeah, I need some water.
I just.
Vending machine on the next one.
Yeah. What page is that? Yeah.
And let's try to, and I can move to tell you wants to make that.
I figured that's why you're right.
Because there are judges that are, don't say anything about it, you're changing everything.
I once in this one. And me as a judge.
We had a judge that you couldn't say anything other than form and then any argument about it. Every time they do this, we have to go up there, they come with white noise. We got it, everybody.
Yes.
You're like, don't forget form. And you're like, what form is it?
Yeah.
What am I hearing?
Okay.
It's not, what's going on?
Yeah.
So how do you think?
So,
Thank you.
I must have heard, so they keep.
She was writing a text message, but like, so mine was just one of the showing us friends.
You know,
It's
the
just,
phone numbers are
you
found on
know,
those.
no one is, I mean, I don't come, I'm supposed to say Fowler, but then I was supposed to try to get her.
Wow.
For some reason,
Right.
it's flowing with the time.
Yeah.
One receipt. My car's license number. That's right. I'm listening to but I got a list.
I'm sure. Oh, yeah, that is a sweet spot, yeah. So he's there. Okay. So, yeah. Yeah, okay. 80. Yeah.
Fine.
Yeah.
Did they come back?
They should remember.
The Tron, the track, and say, still be at the station.
I haven't even decided to make it there. I don't know, I'm like. Oh my God. Sure, I got right on that. You can buy them online?
No, you cannot.
Oh, the veil?
Yeah, they all. There's time. That's too much for you to answer. Yeah. Especially when she said, she said, we feel very about that. So.
Yeah. It's not even registered, but this one, this one.
Good.
So I want to go off what I was. Yeah, so it's really just like monthly guide.
Yeah.
This is available, I was like, oh.
Let's do the list.
So good. Yeah, they managed, I mean, they cashed that.
Have you ever read the?
Yeah. Yeah.
There's another. I got it. Me too. We think this is gonna be.
So we had our, so we had our reception, our first parties at our.
What did you really?
Yeah.
Oh, later.
Yeah. But it's time.
Yeah. Yeah, right. That's great.
So taps to all of us.
That's great.
In a food truck.
That's amazing. That's amazing.
Yeah. That was fun.
Other people's.
Yeah, the food truck, people that really kind of their food truck. It's amazing. It's nice. Casual.
Oh my God. She's a mom. He's a real. He was in. Yeah. But on the she was already in trouble. And so my wife. So, all right, so last year, now he's really, he's got two kids, and he knows.
Yes.
Keep in mind all Tell me what that is, because I'm clearing my calendar for that day.
I'm like crashing.
He's not starting the horse.
They also know, so that's far, North Carolina. So that's, so that they're. So that's Brian's good. So, I'm married. Yeah. That's right.
So that's the picture of you.
That picture. We went back to the house. You're like, she was. This is like a picture, we're like, oh, we're down the wall. Yeah, I never close the house. I just got one picture and know it's in it. Yeah. So almost like that picture.
You know what? I really gonna need to know about that. You're super cute. Yeah, yeah, I mean, it's really super cute. Thank you. I keep thinking, oh, that's cute. That's one thing. What is that?
I'll think about it, let you know.
Right? Just the best.
Yes, come in handy.
They're like, we're almost just flying our beer, like, we got shot for beer, and then like change the pressure of cans.
Yeah.
So I'm like, I just climbed.
You're like, you should have seen
Thousands of beers. It was like the
I got seen someone and someone tasted like over here.
Yes.
I don't know.
It's just, you know, I mean, she.
That was, this is pretty gross, I'll share that. At 11 of us were all like.
You know.
It was like 7, 10 a.m.
It's hard, but
Yeah.
Yeah, I'm like in her shoes.
I like the
That's-
shoes.
Yeah.
I like the shoes when you're watching the movies.
Let's see that all over.
Yeah.
That's just.
That one is our procedure to we do actually. People should swear and say.
Yeah.
No, I don't mean right. I don't know, that's that my high school. That I personally, I wrote on Daddy, that was it's on my money. But yes, when I moved to China. Shock you, it was me, not in the as a turned out, I could not.
Court, come to order, remain seated, remain seated.
Ms. O'Neill, anything before we bring the jury in? Mr. Kendall?
No, sir.
Dr. Dalton? Let's see if they're ready.
Yes, sir.
Please. And Mr. Kendall, Ms. Niles sent an email to Ms. Kimbrough's two lawyers, saying that Ms. Kimbrough is expected to be here by 8:45 on Monday.
Okay,
We'll let you and Ms. O'Neill know if and what we hear back from those two lawyers.
thank you, sir.
You're welcome.
I think I teed up number 96.
All right, Jerry. All right. Oh, here's a president account for.
Thank you, Sergeant. Ladies and gentlemen, welcome back. I have forgotten to ask, but I trust you would have let Sarge or someone know. Are we doing okay temperature-wise in here? I noticed at least one juror sometimes has a little bit of a covering suggesting it's cooler, but others seem like the temperature is okay because they're in short sleeves. Are we okay? Close enough? Okay, good. I don't have a whole lot of control over temperature, and unfortunately, it's not individually available like the sleep number bed where you can be this way and your sleep mate is a different temperature, but we can adjust it generally if need be. We will continue with Dr. Dalton's testimony. He remains on cross-examination with Mr. Kendall. When you're ready, sir.
Thank you, sir. Mr. Dalton, Dr. Dalton, I keep saying Mr.
Either's fine.
Okay. I've asked you to look at Defendant's Exhibit number 96.
I'm there.
You there? Okay. Do you recognize this document?
This is an email from me to Donnie Hyder dated 7/12/16.
Okay. And down below, under that is another email. Do you recognize that document?
I do.
And what is it?
This is an email from Sam McGuire to me, dated on the same date.
Okay. Yeah, I'm going to move to introduce number 96.
So I'll admit it, I just want to make sure I'm understanding. There's an email and then there are these pages that look like they're a separate document. They're unnumbered that follow it. So I want to make sure we're clear on what 96 is. There's a 2-page email that was just described. And then there are 2 pages that I'm not sure if you intended, Mr. Kendall, to include them. And if you did, I want to make sure Ms. O'Neill has no objection to these sort of disjointed pages.
I actually have an objection to the second. I'm sorry, Your Honor. It says it's 2 of 3. The first page, it says page 2 of 3, and there's no page 1. This actually came up at a deposition, and we objected to it, and Mr. Hyder's attorney at the time said that she had the full email and would replace it, and then we never did, so I do agree this objection.
Okay, we'll get to that in a minute. I want to hear from the straggler pages.
Yeah, I don't believe the straggler pages go with the document.
We can take out page 3.
But there is a,
The last page, I should say.
So I've got 4 pages. I'm sorry. I've got an email that's 2 pages. It's page 2 of 3, page 3 of 3. Then I've got this page that says the proceeds of the loan will be used. It's a different font. It's not part of the email. And then the 4th page is an agreement to purchase real estate.
Yeah, the last 2 pages can come out.
Take
I only want to talk to him about the emails that he's on.
Okay, so then to Ms. O'Neill's concern, your exhibit 96, which looks like was an exhibit from a deposition, starts with page 2 of 3. There's no page 1 of 3.
Yeah, and I don't know what page 1 was, never had it. The first page is this 2 of 3, and I'm not sure how the 2 of 3 got there, but these are definitely emails that he's recognized, he knows about, he's on the emails. And I want to ask him about those emails.
So I agree with Mr. Kendall. I appreciate Rule 106 as well, but if it's a series of email exchanges between Dr. Dalton and Mr. Hyder, then related emails would be available to both sides, I guess. So, yeah.
You have this objection to deposition. I'd like to restate it. I understand the question.
Got it. So your objection to completeness under Rule 106 is noted and overruled. And defendant's 96 is admitted.
And we can take out the last 2 pages.
Correct. Defendant's 96, to be clear, is a 2-page exhibit in the lower right-hand corner. This first page says page 2 of 3, and the second page, unsurprisingly, says page 3 of 3. It's an email chain.
All right, thank you.
You're welcome.
Those 2 pages, Roman, I think that this is the sort of problem. I don't know if he wants to approach, do this in front of the jury.
So Mr. Kendall has asked to admit just the 2 pages of email.
Right.
If you think that is incorrect, okay, what I'm going to do is let him admit just the 2 pages, and then if you need to on redirect, supplement it, you can do that if there's no objection from Mr. Kendall. He's seeking to admit just the 2 pages, and I think they have been authenticated and a foundation has been laid for them. And just like any other document, Mr. Kendall is free, or you're free to introduce part of it. Okay.
All right, thank you, Judge. Let's look at the top email there dated July 12, 2016. Just to put this in context, this was around the time that the Verbena Street properties were being closed, right?
Correct. They closed the next day.
Okay. And this document this email is from you to Donnie Hyder, and the purpose of it was to clarify where money was going to end up, that Robin Fowler was injecting into the transaction. Is that right?
Correct.
And in that first paragraph there, you say that Crystal's math, that's a reference to Ms. Kimbrough, who's the closing attorney, right?
Correct.
And that I'm looking at the 3rd sentence there. Well, actually, let's go to let's see, 1, 2, 3, the 4th sentence that it starts with. In fact, you're correct in her math by saying the settlement statement from Crystal shows $127,000 due from purchaser at closing. The purchaser at closing would be D2, right?
Yes.
And then you say it needs to show 0.
Can I correct that? It's not me saying that. If this is me, this is what Sam is saying. It's me telling Mr. Hyder what Sam is saying, not me saying this.
Exactly. I got you. So then you say in the 3rd sentence, in fact, it should show a balance due to Bristol, which will be used for carrying costs as we spoke about last night. Now, that last night reference is to the conversation that we talked about earlier that you and Mr. Hyder had one night where you guys changed the parameters of the deal. Is that right?
Correct.
Okay. So you're referencing to Mr. Hyder what Sam is saying. And then you said Crystal's math is wrong. It should be $2 million, which is the money that was being infused by Mr. Fowler, minus $230,000, which was the money that he had previously loaned to D2, and then minus the $1,200,000, which is the purchase price of the property to Mr. Wagner, minus the closing costs, equal remaining funds to Bristol for carrying costs and toward payment of monies owed to Bristol, right? That's what you're saying to Mr. Hyder.
No, there's not. This is what Sam is saying to me, and I have cut and pasted this statement to an email to Donnie, and I said, this is from Sam. And so everything after that, this is from Sam, those are Sam's words, not mine.
Okay, so you cut and paste a previous email from Sam McGuire to you. Is that right?
And it could be an email. Yeah, it was an email. It had to be an email.
Okay. And then he's asking you to please advise.
He's saying to me, please advise.
He's
Right.
Sam.
Sam.
Sam is saying that the please advise is from Sam to John Dalton.
Right. And then you just cut and paste everything after this is from Sam and send it to Donnie Hyder.
Correct.
Okay. Now, did you agree with the part of what Mr. McGuire was saying to you, which is that remaining funds to Bristol for carrying costs and toward payments of monies owed to Bristol?
So there's carrying costs are actually mentioned twice in this email, and I think that that pretty much sums up what I said earlier in my about the idea was that the balance was to go to Bristol, which was to be used for carrying costs, as we spoke about last night. That's 100% true. This math equation, this isn't my math equation, but that is pretty much sums it up. There was the timing of the payment towards Bristol and how that would be affected was also discussed, and that was going to be at the end of the deal. So that part's not in that email from Sam, but everything else is correct.
The payment would be at the end of the deal.
Yeah, so once Mr. Hyder got financing for the project, then Mr. Hyder would get paid per our deal that we made.
Okay, now how much money was Mr. Hyder supposed to be paid?
So Mr. Hyder said, well, I was going to sell the property at 3 million and get 1.8 million or whatever less closing costs as my delta on this deal. Basically, what I found out right prior to making this deal, when this whole end of June, when I found out their true property price, because he wouldn't share that with me. And I asked several times, and he said, that's my deal with Abe. That's not your deal. Your deal is with me. And this is what it is, $3 million. And so there's this phenomenon I'm aware of where you can have a contract and you can have an option. We talked about this, an option on that contract to sign it. Right. And so I figured, okay, well, he's doing that. And that's a known thing that people that, are in the real estate business do. And so I was like, okay, that seems like disingenuous. Right. And so that he didn't let me know what his deal with Abe was. But even at 3 million, I was like, there's lots of profit in this deal potentially. So that's fine. Like no matter what his delta was, and I didn't know what it was at the time when I entered into this deal. Under whatever his delta was, 3 million less whatever he made the deal with A was, I'm like, it's fine because even at 3 million, this deal is good. So when this deal fell apart, that's when I start finding out, or expired, and he approaches me about this new deal. Mr. Hyder does. That's when I find out the true purchase price. And at that point, Mr. Hyder's like, listen, I had this with you. We had a deal where it was going to be, my difference was going to be 3 million less this purchase price in closing costs. And I said, you know what? Fine. That's okay. We can keep that deal as long as it's on the back end. And on the back end, when everything settles out, because the property's still worth the same amount, it would be as if I purchased it for 3 million. And the numbers will work out exactly like I thought they were in the beginning. And I was fine. I'm like, all right, he made this great deal. If he gets this done, then on the back end, he can have that. But I'm not giving him anything on the front end. I'm not giving him $1 million because he says he's going to get it done. But if he gets it done, then sure. Heck, Brian and I would have had several $1 million of equity. And if he gets this done as a partner in this deal, I'm fine partnering with him at that. He gets $1 million. He already had 25% of it anyway. So that's going to be over $1 million. I was okay with that.
Okay.
Does that make sense? Sorry.
Don't ask him.
Sorry.
So the amount of money that he would get, if the deal had gone through on the back end, would have been what amount?
So that number would have been, the basic formula would have been, all right, let's take whatever this whole thing was, right? So there's $457,000, which is supposed to be used towards closing costs out of a $2 million
Toward carrying costs.
carrying costs, plus the closing costs of this loan. So I'm not sure what those were. I don't have that number off the top of my head. But let's take those, right? And so that number is what this would have been kind of, well, let's back up.
Can you do it backwards?
Yeah, let's do it backwards. Take 3 million.
Don't talk over each other. You go, Mr. Kendall.
Can we start with 3 million? Take it down from there.
Okay. 3 million. Okay. It's hard to do that because it really starts at 2 million. Let's start at 2 million. Can we start at 2 million?
No, you said the deal was that he would get the delta
Yeah.
between the 3 million that he had in the initial deal with you and your brother, minus what it was owed to Mr. Vackman, which was the 1.2,
Yes.
minus any closing costs, which are whatever they were.
Yes.
And so his deal would have been the 1.8, that is 3 million minus 1.2, minus the closing costs, whatever they were on the closing statement. And then he would be entitled to that delta.
So with the carry costs would have to be put into that formula, but otherwise that's really close. Yes, it would be let's do it 3 million less the 1.2, less the 230, less the closing costs, less the carry costs. That's the cost of getting to that end. And that delta was going to be less than 1.8, less than 1.5, probably more like 1.2, 1.3, somewhere in that range to Mr. Hyder once he got it all done.
Well, I got one caveat for you.
Okay.
If his deal was the 3 million minus what's owed for the acquisition of the property, which is 1.2,
Okay.
minus the closing costs,
Correct.
whatever they were, it would have been 1.8 minus the closing costs, not the carrying costs, because he would have sold that property to you and the carrying costs would have been your responsibility.
Yeah, if the first deal got financed on 6/30/2016, that's exactly what would have happened.
Exactly. So the delta would have been 3 minus 1.2 minus the closing costs. 3 minus 1.2 is 1.8 minus the closing costs, whatever they were. You would have had the deal. You and your brother would have owned 100% of that, whatever was being transferred.
Correct.
Okay, I know you felt that it was Plaza 2 and he didn't. Okay, but that would have been the delta. So if you guys had a conversation and the agreement was, okay, well, we'll recognize what you would have had, but it's only on the back end.
Correct.
Then it would have been the 1.8 minus the closing costs on the back end.
I see what you're saying. You're saying that the carry costs shouldn't have been included on the second deal?
Exactly.
Oh,
Because
they were. That's the whole thing, right? It's a second deal. It's a whole different deal that's made verbally, and it includes using that money for carry costs.
Okay.
And so when we finance the whole thing, then we do the math.
okay,
And so that number that he's quote unquote owed kind of shrinks over time because we have to carry the property.
okay, but under your definition of carry,
Remember, we also, I'm sorry.
well, under your definition of carry, that had nothing to do with the interest that was owed to Mr. Fowler, Dr. Fowler.
Oh, it absolutely did. So if you're going to take out that $2 million loan, and if you take it out on a 10% interest rate, so if you do take it out at a year, now it's a $2.2 million note that you have, or payment that you have to pay off. That's the loan payoff. And a couple of times Donnie would ask me to get the loan payoff information from Sam McGuire and Robin Fowler. Sam would provide it. Dr. Fowler wasn't intimately involved with it.
Okay, that brings me over to exhibit number 83. Can you take a look at that, please? Defendant's number 83.
I'm there.
Okay, now, can you identify this document?
Yes, this is it's from Sam McGuire, the office of Sam McGuire. It's to D2 Property Groups, and it's regarding the loan payoff.
Okay, and what's the date on this document?
August 2nd, 2017.
Okay. And is this a document you've seen before?
It is.
And it's to you, is that right?
Correct.
We move for admission of number 83.
Defendant's 83 is admitted. Is that a business address on there, Dr. Dalton, or a personal address?
It's personal.
Okay, let's not put up on the screen the top part, please. And you'll need to redact that. Yeah, just scroll up. I'm not saying you can't use it, but we'll need to, before this goes into the record, take out the home address.
Oh, you mean before it's submitted to the juror? Can
Correct. No, you can put it, just don't scroll up so that please,
Okay.
so that the home address is not on the screen. And then before it goes to the jury, we'll just need to redact the home address. Should have already happened, but here it is.
Okay. All right. This is one of those loan payoffs you were talking about. Is that right?
Correct.
And this is the very last loan payoff you received before the property was foreclosed the very next month in September of 2017. Is that right?
Correct.
Okay, now let's look at this document. Mr. Fowler says that through August the 31st of 2017, D2 Property Group would have owed Fowler Financial LLC $2,452,834.45. Is that right?
Correct.
So is that a correct recitation of what pursuant to your loan agreement with Fowler Financial you would have owed to him?
Correct, it is.
Okay, now it says principal amount $2 million and then interest 7/12/2016 through 12/31/2016 of $108,887.80. Is that right?
Yes.
And that's because no interest was paid because interest was due at the end of the takeout, right?
Correct.
And then from 1/17 through 8/31, there was a total of $134,998.65, which was up to the date of foreclosure, roughly.
Yes, sir.
And then he had a provision in his loan agreement for 10 points, which is $200,000. And he's charging you other expenses and attorney's fees. Total payoff, $2,452,834.45, right?
Yes.
Right. Now, I believe you said earlier, let me ask that question. Do you know if anyone purchased this property at the foreclosure sale, which happened in September of 2017?
I do not.
When I say anyone, I mean a third party other than the party that is owed the money.
I do not.
Okay.
Let me correct that. I know that it's still Robin Fowler's in November, but I don't know how foreclosure sales work. If that means if no one raises their hand, you just keep it, or how that works.
Now, do you understand or have you had any knowledge that after this property was foreclosed upon, Fowler Financial transferred this property to an entity that's called 2240 Verbena Street LLC?
I did not know when that happened or that it happened.
You don't know that happened?
Well, that's not true. I know because of this litigation that it happened because I've since looked at the kind of property records of that property. And so I saw on the property records, if you look at the line of who bought, who sold, how it kind of says transferee, transferor, you can see the parties going up. And at one point, it is under Fowler Financial, and at one point, it's under a new entity.
Now, when are you saying you found that out?
Through the course of this litigation.
Well,
I assume that it was theirs, though. So I know it was theirs in November for sure, because when I went to Sam and Robin and said, can we have it back under contract for a month? They were able to do that. But as far as what entity it was in, and if it was, what the name of that entity was, I was not aware of that.
can I get you to look over at exhibit number 103?
Okay.
Are you there?
I am.
Okay, this document is a document that on the last page bears your signature. Does it not?
It does.
And it also bears a signature of your brother, Brian Dalton. Is that right?
It does.
So you've seen this document before, correct?
Correct.
What is it?
It's a contract for sale and purchase. And this is the contract we entered into at the end of November. And now I see the name of the entity you were talking about. It's 28 November 2017, and it's the between 2240 Verbena Street and D2 Property Group.
We're going to move to introduce number 103.
Defendants 103 admitted.
Now, this document was executed around the same time that NDA agreement that we earlier looked at, that you said you had seen before between Fowler and Fowler and Hyder, right?
Yeah, that NDA didn't have any signatures on it.
Yeah, it has signatures on it.
Well, it's not in evidence. We may get in through a different witness.
Okay. So you were negotiating with Mr. Fowler and to repurchase that property, right?
Yes, at this time.
In November of 2017.
Yes,
And that would have been after the property was foreclosed upon in September of 2017.
correct.
And that would have been the time after Mr. Hyder's, and I know you didn't believe it had any validity, but after his interest, his second mortgage interest in the property had been extinguished,
Yes.
legally extinguished.
Well,
But let
yes.
me withdraw that question. All right, so at this time, when you entered into this agreement, when D2 entered into this agreement, you proposed to Mr. Fowler that you were willing to pay him $3 million for the purchase of this property, right? Correct?
Correct.
And you put up $10,000 as an earnest money deposit.
Correct.
And you were giving yourself until $25 days after this contract was signed to close this transaction.
Correct.
And my question to you is this: what made you think that you could close this property for $3 million in 25 days of the date you entered into this particular contract?
Donnie Hyder said, I have this offer. It is solid, and we'll be able to close this deal in 30 days.
So the answer is Donnie Hyder.
Donnie Hyder presented this letter of engagement from another group that was interested, and it would, our contact person's name was, I think, Dion Sante Robinson for this group. And that is a series of emails and conversations that happened over the period of the next 25 days.
Now,
But that was from Donnie Hyder.
Now, we're talking about the same Donnie Hyder that had not been able to get the financing to close this property from July of 2016 up until this particular point in time.
Yes, same Donnie Hyder.
Same Donnie Hyder. The same Donnie Hyder that you were so disappointed with, who didn't come through, as you say, on his promises previously over the last year and 5 months, 17 months. But now all of a sudden he has a solid deal.
I didn't believe it was solid.
Well, you must have believed that you entered into this contract and you put up $10,000.
I made sure that was 100% refundable, and it was refunded when Donnie Hyder did not come through on his promise. And as I said earlier, this is the deal around which I think Donnie Hyder had ulterior motives to try and clear the name of his friend and attorney, Crystal Kimbrough, in some way regarding this lien or whatever that affected her ability to write title insurance.
Now, how was you executing a contract with Robin Fowler to buy this property going to clear Crystal Kimbrough?
So if you look forward in the emails from this point forward, especially between Donnie Hyder, Dion, and Sam.
Now, who is Dion?
Dion Sante Robinson, I think is his name, and he was the person who presented to Donnie, or that Donnie reached out to, however that relationship developed. This is not the first time he's been in this 1.5 year long saga, but he is the one who presented the letter of engagement, to which I presented that to Sam and Robin in order to get this contract we're talking about right now.
Now, who is this Dion person with? What company is he with?
It's American something or finance. I don't know.
Do any due diligence on this person?
I didn't believe for 1 second this is really going to happen.
Do any due diligence on this person?
I did not.
Where in this agreement does it say your $10,000 is refundable?
I don't know. I didn't page through it, but I know that it was, and I know that I got it back, and we showed those wire transfers yesterday to and from the law offices of Sam McGuire.
So is that $10,000 included in your calculation of damages?
That particular $10,000 is not. However, it was later, $10,000 was later transferred to pay for Dion and then more for Crystal Kimbrough in relation to this quote unquote deal.
So even though you didn't believe that this deal had a chance to materialize, you put up $10,000 in the earnest money contract, you paid Dion $10,000?
Yes. I paid Donnie Hyder $10,000 to pay to Dion.
Okay. And you also paid some more money to Crystal Kimbrough?
Yeah, we talked about that yesterday. It was a transfer that was in the very beginning of January 2018. After Mr. Hyder told me that she had to go to counseling and all that stuff, that she was struggling with this problem with losing her ability to write that title insurance, and that caused her great stress in her life.
Okay. So you knew that this deal, or you thought that it was just almost impossible that this was going to come about, but you paid Crystal Kimbrough for the work she did in relationship to this deal, right?
It seems facts, and this takes the witness's testimony yesterday about whether he thought she'd done the work.
Try the question again.
Yes. You paid Crystal Kimbrough money for work that she performed to put this transaction together. Is that correct?
You when you say this transaction, which transaction?
Transaction involving this contract that we're talking about here in 103.
Same judge. That's one yesterday.
You don't get to tell the world what the testimony was. So I want to make sure you understand your question. You are asking Dr. Dalton if he paid Crystal Kimbrough for work she did on defendants 103, this contract?
Yes.
Okay, you can answer that.
I paid Donnie Hyder money that he told me that Crystal Kimbrough was owed. This is part of the whole, you shouldn't reach out and talk to her, you shouldn't call her. This is the discussion about, well, $25,000, that would be this many hours, 40 hours or whatever that text thread said.
Did Mr. Hyder ever explain to you what kind of work Ms. Kimbrough would have done on 103? Or this is related to work for the closing that happened months earlier?
This is related to work specifically to this deal.
Okay.
Because Ms. Kimbrough was already paid on the work she did on the Verbena Street closing deal out of the closing proceeds, right?
I honestly don't know what Ms. Kimbrough was paid. I do know what I paid Mr. Hyder for what I was told was for Ms. Kimbrough. The transfers never went to Ms. Kimbrough's account.
Okay. The transfers never went to, oh yeah, you never directly sent the money to Ms. Kimbrough's account.
Correct.
Okay.
I was under the impression Donnie Hyder had done that.
Right. Okay. So that amount that you paid Ms. Kimbrough per your testimony yesterday was $15,000. Is that correct?
I think that was it, yes.
Uh-huh. She had originally asked for 25,000. Is that right?
Donnie Hyder had originally asked for 25,000 for her.
Okay. So you ultimately paid you paid Donnie Hyder for Ms. Kimbrough 15,000.
Correct.
Okay. And that was for this transaction that's represented by 103.
That's correct.
Okay. And then your testimony is also that you paid another $10,000 out to this Dion person who came up with this potential financing arrangement.
I paid that money to Mr. Hyder after he showed me a screen grab text of his bank account being debited for $10,000, and he told me that was for Dion.
Okay. So it's safe to say that even if you got your 10,000 earnest money back, you still spent $25,000 on this transaction.
Yeah, yes, plus the $100,000 that I had just also around that same time made the last payment on.
But that $100,000 had nothing to do with this contract.
It did not.
That $100,000 was paid before this contract was ever entered into.
That was not correct. The first payment was made in the beginning of November. The second payment was made in beginning of December. The third payment was made at the end of December.
Okay, so during the period of time that those payments were being made, you entered into this contract with D2 and the 2240 Verbena Street LLC entity to purchase the property for $3 million.
There's a text message that documents this that we went over yesterday that shows that Donnie's saying it would be a good idea for you to stay for our other deal to stand, even though we were doing this current deal. And the other deal he's referring to is $100,000.
All right. Okay, I want you to look at document number 43.
All right, I'm there.
43. Are you familiar with this document?
I am.
Are you the signatory on this document as the maker
I am.
on behalf of your company, D2 Property Group LLC?
I am.
I move to admit 43.
Defendant's 43 is admitted.
Okay, Mr. Dalton, we talked about this document. I just want to put it in the record. This is the promissory note for $1 million that you say you never thought was valid. And you didn't worry about it because there was never any way you could think it was valid.
This court said it was not valid.
Okay, so this document was executed on July the 12th, 2016. Is that right?
Yes.
Why did you think the document was invalid?
Because I never.
I'm sorry, no one said
I'm
anything?
going to object to that, but I'm not going to go ahead.
Okay.
because Mr. Hyder never gave $1 million towards the deal. So why would I owe him $1 million with a promissory note if I did not receive $1 million or some portion of that?
Okay. Look at exhibit number 44.
Yes.
Can you identify that document?
Yeah, it's a guarantee between Bristol and D2 Property Group.
Okay, and that document bears your signature as well. Is that right?
It does.
Move to admit 44.
Defendant's 44 is admitted.
What is 44, Mr. Dalton, Dr. Dalton?
It's a guarantee.
And is executed by whom?
By my brother and I under for D2 Property Group.
Okay. And this is a guarantee of the previous promissory note that we looked at in the defendant's exhibit 43. Is that correct?
That's how I understand it.
Okay. And I guess you feel this document is equally as unenforceable or invalid.
That's not only my determination, but this court's.
Okay. Did you feel that way when you signed the document?
Yes.
So why did you sign the document?
I was told to do so by my attorney, Crystal Kimbrough.
So you just did it because she told you to?
Yes.
Okay. Do you feel as though you were justified in relying on her advice?
Yes, I do.
Okay. And why is that?
She's my attorney.
Okay. So based on her being your attorney, you felt obligated to sign this document?
Yes.
Okay. All right. Let's see, Judge, I'm gonna wrap up here in just a second. I want to ask you about the document that came into evidence yesterday. It was your plaintiff's exhibit 279, which is the document entitled Private and Confidential Compromise and Non-Disclosure Agreement. I don't have that.
It's not in a binder. It's that free floating.
Yes. Can't put it up. Did you guys put that in your exhibits?
You know what, I'm not sure I sent you an electronic copy. I may forgot.
Dr. Dalton has a copy in front of him, so we can at least proceed with questioning. I don't know if it can go up on a screen at this point, technically.
Okay, doctor, let me ask you about, you saw this document, right?
I did see this document.
Okay, and you and Donnie Hyder, you as D2, when I say you, I mean D2 Property Group LLC, sued, okay, we got it up. Oh, what's that? What's up?
Yeah, we
got it. Okay.
I apologize.
Okay.
I think I forgot to email you the electronic copy. I marked it in court yesterday.
Okay.
So Zach's got it up.
Thank you. Thank you.
Just tell him which part you want pulled up.
Yeah, because you guys got the fancy dancy stuff over there.
Everyone's got great stuff.
Okay. Dr. Dalton, I want to ask you about this document. You, D2, and Donnie Hyder sued Atlanta Beverly, Atlanta Plaza, Denise Vaknin, and Abraham Vaknin in the Superior Court of Fulton County regarding certain misrepresentations that they had made with regards to payment of taxes. Is that right?
It is.
We heard Mr. Vaknin testify that it didn't have anything to do with taxes, but that's incorrect, isn't it?
I still don't know what's correct because I don't have a final HUD with like both sides on it. So I don't know if he actually is obligated to pay taxes. I was under the impression that he owed us like $78,000 in taxes. And we entered that lawsuit in September of 2016 when Mr. Hyder and I were working closely together. And I entered that under the advisement of Mr. Hyder with the attorney he picked.
Did you in any way do any due diligence about whether or not that was accurate?
I relied on what Mr. Hyder told me, that was the back taxes that was owed. Yes.
Okay. And you voluntarily entered into this lawsuit. It's not that Mr. Hyder put your name on a lawsuit that you didn't know about. Is that right?
That's right. I voluntarily entered into this lawsuit.
Okay. And you voluntarily resolved that lawsuit?
Yes, this lawsuit was resolved.
But as the D2?
As the D2.
And that was in 2018. June of 2018. Well, if you look
Yes.
at the, there's two documents here. One has a date in it, one doesn't have a date. If you go down to page number 279007. Yeah, that's the page. So the document that's dated June 6, 2018 is a document that the Vagnans signed, and it has a date on it.
Yeah, looks like I signed it on the 5th, they signed it on the 6th.
Right. You had the Vagnans to pay you $22,500 in 2 installments. Is that right?
Correct.
And they agreed to that.
They did.
And I think your testimony yesterday was that was calculated based on the amount of money you had spent to your attorneys.
Yes, on specifically this portion of the case, yes.
Right. And when you gave your total all-in attorney fee number yesterday, was this amount backed out?
It was.
It was?
Yes.
How do you know that?
Because my attorneys bill and have invoices that are very specific to this litigation. It goes with a case number.
Okay. Paragraphs 2 and 3 of this document. How did that come about? Where you agreed to testify on their behalf and they agreed to testify on your behalf?
We realized when we've met at that day, which was in a courtroom, that we both had very different stories about what transpired with the purchase of the Verbena properties, and that our stories both pointed towards some of the fraud committed by Mr. Hyder and concealing of details. And so we wanted to make sure that if this ever came to trial like it is now, that they would be available to testify at that proceeding, and that if they had a trial with Mr. Hyder, that we would make ourselves available to testify at that proceeding.
Okay, and then you said you guys compared notes and found out that there were similar stories of fraud on the part of Mr. Hyder. Can you tell me what the fraud was by Mr. Hyder to Mr. Vacning?
What Mr. Vacning testified on about the different purchase price, about the fact that he wasn't even aware that we were part of this transaction in any way until the closing, when he saw our name on it.
Well, I thought you just told us that this is a regular occurrence in real estate, that people flip properties to third parties and they don't know what one party is buying the property from when they receive the property from that same party. Didn't you tell us that?
I did, but I would think that typically in those things, as I would understand it, all parties would be aware of all parties. There would be no secret or hidden parties. And what Mr. Vacning said was that D2 Property Group is as I described, secret or hidden party. He was unaware of D2 Property Group when he was discussing things and making a deal with Mr. Hyder. And that he was not made aware of that until the July.
So I'm confused about what your understanding of how real estate transactions typically advance. So you said you knew that there was a person involved in the Verbena Street property sale by the name of Abe Backman.
Yeah, that's what I knew, yes.
And so that wasn't any fraud on Mr. Hyder's part as to you in terms of keeping his name a secret.
No, he did not keep his name a secret.
And you specifically asked him what was the price that he was purchasing the property from Mr. Wagner at, and he told you that was his business.
Correct.
Was that fraudulent for him to keep secret the amount of money that he was paying to Mr. Wagner for the property?
Objected, Post-foreclosure conclusion.
No, I'm asking him in his mind, what is his?
You need to sustained.
I don't know how to proceed, Judge, if I can't ask him whether or not he thought that was, he's filed a fraud claim in here. I'm trying to determine what part of these transactions are fraudulent.
Then you'll need to try to figure out how to do that. I can think of 5 different ways to ask it that don't require this witness to provide a legal conclusion about whether fraud occurred. So try again.
He used the term fraud in his response to my question. He said that they compared notes and they determined that Mr. Hyder had committed several acts of fraud. I'm asking him about what his understanding of fraud is per his testimony. That's his testimony. And I think I'm permitted to ask him what is his understanding of fraud and whether or not keeping that man's amount of that contract secret was fraud in his mind.
Okay, so ask the question.
Is that an act of fraud on behalf, in your mind? In your layman's mind, not in some lawyer's mind or some legal definition. But in your mind, you use the term that you compared notes with Mr. Wagner, and you guys determined that Mr. Hyder had committed fraud in a couple of different ways. And I asked you whether or not keeping his name secret, keeping his amount of the sale of the contract secret was fraud in your mind. Is it?
No.
Okay, that's all I'm asking. So he told you what the man's name was. He didn't tell you what the amount of the contract amount was. And you said you had no problem with that. That's his business. And he said that was his business. Is that correct?
Yeah, I accepted it as his business. I accepted that.
All right. So what was the fraud that you identified to Mr. Wagner on your side of the ledger of identifying fraud?
I didn't identify any fraud to Mr. Wagner. I just noted that Mr. Wagner did not know who Brian and John Dalton were in this transaction at all until July 2016, after the expiration of that contract.
So do you feel Donnie Hyder had an obligation to tell Mr. Wagner who he planned to sell the property to after he concluded his transaction with Mr. Wagner?
Objective basis of relevance. What Mr. Hyder's obligations were to Mr. Wagner are between Mr. Hyder and Mr. Wagner. It's not that this lawsuit was made up.
Now, I'm asking him if he feels Mr. Hyder had an obligation to tell Mr. Wagner who D2 Properties was.
But I understand your question. What's the relevance of that? Dr. Dalton just told you he doesn't believe that whatever went on between your client and Wagner was fraud. I just heard him say that. You heard him just say that. I thought we were moving on, and now we're back to it.
I didn't know he said all that.
Well, maybe you should listen to his response.
Well, maybe he should repeat it. So
no, you can ask a question and we can keep going.
Is that what you said, Mr. Dalton, that you don't think anything that Mr. Hyder did with Mr. Vagnon was fraud?
That's not what I said.
I didn't think it was.
Okay, then I misunderstood.
Okay. So I'm specifically asking you, because I didn't hear you say that. Do you think that Mr. Hyder's not disclosing to Mr. Vagnon who D2 property was in this transaction is fraud?
I think that and forging his signature on that contract is fraud.
Okay. Do you know for a fact that in this transaction initially, as it was set up, that it was designed to be a transaction where Mr. Hyder was purchasing the company, Atlanta Beverage?
That's not what I heard Mr. Vagnon say.
Okay, but I understand that. I understand that Mr. Vagnon might have said something else, but do you understand that the documentation that Ms. Kimbrough was initially putting together was a transaction for Mr. Hyder to purchase the company, not the land, not the buildings, but the company, Atlanta Beverage?
I do understand what Ms. Kimbrough put together, that she put together a purchase agreement for that company, even though we said we weren't going to do that. And I also know what Mr. Vagnon said, which is he had no intent in selling the company. And so those are the things I know.
Right. But do you also know that Ms. Kimbrough put this transaction together to show it initially that way?
I don't know how she put it together initially, but I know at the closing, she was presenting forms such that we would take over Atlanta Beverly, the shares of Atlanta Beverly.
Exactly. And do you also know that Mr. Sam McGuire wrote her letters and emails and said, no, that's not the way we want to do it. We want a clean transaction to purchase the land?
Not only I do know that, and I know that I also sent texts to Mr. Hyder saying that I don't want to do that either.
Right. And so initially, when these documents were signed, they were signed with the idea that Mr. Hyder, was purchasing a company and not a building and land.
So I looked at that document and that came up as evidence in Mr. Vagnon's testimony, and it was that handwritten thing. I don't recall anywhere on there being for all the shares of Atlanta Beverly, anywhere on that document. So that's the agreement that I understand that they left with.
Okay. All right. Did you ever, after this foreclosure, did you ever get any money or any other benefit from Robin Fowler or any of his entities, 2240 Verbena Street, Fowler Financial? Have you done any more business with either one of them?
So can you unpackage that? It was a bunch of things.
Let me break that down. Have you done any more business with Fowler Financial since Fowler Financial foreclosed on this property in September of 2017?
No.
Have you done any business with other than signing this contract that we just looked at? Have you done any business with 2240 Verbena Street LLC?
No.
Have you or your brother or D2 Properties received anything of value from Fowler Financial or any entity that Dr. Robin Fowler is connected to?
No.
That's all the questions I have.
Thank you, Mr. Kendall. Ms. O'Neill? I'll believe it when I see it.
John, let's start with what was marked as Defendant's Exhibit 96. If you can look for that for me, please.
The defendant 96?
Yes, that we just went through. That's the one where we had a discussion about the extra pages.
Yes.
Wrote for the wrong hearings. And if you look at the email from you to Sam McGuire, Thursday, July 7th at 2016 on the first page,
Yes,
and the first sentence of that says, here is a paragraph describing the general uses of the money.
yes,
So we took some pages out of this exhibit. Is the first page that was taken out the one that says the proceeds of the loan will be used to acquire? You go to page 3 of this exhibit. Oh, actually, you can't, Dak, because it's not admitted. It is the first page. Well, let me ask it this way so the record's clear. The defendants took out 2 pages of this exhibit because they thought they didn't go with it, right? You recall that?
correct,
All right. And the very, very last page says agreement to purchase real estate at the top.
correct,
Right. And then the second to last page is a document that starts with the proceeds of the loan will be used, and then it says 1 to acquire, et cetera. You see that?
correct.
Is that the paragraph describing the general uses of the money in our worst case scenario that you're referencing in your email to Sam McGuire of July 7th at 10:15 p.m.?
Are you referring to the one on the third page of this exhibit that starts the proceeds of the loan?
Yes.
Yes,
All right. So that was attached to that email.
it wasn't, yes, it was.
So it does get included.
It should be. It's a part of that email.
And was this agreement to purchase part of the email as well?
It was.
All right. And was it attached to the email to Mr. McGuire?
It was an attachment to Mr. McGuire.
Okay, Your Honor, we would move to amend defendants, I think this is the proper way to do it, amend defendants 96 to put back in those 2 pages that were originally taken out.
Mr. Kendall, any objection to re-including what you and I both thought were extraneous pages to defendants 96?
No objection.
All right, and then I would like to display the paragraph that you were talking about. The one
So the
that's-
record is hopefully clearer. Defendants 96, which was admitted in the form of 2 pages, which was an email from Dr. Dalton to Mr. Hyder with emails attached to it, remains in evidence. There were 2 additional pages, the provenance of which weren't so clear to me or to Mr. Kendall. And Mr. Kendall agreed that it should just be the email part that is admitted. But Ms. O'Neill has made clear that the 2 wayward pages were actually attachments to the email and are pertinent to the email. And Mr. Kendall agrees that they can be added back to defendants 96, which is now, despite what it says on the bottom of some pages, a 4-page exhibit.
And what did you tell Mr. McGuire about the general uses of the money back there when you sent this email to him before anything at all closed and any money changed hands on July 7th, 2016?
Number 1, that would be used to acquire the property. Number 2, to cover closing costs. Number 3, to pay back Robin Fowler $230,000. Number 4, complete necessary due diligence to secure conventional financing for the rehabilitation.
Thank you. All right. So, and then I want to go back to where, you can take that down, where Mr. Kendall ended. You didn't want to purchase any company related to Verbena Street, right? You didn't want to purchase Atlanta Beverly. You didn't want to purchase Atlanta Plaza, true?
That is true.
And you heard Mr. Vaknin say he didn't want to sell any of his companies. Do you recall that testimony?
I do recall that.
And you said in your testimony, I believe, that Sam McGuire said his client didn't want to lend any money for somebody to buy a company. Did I remember that right?
I do.
So who's the person who wanted to buy a company?
Donnie Hyder.
Anybody else at all?
No.
All right, if you could put up for the screen for me the document we've previously admitted as Exhibit 30. And it'll be hopefully up in 1 minute. In response to some questions from Mr. Kendall, you talked about the document that Mr. Vaknin and Mr. Hyder had signed, and you said you didn't remember it talking about buying any company.
That's what I said, yes.
Is this the document you were referring to, Exhibit 30?
It is.
Thank you. I don't need that on the screen anymore. You were asked by Mr. Kendall whether the taped conversations that were made between November of 2017 and February of 2018 included any references to the $457,000 that was given to Mr. Hyder / Bristol and that you believe should have been used for carrying costs, and you said no. Is there a reason none of those were included in those taped conversations? What were you talking about at that point?
At that point, we were talking about suing Robin Fowler, initially trying to get this one deal done. The one deal doesn't get done. We're talking about trying to, you should sue Robin Fowler, and it's no, and I'm going to sue you if you don't. And that was the gist of those conversations. So it was just threat and me saying, no, let's work this out.
Had you just agreed that he could have just kept that $457,000 and that's why there was no discussions about it during that November 2017 to February 2018 time period?
If I didn't agree that I didn't want to, I just wanted out. I wasn't planning on trying to get that or anything. I just wanted to get done.
And is that the same reason that there was no discussion of who owned the plaza or the retail versus the apartments during those tapes?
Yeah, all that wasn't done. It was not worth discussing. I just wanted out.
If Mr. Hyder had not sued you, would we be here today?
We would not.
Those are all my questions. Oh, I have one document, sir. See, you know better than to trust me. Can you go look at the plaintiff's volume 1?
What exhibit number? So the rest of us,
It's going to be 12.
12.
It's just that she referenced this. So I was gonna-
I'm there.
This is a document you've seen before, correct?
It is.
All right, can you identify what it is?
This is, I can't pronounce that, writ of some fieri fascia, that's in the state of Court of Fulton County, and it's Brandy Harris versus Atlanta Beverly.
In your questions, in your answers to Mr. Kendall's questions, you referenced a judgment that had been entered regarding the Verbena Street properties, or entered against Atlanta Beverly, Atlanta Plaza, and the Vacnans. Is this that judgment that you are referencing that was at the center of the debate about clearing up the title and Mr. McGuire and Ms. Kimbrough having a professional dispute?
Yeah, this is the document.
We would move plaintiff's forward.
Mr. Kendall,
I have no objection.
12 is admitted.
That's it. No more questions.
Mr. Kendall, anything else?
Just one question, or maybe a follow-up. Dr. Dalton, you just mentioned that, again, that these conversations that you take 12 hours worth between November of 2017 and February of 2018, that Mr. Hyder was making threats. Is that right?
Yes.
Did Mr. Hyder ever physically threaten you?
No, well, by physically, you mean like for physical harm or something?
Yes.
Oh, no. He was always nice that way. He was polite.
Did he ever threaten your brother?
With a lawsuit or physically threatened?
Physically
Okay, yeah,
threatened.
physically, no.
Did he ever threaten anybody in your family? Physically?
No, not physically.
So when you use the word threat, you're talking about, when you say he threatened me, you're talking about he threatened to file a lawsuit.
Yeah, I look at it as do this or I do that. To me, that's threat.
Okay, and you're no stranger to filing lawsuits yourself, right?
Before this, I'd never filed a lawsuit.
But you filed a lawsuit against a Vagnan,
Yes,
filed a lawsuit against Crystal Kimbrough,
yes.
and I believe there's somebody else you filed a lawsuit against revolving around this situation, and I can't think of who that was. Who was that?
There was a counterclaim against your client once he sued us.
Yeah, and then there was a lawyer. Well, that's all right. No
No
further,
other lawyers.
no further questions.
All right. So ladies and gentlemen, it's time for your questions. We're going to break for lunch in a little bit, but I would like to complete Dr. Dalton's testimony, so we've got a natural break point. You'll still get the full lunch break. I noticed some of you writing things down as early yesterday. So if you would do me the favor, please, of reviewing your questions to make sure you're not submitting a question for which you now feel you have the answer. That would be real helpful. That would streamline things. But take the time you need. If you have any, and you need not have any at all, but if you have questions for Dr. Dalton, jot those down and send them to your right to Sarge, and he'll get them to me, and we'll go from there. Thank you. Thank you, everyone. All right, Mr. Kendall, so Neil.
25%.
Questions that
There's one that's a little conclusion about the
number 25, one about something being all in.
no, I'm doing this. The rest of them.
Do you have perspective on 25? I'm going to call it. Um, so, position. One second, 7%. Ordinance of the bottom.
I don't either.
understand that.
Well, I guess I just say I don't see the relevance. I don't intend to ask it unless someone can tell me how that's relevant to this case.
I don't see that.
Well, this is not true. Sure, I suppose for whatever reason, that's your person. Actually, well, we can do the process. You do it fair. It's going to tell jurors the next question. Then they should be the next question. And regardless of whether or not weakness, so if the juror were to say, have you ever, are you a tourist? How is that a relevant question? Well, I'm saying. No. Please answer my question first. How is that relevant? Should I let them ask that? Because in their mind it's relevant. Should I let you ask that question? No, then you can't ask. I can't ask because I'm bound by legal rules. Well, so are they, and that's how it works. I hear you. You can get that on the record outside the court. That's not how process works. It's hearsay. It's hearsay. Socially conscious person instead of and you got that on the record. And you can do it again. You keep pressing. This number 21 is updated financial documents. Should they have been updated that way? So to me, it's a human answer, which should suggest legal. I know you don't have a problem with it.
The contract.
That their individuals are relevant to whether or not the country's deals. That's exactly the question. So you think? Thank you.
Dr. Dalton.
I'm going to try to do these in a certain order, but we may bounce around a little bit. Concerning the business D2 did with Mr. Hyder and the residential properties, the 7. You mentioned that Mr. Hyder helped with tenant problems, the roles that Mr. Hyder had in connection with that. What would an example be of a tenant problem? Like a pipe bursting, we had a kitchen fire at one of the properties, and he helped with that. Maybe an eviction. So someone's, back in their rents, he would go to collect. If they didn't collect, he would go through the proper channels for eviction. Those would be the type of tenant issues that would arise in kind of the normal business of those properties. If Mr. Hyder did not have authority to act on behalf of D2, why was it or how was it that Mr. Hyder was responsible for managing and maintaining and collecting rent those 7 properties? So if he had to do anything that required like legal procedure and stuff, that would have to come through me. I'd have to give permission to do that. And that was our thing. Is it okay if I do this? Should I get started on this? That sort of thing. There was one time when there was a water meter issue and that required the owner of the property to go down. That was in the Mildred property. And so he sent me the photocopies of the citation stuff and what I needed. And then I went down to the county down here and went to the appropriate office and I filled out the paperwork and signed what I had to sign and paid what I had to pay to get the water meters updated. So in that way, if something had to be like my signature, it was me doing it. Otherwise, if it could be done through the property management side, then we'd handle it through the property management side. There were some exhibits entered about a memo of management transfer, some letters that went out to
tenants in the D2 properties, were those being sent to the current tenants of record at those properties, if you know what I'm referring to?
I think you're referring to the letters that Donnie Hyder sent to the tenants saying that if they had further questions to contact Cityside Properties,
Correct.
Which is our current management group. Those went out to the tenants that were currently at those properties.
You testified that you met one of the tenants. You stated his name. I don't recall it offhand. Is there a reason why that's the only tenant you've met of the various tenants you've had?
Yes, it was because there was an issue at his house. We were in between the property management issue because Mr. Hyder had litigation against me now, and we had not yet secured our other property management group to take over. And so I needed to kind of go assess what was going on, assess what stage we were at. And so I went and actually went a couple times because I had to make sure he was there. I didn't just let myself in. And he was there, and we went through the place, and he showed me all the areas, and some of that had been fixed because Mr. Hyder had done some work on that property. And then some things that needed to be fixed. And so when we got our new property management, that was one of the first things we did, was fix those issues.
Can you share with the jurors the financial arrangements that D2 had with Mr. Hyder or American Business Group concerning the services that Mr. Hyder and his company provided, collecting rent, doing the repairs, or at least lining up the repairs? Was there a fixed fee that D2 paid to American Business Group, or how did that play out?
Typically, the fixed fee was the management fee, and that was 10% of rents. And then for any repairs or something like that, like let's say there's a property that needed a new door or something, so I would get on the property management statement, new door, and that would be just the cost of the door and whatever it was for install. And it would be line itemed, change locks, change mailbox, stuff like that. It would be line itemed on those statements. And then I would have a spreadsheet that I would give to my accountant at the end of the year, just an Excel spreadsheet. And I would have those items line itemed, because sometimes there was some capital improvements. If you could buy like an appliance, or if you do some roof work or something like that's different. So I think, and so I wanted the accountant to have that kind of line item thing, and Mr. Hyder provided that for us.
What about in terms of finding and ultimately acquiring the properties? Did D2 pay Mr. Hyder or one of his companies any finder's fee, because now you've added house number 5 to your portfolio?
There's no finder's fee or any arrangement to go, quote unquote, look for properties. Like, I'm going to give you X amount of dollars if you can keep an eye out, kind of like a retainer type of idea, or like every property you close, I'm going to give you X amount of dollars, percentage of that value. There's nothing like that. It was just Mr. Hyder identified the properties. This is how much it will cost for you to own the house, is what he would tell me, basically. And we would look at it, and I would decide if that was something we wanted to do.
Was there any contract, or was there a collection of contracts that memorialized the terms of engagement between D2 and Mr. Hyder and his companies concerning the management of these non-Verbena properties?
There was not. There was no contract. We didn't have anything written. It was just all verbal agreement and handshakes.
Moving to Verbena, why did you tell Mr. Hyder, okay, the shops are yours?
So he said that I want to keep the shops, and so I had no interest in running those shops or owning those shops, because I knew that it's labor intensive. I don't have an interest in that. I had interest in being an owner in this apartment complex and the land thereof, and having that passive income stream. And so typically that's kind of the whole setup of our business, was to establish a passive income stream. That's why we hired a property management company to do all of that. And so you pay that property management company. So if I do that myself, I would have a more income, but it would come at the cost of my time, which I didn't have extra time to give. So we hired someone to do that.
a little bit about the Vaknin connection to Verbena. Did you ever ask Mr. Hyder why an embassy needed to be involved with anything to do with Mr. Vaknin?
So it was my understanding that he was out of town and out of the country.
Being Mr. Vaknin?
Yes, sorry, Mr. Vaknin was out of the country, and I'm just relying 100% on what I'm being told by Mr. Hyder at this point, and that I find that he's in Israel, and that he needs to be able to sign these documents. And I do know from my closing they have to be notarized. So I don't know how you find a notary in Israel if you have to go to a closing, but I would assume that an embassy might be a place to do that. So it didn't seem unreasonable if someone was trying to close a business deal to do it there. I didn't really kind of question that at all, actually. I just said, okay, he's out of the country, it's not closing. Whether it was an embassy or the American Express travel agent's office, it didn't matter to me at all at the time. I didn't even think about it. And I didn't distrust what he told me. I assumed it was true.
One lawsuit we've heard about here was the suit that D2 and Bristol brought against the Vaknins and their companies. Do you understand how it was that D2 was able to settle with the defendants, we'll call it the Vaknins, without the Bristol group being a party to that settlement?
So that lawsuit was filed in or around September, October 2016. Mr. Hyder's lawsuit and our countersuit was filed much after that in February, March 2018. So what happened was that suit came up on the trial calendar, right? And so it comes up on the trial calendar in 2018, June or about there, when Mr. Hyder and I are in the middle of the litigation that we're currently here for. And so at that point, we clearly were not cooperative parties. And so I'm not sure if it was a legal decision or not, but we made a request to separate ourselves in the lawsuit, and that request was granted.
There were some communications that we saw about a request from Mr. Hyder that D2 not disclose the source of its funding when one of the financing options was out there. You're remembering what I'm referring to?
I think you're referring to the text message about don't tell Lisa where you got the 230 from.
I believe that's what the question is about. Why did you agree with Mr. Hyder to withhold or hide that information?
So that was Mr. Hyder gave me instructions all throughout this, and do this, don't do that. Right? And so with that particular instruction, it actually never came up. Lisa never asks, where is the 230 coming from? How are you getting that? Do you have it? Give me proof of funds, send me a bank statement. She never asked for any of those things. Our conversation didn't involve that 230 and at least where it was coming from at all. So in no way, I didn't have to withhold any information about where it was coming from. And so I guess if she asked me the question, then I would have considered that I've got that money, or how much does she want to know about it? I can tell her.
There was an email from Sam McGuire, involving Sam McGuire, in February of 2018, in which he referred to a need for Donnie's parcel and references to Donnie's parcel. Why, if it wasn't Mr. Hyder's parcel, were people referring to it as his parcel?
So officially, it was his parcel. So that's very clear in the tax record. Officially, by the way that Ms. Kimbrough filed that, the way she had that warranty deed done, and the way she filed those in the books, it was officially, as far as the city of Atlanta is concerned, belong, and still does belong, to Bristol Consulting. And so what Sam McGuire is referring to is that in order to make that development more marketable or more developmentable, that he would, my understanding of what he was saying is that he would need that parcel, because we talked a little bit about this whole new market tax credits. I'm not sure what else is available out there for mixed use versus non-mixed use developments, but that is my understanding of what Sam meant when he said that he would need to have that parcel, because it was in reference to kind of developing or selling the property.
There were many references to Mr. Hyder receiving his money on the back end. Can you explain what receiving money on the back end means?
So the idea on the back end is that this is not a land purchase and hold. This is a development of property. And so when the development of that property has been completed or secured, that would be the back end. In my mind, the back end was when we had permanent financing on the property. And so I described in my medical office building how we went from land purchase loan, construction loan, and then you have one big loan that takes both of those two loans out. And that is your permanent financing. And so that would be the back end of this deal when that permanent financing was obtained.
When you and Mr. Hyder were working through another approach to financing a deal after the foreclosure, we heard Dion and different companies. Were you ever asked by Mr. Hyder for updated financial records for D2?
At that last deal, is it a question for you, just that last one or throughout the time?
So my question to you is whether Mr. Hyder asked D2 for updated financial documents after the November foreclosure for purposes of securing financing.
Okay. So it was just to correct a little bit, the foreclosure happened at the beginning of September, and I don't recall if we specifically had to get an updated personal financial statement. He already had copies of our tax returns and our financial statements, both Brian and I's and the company's, over the last several years. So we had already sent all that to him prior to this. And so I don't specifically know if during that time period of November to the end of December, if we updated those forms. I don't remember. We may have, we didn't, but at no time did I not do or produce a document that I was requested to produce.
Talk about carry costs a little bit. Do you know if Mr. Hyder knew that the interest in one of the transactions was deferred so that there wouldn't be interest as a carry cost?
So interest is a carry cost. It is deferred, though, to the final settlement of that loan. And Mr. Hyder was aware. We pulled up, I guess we did that little thing where we added 2 more pages to that email. Mr. Hyder had that email and that complete description of the deal, just as it is in that email with how it's all outlined. That was forwarded completely with attachments to Mr. Hyder. So he was 100% aware of what that deal looked like.
Do you have any receipts or other forms of proof of what Mr. Hyder actually paid out for the types of carry costs we talked about, insurance or X needs to be done, and you get a text or an email saying you need to wire, and wires went to Bristol or wherever they went? Do you have any receipts or proof that the money you sent to Mr. Hyder or his company then went to what Mr. Hyder told you the money was needed for?
So in the scope of this litigation, we contacted, the biggest thing is attorney's fees. We contacted the attorneys who were involved in this deal, and we said, please produce a ledger of the charges and the work you did for D2 property, Brian and or John Dalton. And so we have some of that information, not every attorney completely complied, but from the information I have, I do not have records of work to justify what Mr. Hyder told me to pay. So specifically Matt Tribble, I was specifically told to pay Matt Tribble, I think It was ended up being $15,000. That went to Mr. Hyder, and I don't have the receipts that Matt Trillo gave us don't add up to $15,000. With regard to Chuck Watts, we specifically asked Chuck Watts to produce us a list of the hours he spent, kind of detailing that, which is similar to what I get from my attorney. And he was unable to produce anything that would have added up to the $45,000 that we ended up sending to Chuck Watts. That the 129 hours at this rate, he did not produce anything to document 129 hours of work. With regards to who was the other attorney? Oh, Kimbrough. The same thing is true. Ms. Kimbrough was not forthcoming with producing any sort of documents which validated hourly rates and work, which would have equaled the amount of money that Mr. Hyder said I owed, specifically that November transaction, like that 25 that got to 15. And then before that, there was, another transfer somewhere in the middle there around January or no, so over the January Tretzky deal, there's another transfer in there, and that none of that was documented by them. Does that answer that question?
That's your answer. Did you inform Mr. Hyder that you at some point began to record the telephone calls you and Mr. Hyder had?
So I did not. And, we Googled it again and tried to figure out, is it even legal to record someone's conversations in the state of Georgia? And it is if you are party to them. So if I am party to that conversation, I was under my impression was, maybe not legal, my impression was that it was okay for me to record my own conversation with somebody else. That was okay. And I did not want Mr. Hyder to know that he was being recorded, because I, at this time, knew that it was really important that I protect myself. And it was going to be important that Mr. Hyder was not pulling any punches with what he was saying.
You testified several times that you felt Mr. Hyder was threatening to come after you and your brother, D2. Can you share with the jury what you meant by threatened and what come after would mean?
Threatening was a threat of suit, and come after was, I'm going to come after you for $1 million. So basically sue you for $1 million would be the translation of that. That was what I was afraid of, and kind of what led to a lot of my decision making.
You testified at several points about not having done due diligence on either a representation that Mr. Hyder made to you or a new actor being introduced to the equation, be it a lender or a lawyer or whatnot. Where do you feel your obligation to have done some due diligence comes in terms of your reliance being reasonable?
There was only one lender I did some due diligence on in this process, and that was early on, and showed that to Mr. Hyder, and he decided that we wouldn't work with that lender anymore. But as far as my obligation, clearly I should have done more due diligence. I fully admit that. I went into this based on trust, and I should have done more. So in that way, yeah, I'll shoulder that responsibility, and that I didn't meet that.
In a related vein, why did you continue to hire or pay attorneys that Mr. Hyder referred to you after having unsatisfactory experiences with earlier attorneys that Mr. Hyder either referred you to or said, this is the one we should use?
That came down to that fear, and protection. I was afraid he was going to sue us, and I was trying to protect myself, my brother, our families, and somewhere in there, a smaller part of it for sure was some hope that, yeah, maybe he'll actually come through. Maybe he will. That's why.
Ms. O'Neill, do you have any follow-up questions based on those questions and answers?
I do not.
Mr. Kimball?
No, not in this time.
Okay, ladies and gentlemen, we're going to take our lunch break. We're going to start back up at, if we start at 1:50, so that would be a 53-minute lunch break. Is that too short? I don't mean to shortchange you, but I'd love to get some stuff done in the afternoon. And we've got witnesses to cover. So please be back in 8E a little before 1:50, and we'll try to get you in here as close to 1:50 as we can. Have a great lunch. Please don't talk about the case while you're out there, and we'll see you at 1:50.
All right, so zero.
Okay, you all can be seated. And you're welcome to, you're done for now. Ms. O'Neill, anything you want to get on the record before we break for lunch?
Just one housekeeping matter, Your Honor, I don't know if you wanted to plaintiff's exhibit, or I want to do it, but yesterday when we advised the court that we had spoken to the Backman's lawyers and everyone agreed to waive the confidentiality, I gave the court an email. I'd like to make that email part of the record in case I get hit by a bus, Mr. Harper gets hit by a bus, and someone's trying to figure out what we did. Should I just mark it as the next plaintiff's exhibit? It doesn't have to be admitted, I just like to have it in the record, or should it be a court exhibit?
It can be a plaintiff's exhibit. I'll hear from Mr. Kendall, but it will just be one that doesn't go back with the jury, but that makes it part of the record so that there's paper along with transcript. Mr. Kendall, do you have any objection to, what number will it be?
280.
Any objection to plaintiff's 280 being made part of the record?
No.
Okay, it's part of the record. Anything else, Ms. O'Neill?
Your Honor, we would also
Ms. Tucker?
object to Mr. Kendall's violation of the motion of limine regarding the status of our law firm when he referred to our trial graphics guy as doing fancy stuff in front of the jury, and the implication that we have more resources.
I felt that. I tried to address it then. I trust Mr. Kendall won't do that again. It may have been tongue in cheek, but it wasn't the right thing to say at that time. All right, Mr. Kendall, what would you like to get on the record before we break for lunch?
Were there any questions that you did not ask?
Yes, and they're all, every question that was written will be made, as I explained before, the process is this. Every question submitted is made part of the record. And so someone who wants to explore what wasn't asked can simply look at what was asked, look at what the questions are, and do the subtraction.
I'd like to read into the records the questions that you did not ask.
That's not happening. What else would you like to do?
That's it.
Okay. Mr. Kendall, you have a project over lunch. We're going to send an email back to Ms. Kimbrough's lawyer. Ms. Kimbrough's lawyer says, I have no idea what this is about. Not aware of any subpoena Ms. Kimbrough received. I trust you got a subpoena to Ms. Kimbrough, but I need to extract the court from that dialogue. So I'll explain to the lawyer that I had Ms. Niles reach out because it was represented to the court that Ms. Kimbrough had been served, and you and Ms. Kimbrough's lawyer can take it from there.
I'm going to send her right now a copy of the affidavit of service that we found.
Great, that'll help. So let's be back at 1:45. We're going to have two witnesses here who will be the defense's first witnesses, but we have one more witness from the plaintiff that we'll work through. It sounds like then plaintiffs will rest. Excuse me, we'll talk about what we need to talk about. And then Mr. Kendall, hopefully you'll be ready to take Dr. Fowler and Mr. McGuire. And by the time you get to them, it may be that McGuire wants to go for, I'm neutral, but ideally we'll accommodate their schedules as long as it doesn't affect the way you want to present your case. Okay. Thank you, everyone.
You said you want 45?
1:45.
Okay, now I probably may not be with you for the afternoon, another deputy. will be coming to relieve me. Remember now, I'm a supervisor.
I know. Well, we will suffer through it.
Yes, but they're gonna get good instruction about what's going on, so they'll be able to carry on.
I bet they'll be able to handle it.
Last couple days.
Okay, thank you.
In good hands. Okay. Have a great week.
Mm-hmm.
Now I'll probably be back Monday though. I'll be back with y'all on Monday.
I'm not sure I will be, but good.
Oh.
Hopefully you'll be there.
Okay.
Yes. Thank you.
Yeah, you're gonna do it this very second. It may be said
Success. Okay. Are you ready? Great. All right. Welcome back, my friends, from your truncated lunch break. Sorry about that. Ms. O'Neill, anything from plaintiffs before we bring the jury back in? Ms. Tucker.
I've given Mr. Kendall a short list of documents I'm going to use with Brian Dalton, and just wanted to know if there were any objections to those documents so that we can streamline this.
Mr. Kendall, you may not have had a chance during your lunch break to go through them. If you did, are these things that can be admitted summarily, or should we have Ms. Tucker go through them individually in terms of authentication and foundation with the witness?
I don't know, I'm looking at the last one right now.
Mrs. Hyder, I don't think I ever said good day. Good day. That page looks pretty important.
Well, it's got, can I ask you one simple question?
So this is not on the record.
Yeah.
All right, I have no objections.
Okay. So what we'll do is when your witness is on the stand, you can say, Judge, we tender, and you can rattle off in numerical order the exhibits that you want to get in. And it sounds like Mr. Kendall will say he has no objection to that. If he changes his mind, that's fine. We'll work through it. But it sounds like those are okay from an admissibility perspective.
And for the record, that order made sense to me.
It's all good. Ms. Tucker, did you have anything else?
I do not.
All right. Mr. Kendall, anything we should take up before we get the jurors in?
I do want to.
Can you take your, make sure we can hear you.
I do want to report that I spoke to Crystal Kimbrough's attorney over the break and explained to her what our status was here. And she said she was going to speak back to Ms. Kimbrough and get back to Ms. Niles.
Great. Thank you for doing that. I fear we scared Ms. Ellison off, or she's doing other business for Wayne Kendall PC, or both.
The latter.
Okay, good. We're ready for the jurors. If they're ready for, they don't get to say. They need to come here. Please.
All right, as y'all see, I'm turning over to.
I see it. We're in good hands. All right, don't mess up.
Okay, hopefully I'll see y'all back probably on Monday.
Be safe.
Have a good weekend.
All right. Thank you, Sarge. You all should know that the Sergeant is advocating fervently for there to be more food options in this building. He's not wrong. I don't know what he thinks I can do, especially in the middle of trial, but I've been asked each day, did you bring it up? I don't know to whom I would bring it up. But way back in the day, there was a cafeteria in the government center. You could go there and get lunch. It wasn't good, but it was food. Then we had this freshman's thing in the basement.
Right.
And for a while, it had a kitchen, but the kitchen's exhaust went up through at least Judge Russell's chambers. And she very understandably did not want her chambers to smell like fried fish. And so they had to stop operating the kitchen piece of Freshman's. But there still was something. And obviously, the pandemic has thrown everything off. But
Long before that, there was more options at the underground where you could sit over and get lunch.
well, that predates me. But allegedly, in this jiffy, the underground is going to be bustling. Someone bought it free and clear and has described some impressive visions for it. But this is probably the 68th owner. But it's rather than it being some corporation from somewhere else, it's an individual. I'm sure it's an LLC, but it's an individual who is present and is talking.
You know, I lived down in Centennial Park, and that all started on individual president who built something. You know.
Underground has never succeeded, and it's a great plan, they had some great things. There's several owners.
You don't need to take that down.
It should succeed.
Where we are? 185 Central. Central Avenue Southwest. What do you need this for? 30303. Yeah,
She's sending you a notice to produce.
exactly. Fortunately, I have nothing to do with paying for transcripts. We did get a bill once. You owe for the, like, trust me. Yeah. Yeah. Like, this needs to go to someone else on my transcript.
So Matt says you're right. Oh, really? Just fire or something. And I found that I physics or something, and That's amazing.
So I said, well, I said, you don't really have that for sale. You know, the real convenience, he said, if you look at that. He told me to keep watching.
Apparently this new deputy is not good. You're the jurors.
All right, so you're.
Don't spill that coffee. Thank you, Deputy. You all can be seated. Welcome back, ladies and gentlemen. We are at a different point in the trial. It may seem a little unfamiliar to you, but I'm going to ask Ms. O'Neill if she has another witness that she wishes to call in the case.
Yes, Your Honor.
Ms. Tucker.
Let's just call this in Brian Dalton.
Mr. Dalton, Brian Dalton, please come on up. And before you're seated, I'll have the deputy swear you in.
You saw a front company that said this is for the true old. About the true color you got. I have C-section next up.
Good afternoon.
Good afternoon.
Before we get started with you, I just have a couple housekeeping
He
things.
needs to just, for formality, state his name and spell his name for the record.
Go ahead.
Brian Dalton, BrianDalton.
All right, before we get started, I have a couple housekeeping issues. Plaintiffs would move into evidence Plaintiffs Exhibit 33, 58, 59, 62, and 64.
Okay. Mr. Kendall, any objection to those 5 exhibits from plaintiff?
No, sir.
Those are admitted.
Also exhibit plaintiffs 274.
One more, 274. Any objection to 274, Mr. Kendall?
No.
All right, they are all admitted.
Great. All right. Mr. Dalton, you are John's brother?
Yes,
Are you the older brother or the younger brother?
I'm the younger brother
Okay. And where do you live?
in Atlanta.
And how long have you lived here?
A little over 20 years.
Are you married?
I am.
Do you have children?
2 kids,
Ages?
13 and 11.
Girls and boys or?
Gabby's our 13-year-old and Spencer's our 11-year-old.
And what do you do for a living?
I'm in medical device sales.
Did you go to college somewhere?
I did, University of Florida,
Okay. And what degree did you get?
finance,
When did you graduate?
2000.
And what's your involvement in D2 Property Group?
I'm one of the partners
When was D2 Property Group formed?
in October of 2015.
What was the purpose of forming that property group?
Real estate investment.
Is D2 Property Group currently operating?
Yes.
Who are the members of D2 Property Group?
John Dalton and myself.
Who are the officers?
John Dalton and myself.
In this transaction related to the Verbena Street property that we've been talking about, who is the spokesman on behalf of D2 Property Group?
John Dalton.
And why is that?
I had minimal involvement in the day-to-day, and John had the relationship with Donnie Hyder.
Can you tell us generally what your involvement was in the Verbena Street project?
Initially, I looked at a couple of documents, appraisal. Ultimately, I invested money in the property, and that was most of my involvement outside of filling out financial documents from time to time.
Were you involved in the day-to-day operations related to the Verbena Street project?
I was not.
Were you asked to provide information in connection with the Verbena Street project?
I just provided my own personal financial statements.
And did you comply with all requests for information to the extent they were made?
I did.
And who did you provide that information to?
Donnie Hyder.
When did you first meet Mr. Hyder?
We met one time. It would have been during the time we were looking to purchase our first single family apartment, which turned out to be the duplex that we purchased.
Is that the Mildred property?
It is.
So you met Mr. Hyder one time, and when that was back in 2015?
It would have been 2015, yeah.
And how were you introduced to him?
Through John.
In the course of your dealings with Mr. Hyder through D2 Property Group, how did you communicate with him the most?
Email.
And who was the primary point of contact with Mr. Hyder on behalf of D2? Is that you or is that John?
It was John.
And what was your specific role in communicating with Mr. Hyder, if any?
I didn't have a specific role. I would get asked for financial documents, which I would supply. Personal financial statements.
Are you familiar with Bristol Consulting Group?
Through this litigation.
And what is your understanding of what it is?
It's one of Donnie Hyder's entities.
Same question with American Business Group. Are you familiar with that?
I was familiar with that just from the property management side. He was our property manager, and that was the name that was attached to those documents.
And was your understanding that American Business Group was also connected to Mr. Hyder?
I was.
Tell me about the first time you remember working with him, with Mr. Hyder.
It was essentially a relatively brief meeting. We met near the property, walked the area, talked briefly about it, and then that was about the extent of my meeting with him.
And when you say the property in you're talking about Mildred.
Mildred, the duplex. That's
okay,
correct.
just to clarify,
Yeah.
You never went to the Verbena Street property and met with Mr. Hyder at that property.
I have not.
And prior to the Verbena Street project, how many residential properties did you buy that Mr. Hyder was involved in?
We bought 7 properties.
And what was your involvement with those properties?
I was part of the financial backing on those properties. We split the costs of each of the units.
Would it be fair to call you sort of a silent partner behind the scenes? How would you characterize yourself?
That would be fair.
And what was Mr. Hyder's role?
With the single family homes, he was our property manager. So took care of collecting rents, maintenance, made sure everything was in tip top shape for our residents that were living there.
Was Mr. Hyder a member of D2 Property Group?
He is not.
Did you ever give him authority to act for D2 Property Group?
I did not.
And you were present in this courtroom for Mr. Bankman's testimony and your brother John's testimony related to the Verbena Street project.
Yes.
So I don't want to go back over those things that the jury's already heard, but I would like to discuss your role specifically in the Verbena Street project. How did you come to hear about the Verbena Street project opportunity?
I heard about it through John.
And when was this?
This would have been in May of 2015. So
Was it 2015 or 2016?
2016. I'm sorry, May of 2016.
Did you talk to Mr. Hyder directly about that opportunity?
I did not.
You said you had a conversation with John. What went on in that conversation? Can you tell us about that?
We talked about a couple different spreadsheets that were kind of going back and forth about evaluation of the property, the appraisal that came through, and that was kind of our conversation assessing, is this something we can really do?
Okay, and you mentioned the appraisal. Did you review the appraisal?
I did.
And where did the appraisal come from?
Came from Donnie Hyder.
Okay, let's look at Plaintiff's Exhibit 32. Can you bring that up? Should be in volume 1.
32.
Mhm.
In that volume 2.
Yes, that'll be the first one in volume 2.
Bad guess.
You need the cheat sheet.
I know, it's up here.
No, he
He's
doesn't.
got one. He's saying I need
Tucker.
a cheat sheet. Okay, so is this the appraisal that you were talking about?
It is.
Okay, and let's flip to page 4 of that document deck. Okay,
I'm there.
what information does the appraisal give you?
The as-is market value and the proposed market value.
Is this what you were referencing when you were talking about the values of the properties?
Yes.
Was this your understanding of the as-is market value at that time?
At that time,
Was this your understanding of the as-proposed market value at that time?
potentially.
Okay. And what was your understanding of what the Verbena Street project properties included?
It was parcels A through I. So it was the apartment complex and also the retail space.
And why did you think it included the retail property?
Those are the conversations that I had with John, and there were some potential tax credits. There's a tax credit worksheet that was part of these conversations of moving forward and getting financing for it. And the tax credits supposedly needed a retail portion to them.
What did you all decide to do next?
Ultimately, we moved forward. We put $150,000 down, and with a $100,000 that was refundable if the deal did not close in the specific time frame, which was June 30th, 2016.
how was D2 Property Group going to pay for the Verbena Street project initially?
Well, we were putting in the 150,000 and the rest of the financing was going to be coming through Donnie Hyder.
And out of that $150,000, what portion of that, if any, did you think was going to be refundable if the project didn't go through?
$100,000 of it would have been refundable.
So $50,000 was at risk.
That's correct.
Was there anything specific that made you decide to move forward with the Verbena Street project?
There was a large upside to a relatively low investment. I mean, essentially $25,000 from each John and I. I mean, that's still a lot of money, and I certainly didn't want to lose that, but there was an opportunity for a larger win in that situation. So we moved forward with it.
Did you ultimately put down the $150,000?
We did.
Who is the money paid to?
I was paid to Donnie Hyder.
And how much did you personally put in?
I put in 110,000.
So let's pull up Exhibit 274, which we just admitted.
You said 6.4?
274.
2.7, the big one. Okay, 274.
Okay. Do you recognize this document?
Yes, it's my bank statement.
Okay. So let's flip the page, Zach. Yep, right there. And this whole page is blacked out, so we're not sharing your personal financial information in the public record. But at the top there, there's a description. And can you explain what that is for?
Yeah, so on 6/20/2016, I made a transfer from my account to Donnie Hyder's account in the amount of $110,000.
Was that money that you just had laying around in your checking account?
No.
Could you afford to lose that money?
No.
What was your involvement in the project after you put in your 110,000?
I was relatively minimal going forward. I would get emails about asking for different financial statements, and I complied those emails and sent them to Donnie.
Other than complying with those emails, did you have any other communications with Mr. Hyder?
They were limited.
What was your understanding of when Mr. Hyder needed to get financing in order to purchase the Verbena Street projects?
It was 6/30/2016.
June 30th?
June 30th.
Okay, I know you said you weren't involved in the day-to-day details related to the Verbena Street project, but I do want to talk about your familiarity with the Victoria Group.
Mm-hmm.
Do you recall the name of that group?
I do.
And what is it?
I was a broker that was supposed to find financing, permanent financing for us for the project.
And why did you think that they were going to help you find financing for the project?
I was someone that Mr. Hyder introduced to us, and we pursued it.
So your introduction to Victoria Group was through who?
Donnie Hyder.
And what did Mr. Hyder tell you about the Victoria Group?
Well, in terms of getting the financing, we had to give them $230,000, which was supposed to be refundable if they were unable to get us financing.
All right, Dak, let's look at Exhibit 150. Are you familiar with that document, Mr. Dalton?
Yes, I am.
What is it?
It's the compensation agreement for the Victoria Group.
Is that your signature at the bottom of the document, or I guess it's in the middle of the lines?
It is.
What was your understanding of what you were agreeing to in this document?
We were agreeing to give them $230,000 that they would hold in escrow as they looked for financing. And if they did not get that financing, then we would get the $230,000 returned to us.
Did you and John ultimately pay that $230,000?
We did not.
Why not?
Well, we got a loan from Fowler, Robin Fowler, for the $230,000.
Did you have $230,000 in cash to pay for that?
I did not.
Did D2 Property Group have $230,000 in cash to pay for that?
We did not.
So where did you end up getting the money?
Through Robin Fowler.
And were you involved in the conversations with Robin Fowler related to that loan?
Yes.
What did those conversations consist of?
We had our initial conversation, and as far as him saying, yes, I will help you with that, I was not part of all the terms conversations that happened later on. But it was a short-term loan for us.
And what did Mr. Hyder tell you, if anything, regarding that short-term Fowler loan?
That the financing is right around the corner. We just need to get this started. You'll get the money back if it doesn't come through.
Did you rely on that information that you were given by Mr. Hyder?
I did.
Did you personally have any communications with the Vittoria Group directly?
No.
Who was communicating directly with them?
Donnie Hyder.
And did you end up getting financing from them by June 30th?
We did not.
So was your $230,000 returned?
It was not.
Why not?
Because they released the money out of the escrow account.
Were you ever able to recover any of that money?
We recovered $163,000 of that money.
How were you able to do that?
By hiring a lawyer.
Once you got the $163,000 back, where did that money go?
Went to Donnie Hyder.
And why is that?
That was through this litigation, understanding that it was his money. So we said.
Did you think the deal was over when Mr. Hyder had failed to get the financing by June 30th, 2016?
Yes.
What happened after that?
After that, there was another opportunity that Donnie Hyder brought us, and we needed to, if we could secure the property for $2 million and secure the property, that was 1.2 for the purchase price. And then we already went through all of this, the carrying costs, and then cost of the loan, interest of the loan that was associated with it. So we would then have the opportunity to have the property and then later on get long-term financing for it.
Was there a consulting fee associated with that $2 million loan?
There was.
How much was that roughly?
$160,000.
The consulting fee?
I'm sorry, $460,000.
Okay, let's move on and talk a little bit about Miss Kimbrough. Do you know who Crystal Kimbrough is?
Yes.
Who is she?
She was our closing attorney for this transaction.
And how did you get connected to Miss Kimbrough?
Through Donnie Hyder.
Did you rely on his recommendation of using Miss Kimbrough?
I did.
Did you think she was your lawyer and D2's lawyer in the Verbena Street project closing?
Yes.
What did Mr. Hyder tell you about her role?
That she would be our closing attorney for the transaction.
Okay, let's look at Exhibit 3. And I believe Ms. O'Neill showed this to the jury yesterday, so I've got some questions for you about it.
Okay.
So what is this, first of all? Let's just reestablish.
It's a email from Crystal Kimbrough to Abe Bakeman.
Okay, and it says, upon review of the file, I have uncovered the attached seller signed documents. At the time of the transaction, the buyer requested his loan terms to be confidential. so I cannot provide the buyer's settlement statement to you. I am not authorized to disclose the buyer's loan terms or anything related to their loan. Do you see that?
I do see that.
Did you give these instructions to Ms. Kimbrough?
I did not.
Did you give her any instructions related to keeping documents from Mr. Vankman?
I did not.
Did you ever tell Mr. Hyder you wanted the loan terms to be confidential?
I did not.
Did you ever tell anyone you wanted those loan terms confidential?
I did not.
Do you know who the buyer is that Ms. Kimbrough is referring to it in this email?
I do not.
Is that D2 Property Group?
I would assume that she's referring to us, but because we were the buyers of the property.
Okay. And who paid for Ms. Kimbrough's fees?
John and I,
What date was set for the closing on the Verbena Street properties?
July 13th, 2016.
What was your understanding as of July 13th, 2016, as to the terms of the deal?
That we were getting a $2 million loan from Fowler Financial. 1.2 million of that was going towards the cost of the property. And then we had closing costs that were associated with that. And then there were carrying costs for the property that would be the difference in those amounts where is how we would pay for keeping the property.
And what about that short-term loan from Fowler Financial for $230? Was that included in there?
That was also included in there.
Okay. Were you provided with the closing documents before the closing?
Yes.
Who provided them to you?
Crystal Kimbrough.
All right, let's look at Exhibit 15. Jack, can you pull that up? Can you identify that document?
It's an email from Crystal to John.
And it's on July 12th, 2016 at 2:36 p.m., right?
That's correct.
Let's go to the second page of the email chain. Do you see your name and email on here?
Yes.
And what was that email doing?
So John sent me the email, the settlement statement, and then we had an exchange about the Hyder consultation fee will be used to carry the property insurance, getting through the next phase of financing.
Okay, so the first email from John to you is July 12th at 2:58 p.m. and it is forwarding the settlement statement, the HUD settlement statement, correct?
Correct.
Okay, and then the next email is July 12th, 2016 at 1 minute later, 2:59 p.m. from John to you. And John writes, the Hyder consultation fee will be used to carry the property insurance, getting through the next phase of financing. Is that right?
That's correct.
Was that your understanding of what the Hyder consultation fee was going to be used for?
Yes.
Had you all had any discussions about this Hyder consultation fee other than what you see in this email?
John and I had that discussion right there.
And this summarizes your discussion?
It does.
Do you know why it was termed a consultation fee?
I do not.
Did you respond to John's email on July 12th?
I did.
What did you say?
I said, here we go.
What does that mean?
Means we're going to see if we can get this opportunity closed. We're closing the property tomorrow morning.
Okay.
Hold on one second. Yes, ma'am? Oh, yes, ma'am.
Sorry, speak a little louder.
Sure. If you would just make sure you get a little closer to the microphone. Thank you.
Absolutely.
Thank you.
All right, you can take that one down. Let's look at Exhibit 16. Have you seen this document before, Mr. Dalton?
I have.
What is it?
It's a email from Crystal Kimbrough to John Dalton on July 12th, 2016 at 7:14 p.m. about the closing documents for the closing tomorrow.
All right, let's flip to the next page. Are you on the next page?
Yes. So July 12th, 2016 at 9:24 p.m.
Okay. And what does that email say?
All the docs, I looked through them, they look good to me. This is at 6 in the morning.
And that email was from John to you,
That was from John to me.
and you received that email.
I did.
Did you also review the documents that were attached to that email and had been forwarded to you?
I did.
Other than the documents that were attached to this Exhibit 16, did you receive any other documents prior to the closing?
I did not.
Where did the closing take place?
At Ms. Kimbrough's office,
And did you sign documents at her office that day?
I did.
All right, let's look at Exhibit 169. You can go ahead and put up the second page of that document. Is Exhibit 169, sorry, are you there now?
I am here.
Okay, is Exhibit 169 the documents that you signed at Ms. Kimbrough's office on July 13th?
They are.
Did you closely review these documents before you signed them at the closing?
Not at the closing, the night before,
So why didn't you closely review them at the closing?
because I looked at them the night before. I thought they would be the same.
Were you relying on Ms. Kimbrough's advice as your attorney?
I was.
Did you have any reason to believe that the documents you signed at the closing on July 13th, 2016 were different than the documents you had previously reviewed in your email?
I thought they would be the same.
And did the deal actually end up closing on July 13th?
No,
Why not?
because we didn't have the seller's signatures.
In September 2016, were you asked to re-sign the settlement statement HUD-1 documents for the Verbena Street project?
Yes.
All right, let's look at Exhibit 24. You can just look at it on the screen if you want to make it easier. Does that look familiar to you?
It is. It's a email from Crystal to John and myself about consolidating both signatures on the HUD one.
Did you sign that new settlement statement?
We did not.
All right. And what was your involvement with the Verbena Street project after the closing?
Very little. I would get emails from Donnie requesting for financial information, and I would fill it out and return it.
Did you comply with all of the requests that you were sent to provide information?
I did.
Let's fast forward from 2016. So now we're jumping forward to June of 2017. Okay, with me?
Yep.
Has any financing been procured by Mr. Hyder as of June 2017?
No.
Have the carrying costs for the Verbena Street project been paid by Mr. Hyder?
No.
So what happens in June of 2017?
We get a letter that we will be getting foreclosed on.
Can you pull up Exhibit 140? Is this the letter that you referenced?
It is.
All right. And what is it?
It's a notice of foreclosure sale.
Did you receive a copy of this?
I did.
How did you feel when you received a copy of this foreclosure letter?
Disappointed, but understanding that we were unable to get financing for the property.
Were you involved in any discussions with Robin Fowler or Sam McGuire related to the foreclosure?
No.
Did you discuss with John at any point trying to push Mr. Hyder out of the deal by having the property foreclosed on?
No.
Did you discuss with Robin Fowler at any point trying to push Mr. Hyder out of the deal by having the property foreclosed on?
No,
Did you discuss with Sam McGuire at any point trying to push Mr. Hyder out of the deal?
no,
Did you ever have any conversations with John, Robin Fowler, or Sam McGuire related to preventing Mr. Hyder from getting money?
no,
Do you recall John testifying that Mr. Hyder threatened to sue him for the $1 million promissory note that we've talked about?
yes,
And you heard the audio tapes sitting in here that were played.
yes,
Were you aware of that threat of lawsuit, that shakedown that was going on at the time that Mr. Hyder made it back in 2017?
no.
All right. What happened after that foreclosure letter came?
After the Brittany Turner letter, John and I,
Well, before that, was the property foreclosed on?
the foreclosure, yes, ultimately in September of 2017.
So after it was foreclosed on, what's the next thing that you recall happening?
The next thing was, there was, I know, some conversation around potentially another lender, which did not work out. And that led us to 2018, where I received a default notice.
And before you received that default notice, did you have any conversations with John?
Yeah, we had a conversation that Donnie Hyder is going to be coming after us for $1 million.
And when did that conversation take place?
Would have been the very beginning of January.
Can you tell us a
2018.
little bit more? I'm sorry, I cut you off.
2018, sorry.
January 2018?
That's correct.
Okay, and what did you discuss with John in that conversation on the telephone? Or was it on the telephone or was it in person?
It was on the telephone, and ultimately it was, we need to sue Robin Fowler or Donnie's going to sue us. And we were not going to sue Robin Fowler. And so here we are today.
Was this telephone call that you received in January 2018 from John Dalton the first time you realized this was a problem?
It is the first time that I realized that it was a problem, yes.
Had you been involved in anything related to the Verbena Street project after the foreclosure in September 2017?
No.
I think you said just you knew about a lender maybe?
There was always a lender, but nothing. I don't think I had to supply any type of documents. I just knew there was something else that was potentially happening.
And between that time period of September 2017, when the property was foreclosed on, and January 2018, when you found out about the lawsuit threat, were you communicating with Mr. Hyder during that time period?
No.
Right. Let's look at Exhibit 139. Have you seen that document before?
Yes.
What is it?
It is a letter of notice of default.
And when did you receive that letter?
January 23rd, 2018.
How did you feel when you got this notice of default letter from the law office of Renee Turner?
I was very concerned and very frightened.
Why did you feel concerned and frightened?
Because I don't have $1 million to pay, and I did not owe $1 million to anyone.
Did you discuss the issue with John?
Yes.
What was said in that conversation?
At this point, we knew we had to retain counsel.
And did you retain counsel?
We did.
Did Mr. Hyder end up suing you?
He did.
What did you do to respond to the lawsuit?
We filed claims against Mr. Hyder.
Does Mr. Hyder still have a lawsuit against you?
He does not.
And do you know whether the court looked at whether or not you, John, or D2 Property Group owe Mr. Hyder any money?
They did look at that and they dismissed it.
Did the court find that you owed Mr. Hyder any money?
No.
All right, Mr. Dalton, how much money are you personally out of pocket as a result of agreeing to enter this deal with Mr. Hyder?
Around $450,000.
And what does that $450,000 include?
Includes $110,000 from the initial investment, and then lawyer's fees, and also the missing rents from that time period when Donnie was holding on to them.
Are you including any of the loan monies that went to Mr. Hyder for the carrying costs on the properties? I know we've heard about the $457,000.
No,
Okay, so that 457 is not included in your 460.
that's correct.
And if you're looking at the total losses for D2 Property Group as a result of this entire transaction, what's the number on that?
It's right around $2.5 million.
Sitting here today, do you think Mr. Hyder provided you and John information that was not true?
I do.
Can you detail any of the information you believe you were provided that's not true?
There's always a lender that was coming to take a look at the property. There was always someone that was not going to pan out, and we paid every time that these people came to look at the property. And so the $460,000 that was part of the carrying cost was supposed to take care of that. And we ultimately had to pay ourselves or out of our own pockets to continue to look for financing.
Would you have entered into the Verbena Street project if it wasn't for what Mr. Hyder told you?
No,
Did Mr. Hyder's representations to you cause you to lose money?
yes,
Did his actions affect your relationship with your brother, John?
definitely.
Can you describe the emotional toll that this whole process has had on you?
Yes, it's been unbelievably hard. 2016 and 2017 were a very challenging year without this. And that led us to 2018. And as we're entering into 2018, I find out that I am now involved in a lawsuit for $1 million, which I don't think I owe. And so through that time, as we get into 2018, I'm about, my bandwidth emotionally is very thin. I had a death in my close family. And I just was not able to handle a relationship with John at that time. So it drove us apart. I didn't know what to do. I was scared, and unfortunately, none of this needed to happen. And John would have walked away in 2017. I was not familiar with all the details of every transaction that was going on through 2017. And he was willing to go through all that and just walk away and be done. We would not be here in this situation right now if it weren't for Donnie Hyder.
Thanks. And I know you said 2016 and 2017 were particularly hard for you. Is there a reason that those years were hard for you?
In July of 2016, my father-in-law, who I'm very close to, was diagnosed with AML, acute myeloid leukemia, which is a cancer of the blood. So it's very emotional to kind of ride the highs and lows of cancer. I don't know if anyone else has experience with that, but every day we have this new test. We're going to get through it. It doesn't work. So my wife is running off to be with her family in South Florida. I'm trying to man the kids. Unfortunately, he doesn't make it. And we're trying to put our pieces back together just emotionally. And then this happens. And so it was not something that I was able to handle at that time, and still have a strong relationship with John. I just didn't understand why we were in this position. And knowing what I know now, there's no reason for us to be here. Donnie Hyder brought us to this place.
Do you think getting involved with this transaction has affected your family?
Absolutely.
How so?
John and I don't have the same relationship anymore because of all of this. Our kids are similar in age. We don't have the same relationship with my niece. I mean, it has been all consuming in my life. And so getting to where we are now has been a challenge, and it's been a challenge for my wife and I. It's been a challenge for, I know, for John and his family. So it has been extraordinarily hard.
Have you personally had to take time off work to deal with this?
I have.
Can you estimate how much time total you think you've had to take off?
It's been a couple of weeks.
What would make you feel whole here?
I mean,
Judge, I'm going to object the same objection I interjected before about these open-ended damage questions.
Okay, noted, overruled.
It's hard to put a number to this, and we have been through so much over the past few years. We've done everything that we could. John has done everything that he's could, and to get to where we are today. I mean, we look at everything that D2 has lost, and that's nearly $2.5 million of potential, so $5 million.
Thank you. No further questions.
Mr. Kendall, questions for Brian Dalton?
Yes, sir.
Thank you, Ms. Tucker.
Mr. Dalton, we never met before, have we?
No, sir.
Okay. I want to first of all express my condolences to you for the loss of your father-in-law.
Thank you.
I understand that that's a hard thing for anybody to go through. You only met Donnie Hyder, you said, one time, and that was at the Mildred property. Is that right?
I believe so.
So that was the first property that you guys got into with Mr. Hyder's involvement. Is that right?
That's correct.
And can you describe that meeting, please?
It was brief, my portion at least. We met at the duplex and walked the property, briefly drove the neighborhood, and that was the extent of my meeting.
Okay. Did you have any phone conversations with Mr. Hyder?
We may have communicated on the phone less than a handful of times.
Okay. Do you recall having any email correspondence between you and Mr. Hyder?
Yes, I mean, I would send him financial documents and things like that.
Okay. What about text messages?
I don't think I'm sure there was some text messages exchanged, but it was not a routine.
Okay. Now, were you in on any of those phone conversations that your brother John said he recorded of Mr. Hyder?
No.
Throughout the communications that you had with Mr. Hyder, text messages, phone calls, in-person meetings, emails, can you identify for me what is contained in those written documents that Mr. Hyder misrepresented to you?
In the meetings, I wasn't there for any meetings.
Okay, except for that first meeting at
Right.
Noted Property. That was well before the Verbena Street properties ever came up, right?
Yes, sir.
Okay, so now we're down to emails, texts, phone calls,
Mhm.
letters, any other types of communication. Can you identify for me what in those communications Mr. Hyder misrepresented to you about any subject, Verbena Street properties or anything else?
Mr. Hyder wasn't communicating with me.
Okay. Now, Ms. Tucker asked you about that's a similar question. What are the misrepresentations? And you said that there was always a lender that needed to be paid.
Mhm.
Is that right?
And that's certainly how I felt.
Okay. Now, what is your definition of carrying costs?
It would be the money that is involved to pay taxes, insurance, maintenance on the property, kind of the day-to-day maintenance, fees that are associated with going, or when these people are coming in to look at the property in terms of financing it, those types of fees.
In your mind, is there a difference between pre-development costs and carrying costs?
I don't have a difference for those.
What is your you don't have a different definition?
I'm not well versed enough to give you a different definition for those.
Okay, what is your background and experience in commercial real estate development, particularly multifamily housing?
I have no experience in it.
Did you ever do any due diligence on Donnie Hyder in terms of his ability to bring financing to the tune of $10 million to this particular project?
I did not.
Is there a reason you did not?
No, there's not a reason. Ultimately, it was we have this time frame of till June 30th, 2016 to get financing that Donnie Hyder feels that he will be able to secure. And that's going to cost us $150,000. And if it doesn't work out, then we'll get $100,000 of that back.
Okay, do you recognize that obtaining $3 million in 60 days is a tall order?
Objection, argumentative.
What was the objection?
Argumentative.
I think you can explore this, but I think you need to ask it in a different way instead of inserting your opinion as to whether that's easy or not easy.
Is obtaining $3 million in 60 days something that's easy or hard for an experienced real estate developer to do, in your opinion?
For an experienced one,
Yes.
I would think that would be potentially in 30 days, relatively easy.
You would think that would be easy?
I think so.
Okay. Have you ever done that?
No,
Have you ever attempted to do it?
I have not.
Do you know anyone that has attempted to do it?
No, not personally, just stories of people.
Would you feel that your reliance on Donnie Hyder to do that was reasonable?
So the conversations on
Overruled.
through the conversations I had with John at the time, he felt that Donnie told him he could get this done.
Well, I'm asking you about you personal. Do you feel that relying on Donnie Hyder to obtain $3 million or $10 million or whatever amount of money was the agreement that he would raise was reasonable? Your reliance on him to do that task was reasonable?
No objection, Your Honor.
Okay, overruled.
I didn't know Donnie Hyder, so I don't know if it's reasonable or unreasonable. What he represented to John was that he could get that done.
That's what your brother John told you?
Yes.
Okay. You indicated that you lost $450,000 in this Verbena Street Properties transaction. Is that right?
Yes, sir.
Can you detail that for me?
It'll be 110,000 from the initial 150 down payment.
Let me stop you right there. So of that $150,000, you put up 110 and your brother put up 40. Is that correct?
Yes. Well, I think John put up 30 and then 10 came from our D2 property account,
Okay.
if I remember correctly.
All right.
And then about 300 and I'll have to get the exact number, but $330,000 of legal fees, and then the rents that are associated with that Donnie Hyder held.
Wait a minute. Because that comes to 440. So the rents would have been 10,000?
I would have to go back and look and see what the rents were.
Okay. So the 330 that you say is attorney's fees, that's money that you personally contributed to attorney's fees?
Yes.
And these attorney's fees would have been to which firms?
To my lawyers right here.
To Wamba Bond,
Yes.
solely for this litigation?
For the charges that Mr. Hyder brought against us that were dropped in this litigation now.
Do you have any statements?
Yes.
Where are they?
I think they're.
Okay.
Your Honor, may I have first witness?
Sure.
I just want you to answer the question. Do you have any statements?
Yes, sir.
Okay. So the total of the 110, the 330, and the rental fees that Mr. Hyder withheld come to the 450,000.
It's going to be right around there. I'll have to do the exact math of that breakdown.
Okay. And did you ever answer Ms. Tucker's question? I might have missed it when she asked you about what your total damages were?
Yes.
What was it?
We said $5 million. I'm sorry, our total damages are around $2.5 million.
$2.5 million. Okay. I think that's all I have on Mr. Brian Dalton, Judge.
Okay. Any redirect, Ms. Tucker?
Just one, Your Honor. Mr. Dalton, can you identify what's in the last letter in front of you, please?
It is the statements for Womble, Bond, and Dixon.
Did you receive those statements?
Yes,
Did you correct copies?
yes.
Given to evidence as plaintiff's exhibit to 281.
Judge, I've never seen any attorney's fee statements from Wumble.
So we can talk about this when the jury's not around. I'll table whether it's admitted or not or made part of the record. I don't know if it was ever requested in discovery, which would be why Mr. Kendall didn't get it if he didn't ask for it, but we'll work through that outside the presence of the jury. So I'll defer ruling. It had been authenticated, and so we can work through relevance and whatnot. That's 281 is the number we're calling it?
Yes,
All right. Any other questions for Brian Dalton?
nothing further, Your Honor.
All right. Ladies and gentlemen, if you have any questions for Brian Dalton, you should write them down and pass them to your right, to the deputy, and we'll take it from there. If that's everything, bring it on up. Thank you. Thank you. Okay, Ms. Tucker and Mr. Kendall. Multiple on one.
Okay.
Oh, did you get it? You pressed that button. Brian Dalton.
Yes, sir.
Can you describe what due diligence, research, whatever due diligence might mean to you, that you did as a silent partner to review documents and transactions that your brother told you were going on in the course of the evolution of this deal?
Ultimately, I didn't do my part of due diligence. I was certainly distracted at the time and should have been more involved in the whole transaction, but I wasn't able to.
When you referenced a consulting fee, did you find out what was involved in the consulting that was being done?
I asked about the consulting fee.
Asked whom?
I asked John, my brother, about the consulting fee, and it was going to be used as the carrying cost for the property.
You quoted a figure of around $330,000 that you've paid for attorney's fees. those are attorney's fees associated with which piece of litigation that we've heard about or pieces?
So initially in 2018, Donnie Hyder filed a lawsuit against myself and John and D2 Property. And that's when the litigation, or that's when the fees started. We filed suit against him also after he filed against us. And so from that time frame to now are the attorney's fees.
And then when you were detailing for Mr. Kendall the components of the figure you're seeking, you mentioned about 10,000 in rents. That represents what?
So that, and 10,000 is not the correct number. And I'll have to go back and correct that, or we can look into that. But Mr. Hyder stopped paying D2 Property the rent money that was coming in and was then crediting it, in air quotes, crediting towards the promissory note that he thought that he had against D2 Property Group.
Did Mr. Hyder ever give you a reason why you, meaning D2 and your brother and you, should sue Robin Fowler?
No, the suggestion was to stop the foreclosure from happening. So if we sued Robin, he wouldn't be able to foreclose on us.
Right. Ms. Tucker, do you have any questions based on those questions and answers?
No, Your Honor.
Mr. Kendall?
No, sir.
May Brian Dalton step down? Thank you. Thank you, sir.
Do you want me to leave these here or take those?
I would leave those there. That when you say those, that's the 281 that the lawyers and I will work through. So right there. Thank you.
Thank you.
Ms. O'Neill, next witness. Okay. Ladies and gentlemen, at this time, the plaintiffs have rested. Mr. Kendall, are there motions we need to take up?
Yes, sir.
Okay, so we're going to give you your afternoon break right now. I hope to keep it to 15 minutes, but I do need to talk with the lawyers about things we talk about after a plaintiff in any civil case rests. So we'll do that and we'll get you back in here as soon as we can. The goal will be 3:15-ish, but bear with us if it's a little longer than that. The fact that the plaintiff has rested does not mean it's time to start talking about the case. It may be that you hear from Mr. Kendall and information that he wants to share with you as well. So please don't start figuring out what you want to figure out about this case with your colleagues. Talk about something else, no outside research, and we'll get you back in here as soon as we can. Thank you so much. All right, you all can be seated. We're going to do the motion first so we know what's happening after you'll get your brief break before we get the jurors back. So Mr. Kendall, if you would come to some microphone, your table at the podium so we can hear you.
Okay, can I have two minutes? Put my stuff together on this. Okay.
Judge, we have several claims that have been made in this lawsuit. The first claim is for fraud in the inducement. I don't believe the plaintiffs have put up a case sufficient to make out the elements of a fraud and inducement charge. And the largest element of that claim that they have failed to put up sufficient evidence on, and actually have admitted that they can't prove, and that's the element of justifiable reliance and due diligence. Both Daltons have testified that they did not perform a due diligence in their vetting of this transaction and Mr. Hyder's involvement in it and his ability to do what they claim he had agreed to do verbally, because there is no written indication that he ever agreed to find financing for this deal, or that he had the ability to do the financing other than what Mr. Dalton testified to about. He said that he could get it done, but it's not specific as to what he was talking about as to what he could get done. So I think one of the crucial elements of a fraud in the inducement claim is missing with regards to misrepresentations and the element of justifiable reliance on whatever is claimed to be a misrepresentation. So even if there is disputed evidence or some evidence about a misrepresentation, there's absolutely no evidence, and the admitted lack of due diligence in vetting whatever information was represented that is now claimed to have been misrepresented. That's number one. The other charges, for example.
You're done with fraud?
Done with fraud.
Question. I'm not familiar with due diligence being an element of a fraud claim. Certainly justifiable reliance is, and one way someone could measure justifiable reliance would be diligent work that someone did to check into the believability or the credibility of the person making the representations. But I'm not familiar with due diligence as I heard you, you're saying, first, I agree. I've heard the same thing. Brian Dalton, John Dalton, we didn't do due diligence. They testified to that many times. I don't believe that that is fatal to a fraud claim, but if you have case law that says justifiable reliance equals due diligence, or if there is a complete absence of any investigation into the alleged fraudster's claims, then it was not justifiable to rely, then I need to explore this more with you. I think there's very much a question for the jury about justifiable reliance, but I don't think that there is no conflict in the evidence as to whether it was justifiable to rely on Mr. Hyder's representations, whatever they may have been, and we don't need to work through that right now. Was my question clear? I kind of went on, but.
No, it's clear. I understand what the court is saying. And I would agree that the stated elements of a fraud and inducement claim do not, quote unquote, use the term due diligence. They use the term justifiable reliance. And I think, though, that in the layman's way of speaking, due diligence is equated to justifiable reliance, or is a subset of a justifiable reliance claim, to the extent that in order to show justifiable reliance, you need to show that you did something that led you to believe or have a justifiable belief that the person who is making the alleged misrepresentation should be believed. So in the course of doing a real estate transaction, and due diligence is a term that is always used in the real estate industry to vet a deal.
It's often used.
Often used.
Yes.
Many times, most of the time. I mean, it's called due diligence, meaning that you go out and you go search out documents, people, information to determine whether or not you should go forward in a transaction. So
I know what it means. I'm questioning whether it is an element. Because I think I can think of fraud cases that where a purported victim could say, no, I didn't do any due diligence. It was Wells Fargo. Why would I do that? And I don't know that it would be a compelling argument to say they didn't go look up the latest 10K from Wells Fargo. But you may have case law in mind that says due diligence is really what justifiable reliance means. It's certainly a way one could argue that it was not justifiable to rely, but a lack of due diligence, you're saying, is fatal to that element. And I think it gives you a great argument. I'm reluctant to say that means there is in fact no claim that should go to the jury. That's sort of, if I can put a finer point on it.
all right, I'm moving on.
Okay.
Your Honor, would you like us to respond to each claim as they go, or just?
I'd like to hear everything from Mr. Kendall, and then I'll let you know which parts I'd like to hear from you on. So conversion is next.
Yes. 1 second. Conversion essentially means that you took something from someone that you did not have a right to take, okay? The testimony here was that, as far as I can tell, the thing that is alleged to have been converted are the monies that came in from the rental properties. And the testimony is that, well, we had a course of dealing that if there were things that needed to be done on the properties, Mr. Hyder had authority to go out and spend that money. Door needed replacing, he could spend that money, and we had no problem with that. And then the further part of that is that apparently it's not exactly clear, was that at some point in time, I'm assuming it was expected that the same thing would happen with the Verbena Street properties, that with regards to stuff that needed to be paid on Verbena, which are called carrying costs, that he would pay for that out of the money that he got out of the closing. He had a different view of that. He said the money came to him. Then there was this talk about in the emails about whether or not he was entitled to the fruits of his labor. And John said, absolutely. You know, it was plenty of time to talk about fruits, et cetera. And there are these 7 or 8 text messages there. And that is the sum total of, as far as I can tell, the conversion claim with regards to taking money out of the rental properties to pay for the things that were being done at Verbena Street. That he took money and didn't pay for things out of the Verbena Street costs, and he should have taken the money out of what he got from the closing. I'm assuming that that's what is being talked about as a conversion. I'm not actually clear on what it is that they claim has been converted. They have not been clear on what it is that has been converted. So that claim, in my opinion, fails for lack of specificity. We don't know what it is, what amount. They've not put up any evidence as to amount of the conversion claim.
Why aren't all the invoices from American Business to D2 indicating here's the rent that was earned, here's the part my understanding of the conversion claim is, I'm not plaintiffs and they'll explain when they respond, but I thought actually it was the clearer part of the case. It's not a very large pot of money we're talking about, but Mr. Hyder elected to redirect rents to payment of the $1 million promissory note. He even wrote it.
One time.
Well, one time or 50 times. My understanding is that the claim, it's what it says in the counterclaims as well, that it's the redirection of the rents towards those things. And that there does seem to be clarity around that. That would be cleared up in closing argument anyway. But the evidence is out there. It's those invoices, if that's the right term for it. But you know what I'm talking about.
Right, I do. But what I read in the counterclaim was that he converted deposits.
The security deposits.
Security deposits. I read that in the counterclaim. There was nothing in the counterclaim that I can recall about converting monies that were on the promissory note. There's nothing in there in the counterclaim that they put up, that they submitted about converting any money from the rental properties for purposes of the promissory note. There was a claim in the counterclaim about converting the deposit. And there's been nothing said in this case about conversion of security deposits.
Okay.
Okay. So that's what I mean when we leave a claim out there that's as loose as that conversion, and there's no testimony about what was converted, except that I'm assuming that he took money that, and this is kind of the only way I can make it make sense, is that he should have paid what are these quote carrying costs out of the $457,000. And that was converted, but that's not a part of the conversion claim in the counterclaim.
Agreed.
Yeah, the 450, that's not in the counterclaim. The only thing that's in the counterclaim is about these security deposits and some later rents that came in. But the testimony was that he had authority to take the rent money and pay for things that needed to have been paid for the residential properties.
Okay.
Let's go to tortious interference with contract. Now, this claim clearly falls because there's absolutely no evidence whatsoever that's been adduced here in this trial as to what contract was interfered with, whether or not they were a third party and he was a stranger to, and the Daltons were a party to the contract that was interfered with, whether or not he was a stranger or a third party to the contract that was allegedly interfered with. None of the elements of a tortious interference with contract claim have been made out here in this lawsuit.
So the allegation, the specific one, paragraph 299, is that, and it's in evidence now, those memorandums of management transfer that told the tenants, hey, by the way, your property's been sold. Don't worry about it. You can stay here, but your property's been sold. That's what's alleged was the interference, tortious interference with D2's relationship with its tenants. So there's something in evidence. If you want to tell me why that's not tortious interference, I'd love to hear about that, but I don't think it's correct to say that they haven't sought to support their claim. They're in evidence and they say what they say. Your client sent to all, not his tenants, D2's tenants, by the way, your properties have been sold. So that may not constitute tortious interference. That's what you should address.
Okay, the elements of a tortious interference with contract claim are that there was an improper action or wrongful conduct by the defendants without privilege. What happened was that Mr. Hyder sent a letter to these tenants and saying your management and the property has been sold / transferred and will now be under different management through this new firm. And my understanding was that he also transferred to that firm all of the security deposits. Okay. So there has to be some improper action or wrongful conduct. That's not wrongful. You may disagree with the language that he used to say sold / transferred because the properties were not sold and were not technically transferred. What was transferred was the management. Okay, and second element is defendants acted purposefully and with malice with the intent to injure. There's no evidence that he acted with malice and intent to injure D2. Third element is that the defendants induced a breach of a contractual obligation. There's no evidence that he induced any breaches. All of the tenants that were there when he was managing the property are still there after he left, still paying rent. There's testimony about that. That all these tenants are still there. They still own the properties. There's nothing that he interfered with to cause anybody to breach a contractual obligation. That's the third element of a tortious interference contract. The fourth element is that the defendant's tortious conduct proximately caused damage to the plaintiff. There's no evidence here. Nobody's testified that they were damaged by that transfer of the letter, that transfer letter where he transferred the security deposits and put the tenants on notice that he was no longer going to be their manager, and identified the new manager that would be taking over, given their phone number and address. Nothing whatsoever that makes that a tortious interference claim. Moving on.
Unjust enrichment.
Yes, unjust enrichment. Claim of unjust enrichment lies where there's no legal contract and the party sought to be charged has been conferred a benefit by the party contending an unjust enrichment which benefited the party, that the benefited party equitably ought to return or compensate for. There's a question here as to whether or not that was a legal contract or not. That was definitely a legal contract, at least for 60 days to purchase that property. Which is the only contract that Mr. Dalton signed. Then the only way we say that isn't a contract is that these verbal agreements that were banded back and forth, which the parties seem not to actually have a meeting of the minds on, which is also pretty clear that there was no meeting of the minds as to whether or not the plaza or the shops or whatever we want to call it. I think it's pretty clear that there was no meeting of the minds regarding that. So it's hard to say that there was a contract there because there was no meeting of the minds. Then we got this issue of the carrying costs, and I'm pretty sure we have no meeting of the minds there. There seems to be a lot of disagreement about what that actually meant and who means what to whom, what that means to each of these parties. So we got a first threshold issue on a unjust enrichment case is that there has to be no legal contract because this is an equitable principle and therefore not a legal principle, which means that there can't be an existing contract between the parties.
Sure, and you just spent the last 2 minutes telling me about no meeting of the minds. So I'm trying to follow you. You kept arguing things that would suggest, boy, the jury better work through this because after the 60-day contract is expired, no meeting of the minds on carrying costs, no meeting on the minds of what does shops mean, no meeting of the mind, et cetera. So there's not an agreement, but the allegation is that Mr. Hyder nonetheless received funds and he was unjustly enriched from receiving those funds, that the parties that provided those funds, D2 and the Daltons, didn't get a benefit from providing those funds. So I feel like you just talked into why the jury should work through this one, but I may have missed it.
Well, let me say, if there is a claim, this is probably the closest they get to a claim.
Okay.
Okay, so let me move on to the next, and that's fraud.
Promissory estoppel.
I'm starting with fraud. I think the last one is attorney's fee.
Promissory estoppel.
Oh, promissory estoppel, yeah. Well, that's basically the same as unjust enrichment to an extent.
Okay.
You can't have a contract, but there has to be at least a promise that somebody made.
I agree.
That there has to be a promise that somebody made, and it will work. It'd be a prejudice to one party not to make that other party make good on the promise. But the catch is that the promise cannot be vague or indefinite. The promise here, I'm assuming, is that Mr. Hyder obligated himself to provide financing for this transaction. That's 60 days. I'm assuming, because there's nowhere in writing, but they said that his statements that I can get this done went to his ability to get financing for this project. Now, the elements of a promissory estoppel claim are, number one, that there's a promise. Number two, that the defendants had a reasonable expectation that they could rely on the promise. I think that's lacking. There is no reasonable expectation on the part of the Daltons that they could expect Donnie Hyder to go out here and get $3 million within 60 days to buy a rundown, dilapidated apartment complex. And that the defendants relied on that promise, and that an injustice can only be avoided by the enforcement of the promise. Those are the elements. The elements that are missing, in my opinion, are, number one, the vagueness of the promise, because it can't be vague or indefinite, and the reasonable reliance element. I don't think either one of those elements, because they've stated, quite frankly, that we didn't do our due diligence and we should have, which indicates to me that you can't reasonably rely on somebody that you didn't vet, that you didn't actually go out here and check out. So I think that claim fails because by admission as well. And then finally, as to attorney's fees, there's no evidence in the record as to what these fees were. There is some evidence about what they were for, Womble Carlisle, but there's absolutely no evidence as to the lodestar factors, the amount of the fees in terms of hourly rates, the number of people that were working on the case, and the reasonableness of those rates for purposes of this particular case. None of the lodestar factors as to attorney's fees are present in this case. There's just a lump sum amount of $330,000 for attorney's fees. How many hours were spent? None of that evidence is in the record and has been testified to. In fact, before you can get attorney's fees, somebody who has familiarity with the amounts that were charged, the hours that were expended, the types of matters that were addressed, has to testify about the reasonableness of those hours, as well as the amount of time that was spent doing the work. There's no evidence whatsoever. And we can't go with attorney's fees because we don't have the evidence that's needed to make out a claim for attorney's fees under Georgia law.
Got
That's
it.
it.
Thank you, sir. Ms. Tucker, will you be handling this? Are you dividing it up or? Okay. So Ms. O'Neill, I'm going to walk you through this because there are certain areas where you can address anything you want to, but there are certain areas where I have specific questions.
Yes, sir.
I'd like to start with fraud. We're going to go in order of the claims, originally counterclaims as they were brought. Mr. Kendall emphasized for the fraud claim, the lack of due diligence, admitted lack of due diligence on the part of your clients as being fatal to the claim. Thoughts?
My thoughts, yes. Yeah. Engaging in due diligence is not a requirement of bringing money to our meetings. At best, my client's admission that they trusted Mr. Hyder when it's clear that they should not have. It's a question that the jury gets to consider. But conducting due diligence is not one. Whether or not you did may be a fact, which goes into the question of reasonableness of reliance, which I believe we have more than amply raised a question of, because Mr. Hyder spent an entire year building my client's trust for this. So the question for the jury is, in the circumstances that were presented to my client, was it reasonable for them to continue to trust him?
Okay. Conversion. There is an allegation about security deposits, and I shared with Mr. Kendall, and you were listening, hopefully, my understanding of what had been presented and what had allegedly been converted, which was rents that instead of going to upkeep on the residential units, the original 7, or anything like that, there are line items on 1 or 2. I thought it was 2, but the evidence is whatever the evidence is. There were line items that Mr. Hyder provided saying, and this I'm keeping because it goes to paying off my $1 million promissory note. I may be misapprehending your conversion claim. There certainly is reference to security deposits in your claim. That's not something the jurors will see. But if I need to protect the defendants from an argument that you might make in closing to seek to recover something for which there is in fact no conflict in the evidence and it's favorable to the defendants. And on security deposits, I don't recall hearing anything about 137.
137 has several letters, and this is in evidence, and Mr. Dalton just testified they never got into this. And it's that they all say this, all have this phrase or similar phrase that within so many days, you must turn over all rents collected on the property, all money held as security deposit for the properties, regardless of the date the security deposit was made. And we're looking for that since August of 2017. There are multiple letters in Exhibit 137.
And I don't know if there's evidence of this, but Mr. Kendall said, gosh, my understanding is that the security deposits moved over to that next management firm.
Dalton said, when I asked him about 137, if you got any of those monies, he said,
Okay.
and I would note for the record, Your Honor, it's our contention that the evidence, the pleadings conform to the evidence, and so where we started in this case and where we are now in terms of conversion, there's certainly a lot more about conversion. There's the money about Ms. Kimbrough needed these fees, and that turned out not to be true after we took her deposition. And you know, Mr. Trumbull needs these fees, and that's not really true. The, you know, what he supposedly had done, what my clients thought when we filed our counterclaims, but we understood and they believed Mr. Hyder might have done with some of that money, that 457. And what we discovered in the case certainly puts all of that into play in conversion because it was not used for what we thought it was supposed to be used. So while in response to the specific questions about security deposits, Your Honor, that's 137 and Dr. Dalton's testimony about that, but certainly think there's many other things here as well.
Okay. Tortious interference.
So again, on the tortious interference, if you look just at the counterclaim, at that time we were focusing on the issue with the tenants. And there is the question of those letters that went to the tenants and the work that had to be done because we kept asking. And this is again going back to 137 because we started asking in March for those keys back and for all of this so that we could get to city side because we wanted to transfer the property. And I don't have the other exhibit in front of me, but the letters to the tenants, I believe, are in May. So there's at a minimum with the tenants, a period of tortious interference when we are trying to manage our own properties, and Mr. Hyder is refusing to allow us.
But what are the damages caused by that?
That goes to those rents that I can't collect for there. And then there's also the Mr. Hyder we've entered into a contract. I'm sorry, you puzzle check.
Sure, I do. Well, because as I understand a tortious interference claim as Mr. Kendall does, and that there's some wrongful conduct. You're contending it is Mr. Hyder's refusal to effectively release the tenants, the security deposits, the keys, et cetera, to transfer from ABG to Cityside property. Cityside. And that was wrongful. I don't know about the intent to injure other than I guess it is preventing rents from flowing to your client, but it causes one of the parties to the contract, maybe the tenants, to breach, but rents were paid. So I'm wondering, this is, let me just finish. This seems a little bit like, not a square peg, but like an elliptical peg going into a round hole. And so it's almost as if conversion doesn't work, let's try to get at it this way. But I thought particularly compelling because people could spin and you could argue to the jury, Mr. Hyder was doing this maliciously because of the deterioration of the larger relationship between D2 and Bristol. And I think you're free to argue that and the jurors would decide what they want. That gets you element 1 and 2. But 3 and 4, the breach and the damages, I wasn't following as much. So walk me through that.
So with respect to the tenants, focusing just on the tenants.
Right.
This claim is more. It is as the court described. Those tenants, we demanded this back, so we or city side collect those rents, do those things. And because those tenants should have been, their contract is with D2. And Mr. Hyder refused. So there's a period of time where the tenants were all breaching their contract because we've now told ABG, you can't collect our rents. ABG is preventing the tenants from paying them to us because they are no longer our representative. And they, so it is the same damages. But I would also say, Your Honor, and both Daltons testified to this, Mr. Hyder's conduct, and they were both asked the specific question, very clearly testified to it, it caused them to breach the contract with Fowler Financial. Because their contract with Fowler Financial, and all of Dr. Dalton testified about this, the representations he made to Robin Fowler when he got the first lien note, when he got the second modification, when he got the first modification, the second modification, and the third, were all based on Mr. Hyder's representation that I got the financing right here. And so my clients entered into contracts with Fowler Financial specifically based upon that, and Mr. Hyder's conduct caused them to breach that.
Okay, but your tortious interference claim relates to, there's nothing about Fowler or anything like that.
Because at the time, we didn't have all the pieces, and the pleadings confirmed the evidence, and I don't believe that there's a requirement that we go back and we have the whole Fowler and the breach and all of that in the case as part of damages. It's not a new part of damages. It is the damages with respect to these damages are part of multiple claims, fraud in the inducement, unjust enrichment, et cetera, and I think they also fit under the conversion.
Okay.
I'm sorry.
Tortious interference. All right. What about attorney's fees?
The evidence is there for the attorney's fees, and Mr. Kendall himself asked for the invoices.
No, I
The
didn't.
reason that we didn't produce them in discovery in this case is no one ever served us with a request for this, ever.
I figured that. But what about Mr. Kendall's observation, and consistent with my experience, that there is a representative from the law firm who says, I am so-and-so, either I was the billing partner for this case or I work for the accounting office. This is how we bill. These are the bills that are unique to this work, because maybe we do other work for Dr. Dalton or for Brian Dalton. This is unique to this case. And these are reasonable because I practiced for 20 years. And for the type of work I do, X dollars an hour is a reasonable rate.
So both Daltons testified that this was just for this case. So I don't think you need someone from the firm to testify. They both were very clear that bills, Dr. Dalton specifically said, different, it goes to the case number. So, and in terms of the amount and reasonableness, there is Dr. Dalton's testimony that he's charged $400 or $500 an hour from his lawyers. So that's there. And there is Mr. Hyder's testimony about work that was done and how long things take, not testimony, text messages. And so with respect to the reasonableness, I think Mr. Kendall can argue that it's not reasonable, but Dr. Dalton testified about what the work was, testified about how it was so much more than had been done in these other cases, talked about the Court of Appeals, talked about the discovery, talked about the depositions, etc. So I think they can argue the unreasonableness, but there is no, I don't believe that there is, well, I agree, traditionally a lawyer comes and says, this is what happened. I don't think that is an absolute requirement for it to go to the jury.
Okay. Mr. Kendall, your responses to any of those arguments as the movement? You don't need to, but I just want to give you a chance.
I'll take the last one first. I think Ms. O'Neill is not cognizant of what Georgia law is with regards to attorney's fees. It is absolutely required that a person familiar with the time it would take to perform certain tasks, i.e. a lawyer, come in and testify that this was reasonable for the time and the matter that the lawyer spent on this particular matter. And it's also required that somebody has to come in and say, this rate that the lawyer is charging is reasonable for the type of work in this particular market. That's required in order to maintain a claim for attorney's fees. You can't have a layperson get up and say, oh, I paid $330,000 for my legal fees without having somebody else come in and determine two things. The hours were reasonable and the rate was reasonable and acceptable in that particular market for the work that was being done. There's just hundreds of cases on that.
So let me pause you there. There isn't, in fact, as I see it, but it may be hidden somewhere in here. It's a very long counterclaim. There's not a specific claim for attorney's fees. This is akin to the whole punitive damages piece, which we've dealt with. But there is a request that I'm reading from the paragraph that follows 324. Dalton Property Group, John Dalton and Brian Dalton request that judgment be entered in their favor on all the claims and that they be awarded damages in an amount to be determined at trial, but which is not less than $1 million.
Right.
So why does pleading it that way preclude plaintiffs from proceeding the way they did? They're making an effort to prove up damages, or I think it's the other side of the same coin. Pleading it this way, why does that trigger a requirement that for attorney's fees, there are these special things that need to be shown as opposed to the reasonableness of anything else they're asking for?
Well, because attorney's fees are like any other measure of damages. You have to prove that they were proximately caused by the claim that you have made.
Well, but the causes, I think it's the size of the fees we're working through. I think there is sufficient evidence to show that the plaintiffs in this case were caused to spend $330,000 as a result of this case. Whether that's a reasonable number or not is where I'm struggling.
And also, there is a requirement that plaintiffs mitigate their damage. So you can't come in and say, well, I spent $1,000 an hour for this attorney when it was a case that could have been handled by $250 an hour attorney. That's the part that requires attorneys to come in and say, this was reasonable for this particular type of claim, and the number of hours we expended was reasonable. A layperson wouldn't know that. A layperson wouldn't know how long it takes an attorney to handle a case of this complexity. Nor would necessarily a layperson know what is the appropriate amount for an attorney fees, hourly rate, in that particular type of case. That's why cases require that somebody, and it can be the attorney that actually did the work, to stand up and say, I did this work was reasonable. My fee is a market rate fee for this particular jurisdiction for the type of work that I was doing. That hadn't been done. They rested without doing that simple task. It's required.
Okay.
If I could say one more thing.
Nope. Anything else, Mr. Kendall?
On the tortious interference claim.
You don't need to spend time on that.
All right. I think that's all I got.
Okay. Yes, Ms. O'Neill.
I was just gonna say, Your Honor, the reasonableness issue that Mr. Trump was talking about, if I filed a 9/15/14 claim, totally agree, but I didn't.
Okay. So, and this is more for Mr. Hyder and Dr. Dalton and Brian Dalton. You all should know, your lawyers know it, that a directed verdict is a very appropriate request at this time, but it's a steep ask. It is basically saying, take this from the jury. And it can happen. It's actually going to happen to one of the claims in just a moment. But it's a pretty high bar that has to be met. I have to find that there is no conflict in the evidence as to any element to the claim. And if you construe all the evidence in favor of the person arguing that in fact, there's not a way for a jury reasonably to find that claim. And it's an appropriately high standard because we're here for the jury to work this out, not for me to decide they shouldn't do it. It's not my standard. It's what the appellate courts have said, but to me, it's a reasonable standard given what's being requested. But it's right for Mr. Kendall to bring this up now. I find that it is not appropriate to grant a directed verdict as to the fraud claim. I think the jury will get to hear all sorts of things about a lack of due diligence, but I think they will also hear a lot about what I would call experiential due diligence. In other words, the Daltons experience Mr. Hyder being a man of his word, being able to accomplish things, the go-getter, and maybe overstating what his abilities are. Is that enough to make their reliance justifiable? That's what our jury's for, but I don't think it's appropriate to take that question from the jury. I also think it's there's been all sorts of evidence about what misrepresentations may have been. Again, the standard is no conflict in the evidence, and Mr. Kendall has done an outstanding job to show where there are conflicts all over the place. And the reason why I'm not granting directed verdict as to unjust enrichment and promissory estoppel is because there are lots of places where maybe Mr. Hyder very reasonably had a different perspective on what the agreement was. And so he was, in his mind, living up to his end of the bargain, which would make it hard for a fraud claim. But if there's not a meeting of the minds, then we do default to unjust enrichment and or promissory estoppel. Conversion survives. I think that there is evidence that there were funds owed to property of D2 that Mr. Hyder redirected, whether it's the security deposits temporarily or for all time, which is some evidence the jurors have heard, or the rents or the other things that Ms. O'Neill mentioned. So I think that's appropriate to go to the jury at this juncture. Tortious interference, I don't think that there is evidence to show that wrongful conduct by Mr. Hyder that he engaged in with an intent to injure caused a breach and ultimately damages as a result of that. It's a creative way of trying to shoehorn another claim in based on the record, but I don't think that that's a claim that survives. And I'm going to hold off on ruling on attorney's fees. The record is closed for plaintiff on this. You can't now call a witness to add more, but I want to give both sides a chance to send Ms. Niles a case or two. I am well aware of the many, many cases. I can give you names, but all the principles that Mr. Kendall said are what I'm familiar with in the context of a 91514, when someone is justifying the fees that the other side is being asked to pay. But I would like, it doesn't need to be briefed, just if either side wants to submit cases by the end of the weekend to Ms. Niles that describe how it would be inappropriate for a jury to consider the $330,000 of attorney's fees as potential damages, or why it would be appropriate for them based on the record as it exists now. So I want to give you all a chance to get a quick break, but we're now 30 minutes past the break I told the jurors we'd take, and we really need to get through, if humanly possible, Dr. Fowler and Mr. McGuire, so that
We're ready to go.
okay. Well, but they're two sides, and it's Mr. Kendall's witnesses. So 5 minutes.
I'm ready.
You're ready? Okay. Court reporter. All right. You take your break and come back as soon as you can. We'll be right here. Thank you. Mr. Kendall, I'm gonna have Ms. Whitlock consult with the two clients. Are you neutral as to who goes first, as long as you're told who's coming in first?
I was gonna take Mr. Fowler first, so to your request.
Well, that was when I thought we would be getting Dr. Fowler in at 1. So if they have a preference and you're neutral, I just soon accommodate them.
I'm prepared to do Dr. Fowler first.
Dr. Fowler will be first. You can let them know. Thanks. You can be at ease. I'll be back in it before the court reporter.
I had to look up again, let me make sure it's right. There's two on that, makes it happen.
Okay, what?
I'm looking for it right now. That's up to Mr.
So, Mr. Kendall, do you want to actually call Dr. Fowler, or do you want to go ahead and be up?
You can go ahead and be up there.
Pull it up, call it, good to see you again. I don't remember. I was at your deposition. This is what you told me. So I'm gonna see there.
We have a little bit of issues with hearing people, so make sure that you.
And then he says.
Up to the conversation, especially.
Okay.
Yeah. Yes, sir.
No. In Russian. Try to figure out everything. Text.
Oh, you need copies. Okay.
Two of each.
Yeah. This is-
Yes.
Oh, you guys are screwing these up.
Ms. O'Neill, are you ready for the jury? You can take a seat. Okay, Mr. Kendall,
Yes.
are you Dr. Fowler?
Yes.
Hello. Thanks for your patience. Please.
All right, adjourned.
Thank you, Deputy. Welcome back, ladies and gentlemen. We are going to transition now to the defense presentation. In an effort to save a little bit of time, we already have the first defense witness here. Mr. Kendall is going to call him in just a moment, as in the witness is, and then the deputy will swear him in. Whoops, we got to get our court reporter in place. You're so quiet. I didn't notice you weren't here. I apologize. You ready? All right, our jurors are here, and the defendants are about to begin their presentation. Mr. Kendall, if you'd call your first witness.
Call Dr. Robin Fowler.
Excellent. Dr. Fowler, if you wouldn't mind standing up for 1 second so the deputy can swear you in, then you can be seated again.
You saw my testimony against the proposal, I did. I have his name before.
Robin Fowler.
Dr. Fowler, I'm Wayne Kendall. I think we met once before back in January of 2019 when I took your deposition. You recall that?
Yes, sir, I do.
All right. Dr. Fowler, we're here about this transaction involving the Verbena, what we colloquially refer to as the Verbena Street properties. You had some involvement in that project. Tell me what it was.
I had given a loan for the purchase of that project.
Okay, how much was that loan?
Initially, it was around $200,000 for a short-term loan, and then it increased, I believe, $2 million.
Okay. That first initial loan, was the exact amount $230,000?
I believe it was, yes, sir.
Okay. And you made that in a company that you own called Fowler Financial, is that right?
Yes, sir.
Is that company still in business?
As far as I know, yes.
Are you the owner of that company?
Yes.
But you are a full-time anesthesiologist that operates pain centers, is that correct?
I work part-time, not full-time now, but yes.
Okay. And you also went through residency with Dr. John Dalton, is that?
Yes, sir.
At Emory University Medical School.
Yes, sir, that's correct.
Did you guys do both medical school together and residency?
Just residency.
Just residency. Where'd you go to medical school?
I did my first 2 years in the Caribbean at Ross University, and then my third and fourth year mostly in Alabama.
Okay. And you're from Alabama, right?
Yes, that's correct.
And you live part-time here in Atlanta?
I'm living here full-time now. At
Oh,
the time of our deposition, I was living here only part-time, but I'm here full-time now.
okay. And you own a couple of pain centers around Metro Atlanta, is that right?
Yes, that's correct.
Okay. Would you consider yourself a friend of John Dalton?
Yes,
And is it true that your family and his family socialize together?
yes,
You go on vacations together?
yes.
And does that continue to this day?
It has been a while, but we certainly have done that in the past.
Okay. Now, you made the first $230,000 loan initially to D2 for purposes of controlling the property that was out at Verbena Street, which we call the Verbena Street properties, right?
It was for that property. I don't know. I'm sorry, I didn't hear you
The
clearly.
question was, for the purpose of controlling that property is why you made the initial $230,000 loan.
I don't know about controlling. I just made a loan for that property.
Okay. And then sometime later after that initial loan, you made a $2 million loan.
I believe that is correct.
And out of that $2 million loan, the initial loan was paid back to you. Is that right?
That I don't really recall the flow of the money, but it was either 2 or 2.2 million. I'm one or the other.
All right. Now you had an attorney that represented you in these transactions. Is that correct?
Yes.
And who was that? Who was that attorney?
Sam McGuire.
Okay. And Mr. McGuire is an attorney that specializes in real estate transactions. Is that correct?
Correct.
Okay. You trusted what he did for you in these transactions. Is that a fair and accurate statement?
Yes.
Okay. How long was the term for the $2 million loan that you made to acquire the Verbena Street properties?
I don't remember the exact terms of the length. It was, supposed to be for a short-term loan. Probably 3 months, 4 months, if I,
Okay.
estimated.
And how did you become to get involved in making that loan?
I was asked by John if I would be interested in loaning the $230,000 for a short term so that they could work on getting permanent financing. And then that was taking longer, I believe. And I was approached and said, would I be interested in loaning a larger amount, the $2 million, for a short term till they could get permanent, more long-term financing.
And I want to correct something I asked you earlier. That initial loan was not to control the property. It was, as you just stated, to allow them the opportunity to seek permanent financing.
As far as I'm aware, yes.
Yes. Okay. Now, was Mr. McGuire, your attorney, involved in the transaction whereby you loaned $2 million on a short-term basis?
Yes.
Do you know if he prepared documents for that transaction?
I would expect that he did, representing me.
Now, do you recall that the terms of that loan were that no interest was to be paid on that loan until the loan was actually extinguished?
I do not recall the details.
Okay.
Sorry.
It's okay.
That's fine. At some point in time, you extended that loan because it was not extinguished as per the terms of the loan. Is that right?
Yes.
Do you recall how many times you extended that loan?
I believe it was 2.
Okay. But could it have been 3?
It could have, I believe it was 2, but
Okay.
it could have been 3. I'm just not sure.
All right. And you were paid a fee when the loan was extended?
I believe that is correct.
Okay. Despite the loan being extended, you ultimately decided that you needed to foreclose on that loan. Is that right?
Yes.
And did you have any discussions with John Dalton about foreclosing on the loan?
I don't really recall any discussions directly with John Dalton. I, do recall, my direction through, or, with my attorney, Sam McGuire, and, I believe they had communications.
Okay, and so Mr. McGuire, is your understanding, would have communicated with Mr. Dalton, John Dalton, regarding the foreclosure?
I think so.
Okay, so do you recall when this loan was foreclosed upon?
Just vaguely, I believe the loan was given in 2016 and the foreclosure took place in 2017.
In September of 2017?
That sounds about right. Yes, sir.
Okay. Now what happened after you foreclosed on the property? Did you maintain the property? Did you try to sell it? Did you try to develop it? What happened?
The most immediate need I felt like was that the property needed to be secured. At the time, it had a lot of debris. There was a lot of unauthorized people on the property. I thought it was a big liability, so I got insurance on the property and fenced the whole property off. I believe it was about a 14-acre ordeal, and then began having the property cleaned up.
Okay. How long did it take you to do those activities?
I think approximately about 6 months was
Okay.
spent cleaning.
And at some point in time in 2017, you started to have some thoughts about trying to either sell the property or develop the property. Is that correct?
Well, I really had never expected to be involved from that standpoint. And once the property was foreclosed on and became mine, at that time, I had to start considering options, what to do with the property to try to recover the loan that I'd made. And I had, I met with Atlanta Housing Authority. I kind of bounced ideas around, but then that was all during that 6 month time frame. And then I made the determination that, me trying to go forward with any type of further work on it just was not something I was interested in. And I would rather just sell it to try to recover my finances.
But during this period of time, and during that 6 month period of time, Mr. Dalton made some proposals to you as to how he could get back in the property. Is that correct?
I don't really recall any discussion directly with Mr. Dalton or anything specific. My interest in doing any type of development was minimal, and short-lived, if at all. So it wasn't really something that I had an interest in entertaining.
All right. So after this 6 month period of time, you decided to sell the property. Is that right?
Yes.
And you found a buyer.
Yes. I mean, it went through, I didn't myself find the buyer. It was listed through a commercial real estate broker and agent, and also.
And who was that commercial real estate broker?
Ty Underwood.
Ty Underwood. And Mr. Underwood found a purchaser for the property.
Yes.
And that purchaser was a company called MJ Partners?
Yes.
And you sold the property to that group?
Yes.
Do you recall when that was?
It was in 2018, and I believe it was about 11 months after I had taken possession because it was still in a short-term tax bracket.
Okay. So you wanted to get rid of it within a year? Is that it?
I just wanted to get rid of it. There wasn't a time frame. I just wanted to recover my
All right.
loan money.
And you sold it for $3.6 million. Is that right?
I believe that's correct.
And roughly that sale took place approximately 1 year after the foreclosure.
That's the 11 months after. Yes.
Right. And is it true that your original loan was $2 million?
I thought it was 2.2, but 2 to 2.2.
Okay. And after you, how much do you think you spent securing the property and putting the fence around it and any other improvements that you made on the property? How much do you think you spent?
It was hundreds of thousands of dollars. Just some figures that I remember is I think there were about 70 40-yard dumpster containers that had to, that was used in the cleanup. There were over 1,000 tires that had to be disposed of and, paid to be disposed of and such.
You said 1,000?
Yes, sir.
That's a lot of tires.
There were cars there that had to be hauled off and taken to junkyards. I had bobcats there cleaning the property, a lot of debris, landscape companies, but I think it probably approached 500,000-600,000, but it was a few $100,000.
Okay. Did you come out on top?
I don't know what you mean by that question.
Did you make a profit off of this deal after you spent that money that you just described? After you got back your $2 million, out of pocket, any other out of pocket costs you had?
Well, from the sale, of course, there were expenses for legal fees and closing costs and agents and such.
Right.
So there was, I would say a net profit of, a few $100,000. And then the reason I say 11 months is because I remember it was a short-term capital gains. So then another 40%, I think about, went to taxes. So it netted out a few $100,000 capital gain.
Okay. All right. Are you in the real estate business currently?
I'm not in the real estate business, though.
Okay. I think that's all I have, Mr. Fowler.
Ms. O'Neill, do you have any questions for Dr. Fowler?
I'm going to show them these. Hello, Dr. Fowler. We met at your deposition. I'm Elizabeth O'Neill.
Yes, ma'am.
Could you pull up Exhibit 3 for me, please?
Dr. Fowler, you should be able to see on the screen in a little bit, whatever it is they're talking about. There it is.
Okay, got it.
Dr. Fowler, I'm going to represent you that Exhibit 3 is an email that a lawyer named Crystal Kimbrough sent to Abe Vaknin, who was the original owner of the Verbena Street properties at the beginning of this whole transaction. And you see there in the second sentence of the email, it says, at the time of the transaction, the buyer requested his loan terms to be confidential, so I cannot provide the buyer's settlement statement to you. I am not authorized to disclose the buyer's loan terms or anything related to their loan. Did you ever instruct a lawyer named Crystal Kimbrough to keep the terms of your loan to D2 and the Daltons confidential?
No.
Did you ever instruct her to withhold that information from the Vaknins?
No.
Did you ever instruct my clients that they were to tell Ms. Kimbrough to keep those terms confidential?
No, ma'am.
So if in 2018, Ms. Kimbrough told this to Mr. Vacnan, you're not whoever she's referring to as the buyer. Fair?
Could you repeat that? I
Yeah.
didn't quite
You
understand.
can't possibly be the buyer Ms. Kimbrough is referring to because you didn't give those instructions to anybody. Is that fair?
I would say that would be fair. I don't know anything about this communication.
Did you foreclose on this property in order to eliminate the interest or any interest that Mr. Hyder or Bristol Consulting may have had in the property?
No,
Did whether or not Mr. Hyder and or Bristol Consulting's interest might be affected factor into your decision-making?
no,
Did you give my client any portion of the proceeds of the sale from Verbena Street property?
no, ma'am.
Mr. Kendall referenced the deposition that he took of you on January 16th, 2019. Do you remember that?
Yes, ma'am.
Memorable experience, right? In that deposition, did you tell Mr. Kendall that you had not made $1.6 million profit?
I would think I did.
I'm going to show you a copy of your deposition and refer you to page 32. Drop things on the floor. I've got a copy of the report.
Thank you.
Page 32.
I'm gonna have to object to the procedure of showing the witness his deposition testimony unless there's some foundation laid that he is being impeached by his deposition testimony.
I'm giving it to him to refresh his recollection because he said he thought so. And so I'm going to ask him to read his answer.
But don't take a look at it yet. So
I'm going to ask him, this is what I intended to do.
I understand what you intend to do, but I'm just working through Mr. Kendall's good point here. So you're contending, Ms. O'Neill, that Dr. Fowler's answer was sufficiently unclear that you ought to be able to refresh his recollection.
Yes, I do not intend to read anything into the record. I would during an impeachment.
So what is your question of Dr. Fowler before he looks at the transcript so I can see if we're going to do that?
Yeah, my question was, at that deposition, did you tell Mr. Kendall that you in fact did not make a $1.6 million profit? And his answer, I believe, was, I would think so.
Okay.
Like him to see if he did.
Well, I mean, I can clarify that. I mean, I do think that's what I said, but I wanted to make sure that I was accurate in my answers here today.
Okay. Well, we're good. Thank you.
Good.
Thank you, Mr. Kendall.
Take that back. Mr. Kendall, do you have any objections to those exhibits that I just gave you?
No, we do not.
Dr. Fowler, I'm going to show you what we marked as exhibits 280, plaintiffs 282 through 289.
Thank you.
Can you identify that for me, please? It's not-
Every one of them, or
Just generally, what do they pick?
Yeah, just, you don't need to describe each one, but if you flip through them and then can relay to the jury in general what these are.
it looks like the Verbena property after the cleanup was done.
After the work that you described, that you did after foreclosure?
Yes, ma'am.
Those are all my questions. Oh, nope, I'd move into evidence 282 through 289.
No objection.
282 through 289 are admitted.
Those are all my questions. Thank you.
Mr. Kendall, anything else for Dr. Fowler?
I have one other question. Dr. Fowler, when you did this loan to D2, the $2 million loan I'm talking about, did you understand that you were lending money on the apartments and the plaza or the shops, the commercial part of that?
I don't really, I went and saw the property at one time. And I mean, I visually saw all of that together, but to be honest, I can't distinguish if I thought the loan was, included or didn't include the strip mall. I just thought of it as, the Verbena property, and I thought the collateral was enough to secure the loan amount.
Okay. After you foreclosed on the property, did you ever ask Donnie Hyder if he would sell the shop property to you?
Right, this is a little bit beyond the scope of the process.
Mr. Kendall?
Well, it is.
Okay. All right, thank you. Ladies and gentlemen, if you have any questions for Dr. Fowler, please write them down and pass them to your right, and the deputy will pick them up. Thank you, sir. Ms. O'Neill and Kendall. I understand what Josh said. I'm just processing.
Yeah. So these are the appraisal.
Than that, you have any concern? Sure. Yes. To cover their loan, to cover. That's how I'm going to ask them, unless you concern. So see anyone recommend do that. Thank you. Dr. Fowler. Back. How did you determine that the Verbena property was valuable enough to be security for your loan?
At some time I had seen, I think, an appraisal or something similar, that valued it at, what I thought was a few $100,000, I believe it was, around, I don't know if it was an old real estate report or an appraisal, but, and I can't remember how much it was for, but I thought that it would be enough to.
Whatever
reasonable
it
collateral.
said gave you the confidence that you would be secured.
Yes.
Okay. Did you ever have any conversations with either of the Daltons concerning cutting Mr. Hyder out from any compensation or earnings that would flow from whatever you or D2 might do with the property?
No, sir, I did not.
Did anyone advise you to engage in all the cleanup and restorative work that you did on the Verbena property?
No, that was my own decision.
And if you could recap again your estimate of what you think your net profit was ultimately when you were done owning the Verbena property.
After tax and everything, I think it was probably around 300,000 to 400,000.
Okay. And the loan, the actual 2 million or 2.2, whatever the dollar amount of the second larger loan was, did you ultimately sign that paperwork, or did you authorize an agent of yours, an attorney or someone, to sign the loan paperwork on your behalf?
I just do not recall, but it is likely that I, would have given, the power of attorney to my attorney to do transactions.
Okay, and that would be Mr. McGuire?
Yes.
Okay. From the time you acquired the Verbena property through the foreclosure up until you sold it, were you or your corporate entity the only owner of the property?
Yes.
All right. Mr. Kendall, any follow-up based on those exchanges?
No.
Ms. O'Neill? Dr. Fowler, thank you for your time. You're free to go.
Thank you.
Mr. Kendall, your next witness?
We call Mr. Sam McGuire.
Have a good weekend.
Can I just leave this?
Yes.
72.
Yes.
Yes. Mr. Kendall says yes. This trial will go into next week. Let's not keep anyone guessing. We all have to watch the Hawks game tonight. We can't be here. Beat the process.
72. 73.
I'm sorry we started without you. I completely forgot. That was not intentional. That was on me. Oh. I would be surprised if that trial took 6 days. We got to go by what they say, so there are no surprises, but it's a crash case. Yeah.
Yes.
If that, unless it's it would have to be if there's a battle of the experts. We haven't done these auto accidents. It's here's what happened. And then it's the chiropractor says, and usually there are no experts. It's bills. Now we're waiting on Mr. McGuire. Ms. O'Neill, I'm going to return to you the Dr. Fowler deposition transcript, but thank you for providing.
Yeah, 84.
You want to go?
Right up here, Mr. McGuire. All right, before you sit, I'm gonna have the deputy swear you in, and then you can assume the position.
You qualify customers to get to the court.
Yes, I did.
All right, I received his name, so I report.
My name is Samuel Fisk McGuire Jr.
You can take a seat now. And Mr. McGuire, you are welcome to keep your mask on if you'd prefer to do that. We have an understanding that the lawyer questioning the witness and the witness can be mask free so that the jurors can hear them, but that's not a requirement. If you're more comfortable with it on, you should keep it on.
Mr. McGuire, my name is Wayne Kendall. We met previously when I took your deposition some time ago. You recall that?
Yes, sir.
Okay. You are an attorney, right?
Yes,
More specifically, you are an attorney who specializes in real estate transactions. Is that also correct?
yes,
Okay. You previously represented the interests of Robin Fowler in his company called Fowler Financial in its interactions with D2 Property Group on Verbena Street properties. Is that right?
yes.
Okay. Describe to the jury what exactly your involvement was with that particular project.
I prepared the loan documents and made sure that they were secured properly,
Okay.
and also made sure the money was secured.
Okay. There were two loans made on that in that particular project. One was an initial loan of $230,000. You recall that?
Can you be more specific?
Yeah, that was a loan made to D2 for purposes of securing permanent financing through one of their proposed lenders. And that was a small $230,000 loan that was made by Fowler Financial to D2 Properties. Do you?
I don't think I was part of that.
Okay, all right. But then there was a second loan for $2 million. You were a part of that, were you not?
Yes,
And you interacted with the closing attorney in that deal, who was Miss Crystal Kimbrough.
yes.
Okay. So what documents exactly did you prepare for that transaction?
I mean, I don't have like the list off the top of my head.
Did you prepare loan documents?
Yes, sir. If you want to identify each loan document, I can tell you if I prepared or not.
Okay. Let's look at exhibit. Can you turn it in that book there? There should be two white notebooks up there. And one is from 1 to 36 and the other one is from 36 to 107. And I'm not sure what
I
it's.
just have one book that goes to 36.
Okay, there should be a second.
The others are all blue binders, it looks like to me, Mr. Kendall.
Oh,
It's hiding.
I had my foot on it.
Okay,
And what number are we looking for?
number 84.
Thank you.
Well, y'all got a lot of documents.
Welcome to our world.
Okay,
All right, is that a document you recognize?
this is a document I recognize.
Okay, did you prepare that document?
I mean, it's something I would prepare. I can't tell you if it's exactly what I prepare, but it's something I would.
Okay. Yeah, I'm gonna move to admit number 84.
Any objection to defendants 84? 84 is admitted.
Okay. This document is a commercial loan agreement, is that right?
This document's payoff. Oh, now I'm looking at the screen.
Yes, you can look at the screen. This document, you said this document is a payoff?
I was looking at 84.
Yeah,
So I can understand the confusion. I'm not quite sure what's in your binder, but 84 in my binder is what's on the screen. So that would explain why you're not recognizing it.
Let's see.
No, it's after the tab. So after 84,
Oh, okay.
that's 84.
Oh, I'm sorry.
Okay. So you may want to reset your questioning. It's in evidence. There's no objection to it, but you may want to ask
yes.
from the get-go as to this document.
Is this a document that you prepared?
This would be a type document I would prepare. It just looks similar to what I used.
Okay. And this would be the, assuming this is your document, this would be the document that you would have used to document the $2 million loan to D2 property, right?
Yes.
Okay. Now, look over on the previous document, the one that you were looking at before, document 83, which is the payoff, the document you identified as a payoff. And tell us if that is a document that you prepared.
This would be a type document I would prepare. Yes.
It's got your letterhead up there at the top, right?
It's my letterhead. Yes.
Okay. And what's the date on this document?
April 2nd, 2017.
Is that April or August?
Oh, excuse me, August.
Okay. I'm going to move to admit 83 if we have not already done so. I think it's already in.
It stays in.
Okay, thank you. The principal loan amount on this loan that was made, that this payoff references is $2 million, right?
Correct.
And then,
We go, this one happens up before your own, you have to scroll up, so Dr. Dalton.
oh, yeah, right.
Oh, right.
Right.
Thank you. I forgot. This is the infamous 83. It is in evidence. Okay.
Right, yes. Do you recall also that pursuant to this payoff document, later on after this document, in fact, the next month, you were involved in the foreclosure of this $2 million loan?
I don't remember the dates, but I did foreclose on this one.
Okay. And you prepared the foreclosure documents on this loan, right?
Yes.
Okay. And as a result of that foreclosure, Fowler Financial took possession of that property, Verbena Street properties.
Yes.
Nobody bought the property at the courthouse step at the foreclosure, right?
No, nobody did.
Okay. Did you personally knock the property off on the foreclosures?
Did I do the crime?
Yes.
No.
You hire somebody to do that?
Yes.
Okay. Now, after this property was foreclosed upon, although you don't remember the date, but it was after this document was prepared. Did you or were you involved in any discussions with Mr. John Dalton about reacquiring the property on behalf of D2 property?
I don't remember.
You don't remember? Okay. I want you to look at document number 73.
Okay.
Do you recognize this document? I'll give you a minute to read it. Put this up, it's already in evidence.
He's ready for you.
Okay. Do you recall what's being stated in this document?
Vaguely, yes.
Okay, did you have any discussions with John Dalton regarding reacquisition of the property over the several weeks prior to writing this particular email?
From my memory, I don't recall exactly the whole reacquisition or that process, but I do remember there was multiple different ideas that we were discussing within this email. Frankly, I just don't remember the timing of any of this.
Okay. Do you recall ever having any discussions whatsoever with Donnie Hyder concerning the reacquisition of this property?
Any conversation I had with him would be brief if there was any. I just don't really recall talking to Donnie.
Okay.
Hardly at all.
Did you have any discussions at all with Mr. Fowler, your client,
Discussions with what?
about selling this property or having a joint participation with John Dalton?
I don't understand your question. I mean, are you asking what?
I'm asking you, do you recall having any conversations
I mean,
about
I recall this email or recall what it says, but I mean, if I said I had a conversation in this email, I had a conversation.
Well, I'm asking you specifically, do you recall your client agreeing to the terms that you outlined in this particular email?
The objection on that question, Your Honor, which is as phrased, it would require, in my opinion, McGuire to disclose attorney-client communication, which may be privileged, and I don't represent anybody to that, but I'm aware of the privilege. And Dr. Fowler's lawyer is here, but not able to raise an objection to speak about that in both privilege. So I reject the form because as phrased, I think it strays into that territory.
Mr. Kendall, what I understand you're trying to get at is, does this email represent something that Dr. Fowler was comfortable proceeding with?
That's correct.
Okay, I think that's an okay question. You can word it how you want, but I'm okay with that.
Yes. I'm not trying to get to his communications with his client. I'm just asking him if what is represented in here is consistent with what his client wanted.
I can't answer whether it's consistent with what he wants. I can't answer that.
I mean, you're not representing something to John Dalton that on behalf of Robin Fowler that Robin Fowler didn't authorize you to represent.
Specifically what?
Specifically what you got in this email.
What is in this email is accurate. I always say accurate things.
The question is that consistent with what your client, Mr. Fowler, agreed to have you represent to Mr. John Dalton?
Still, I mean, I think the question's vague.
You wouldn't put something in this email that Dr. Fowler didn't authorize you to put in the email.
That's a correct statement.
Okay, that's all I'm asking. After this closing took place, you filed a claim against First American Title Insurance Company on behalf of Fowler Financial. Is that right?
I don't remember that, but if you have something.
Turn over
look
to,
at.
yes, turn over to Exhibit 81, please, sir. You see that document?
Yes,
Did you prepare that document?
this is something I would prepare, yes.
Well, I'm asking you specifically, did you prepare this document?
I can't tell if I prepared that document. This looks like something I would prepare.
Okay, what's the, Your Honor, I'm going to move to admit this particular document.
Any objection to defendants 81, Ms. O'Neill?
No, no objection.
It's admitted.
Thank you. 81 up, please. Okay, what is this document, Mr. Fowler? I mean, excuse me, Mr. McGuire.
It's a insurance claim based on a lender's policy.
Okay, and was this a lender's policy that had been issued for the benefit of Fowler Financial related to the Verbena Street properties?
Yes.
Okay, and what was the purpose of filing this claim with First American Title Insurance Company?
After closing, there was just numerous FIFAs and liens that were still not released. And we wanted to make sure that we're in first position. And the closing attorney that handled the transaction was unresponsive.
The closing attorney that handled the transaction was unresponsive?
Yes.
Is that what you said?
Yes.
What do you mean by unresponsive?
Sent her several emails, wouldn't take phone calls, asking for the evidence that the title's clear. She recorded the instrument and she couldn't prove the title's clear.
Okay. So you filed this claim. How was this claim handled by First American Title Insurance Company?
What do you mean how?
Do you want to know what happened with the claim or?
Was it resolved?
I don't remember exactly how it was resolved, other than they contacted basically their agent and forced her to comply.
So what did she do to comply?
She, from my memory, she contacted the basically the parties that had liens against the property, or the parties that had the ability to be able to remove the liens, and she got them removed one by one. But it was a hard process.
Okay, but ultimately she resolved the claim by having the liens removed.
Yes.
And those liens were removed to your satisfaction. Is that correct?
Yes, correct.
Okay. Let me ask you a couple of questions about the foreclosure. Prior to the foreclosure, you sent notices out to Mr. Dalton, giving him notice that the Fowler Financial intended to foreclose on the property. Is that right?
That's a correct statement.
Okay. And you also sent Mr. Dalton a text message indicating that the foreclosure was going to be a friendly foreclosure. Is that right?
I used the word friendly, but I don't know if it was a text or email, but it definitely used friendly.
Okay. Turn over to page 72. Tab 72, exhibit 72. Does the body of that document, and this document has already been admitted. So let me put that up. Okay, does the body of that document look like the text message that you sent to John Dalton?
Yes.
Okay, my question to you is, what do you mean in the text of that communication about the term friendly foreclosure?
Friendly is a term to me that I just basically put on it when parties are open, communications free, and people are, they realize that they can't pay the loan back, but they're communicating with you. And then a non-friendly foreclosure is one where you have to go strip it away and use the instruments as a power of attorney and force them to give the property back. And those are the two differences.
Okay, now, a friendly foreclosure is when you take the property by noticing the foreclosure and actually going through the foreclosure process, but it's friendly because the parties are communicating.
Communication's open.
Communication is open. And an unfriendly foreclosure is where there's no friendly communications and you take the property in the same manner. It's just that there's a communication difference.
Communication is probably the key core element, that you have an open communication.
Okay. And that's what you meant by friendly.
That's what I meant by friendly. It's a term I use.
Okay. Meaning I'm going to take your property, but we still talk.
It's always good to talk. It's always good whenever you're taking property from someone, as long as they're communicating with you, then it just goes so smoother.
Right. But you still take the property.
Of course you do.
Okay. Now, the second sentence there, it says the main purpose is to wash the title clean and transfer a title to Robin minus any possible liens that may be out there and not shown of record. Right? That's what you said?
But I said that, I mean, that's.
Now, explain that to us.
When you foreclose, the best way to cleanse a title is to foreclose instead of like a deed in lieu. So you take a deed in lieu, you still have liens against it. But if you foreclose, it gives you legal rights against the property that are superior to other people's interests. So it's the best way to cleanse the title.
Okay. Now, you just told me that as a result of that claim that you filed against First American in that title, that had been resolved and that you were satisfied that all of the liens had been taken care of, right?
Yes.
And that was in September sometime, is that right?
I don't know the exact date, but if it's September, it's September.
September 2016, I mean. Well, we can go back to that document. Document number 81. Well, I may be wrong. This document does not have a date on it. Does not have a date. Okay, so you've explained number two, sentence on number two. Let me ask you about the last two sentences in this text. Where you said the buyer is still investigating, and once he appears again, I will bring you into the discussions. What does that mean?
This is, I mean, like I'm trying to remember. I mean,
Okay.
So the bottom line is, we really didn't want to foreclose. The bottom line, just really didn't want to because he's a personal friend of Robin's. You know, it's painful to have to do that. And he had visions of wanting to make money on the property. And so I had some contacts that possibly, you know, someone may come in and buy it, you know, and then therefore he could have a windfall. But, you know, no one wanted to spend any money. It just took a lot of money to, you know, basically improve it and get it to where it needed to be. So really that was really the intent of this, is just trying not to foreclose, to be honest with you.
So you were negotiating with people who were potential buyers of this property?
Yeah, I represent a lot of developers and we really didn't want to foreclose, the bottom line.
And you were out trying to find someone, a developer perhaps, who would come in and rescue this transaction so that Mr. Dalton could make some money on the property. And you had some people that you were talking to that, as indicated by that last sentence, that says that I have another buyer, I am pitching in Miami too. So you had multiple potential buyers.
I have multiple clients.
Okay. All right. That explains that. Other than filing the claim against Ms. First American title, did you have any other involvement with Ms. Kimbrough in this transaction?
Other than painfully closing the loan with her,
You mean the $2 million loan?
the $2 million loan that she handled the disbursement of.
Okay. What was the pain in closing that loan? Vis-a-vis communication?
Communication was just really poor.
What about the work that she did?
Pretty poor.
Okay. Did the work that she did cause your client, Robin Fowler, any damages?
What's the relevance of damages to a non-party?
It's just part of my presentation here is that I just want to know, he said that she did poor work. I want to know.
You can ask what the poor work is.
Yeah. Let me go at it that way. Can you identify the poor work that she did?
First of all, I was very formal with her. We required certain elements for funding, and she was very difficult on being able to follow direction. And then the ultimate crescendo was when she was trying to pay off one of our loans, and her computer was hacked, and she was sending money to Fowler Financial to overseas. So we had to invoke First American again to come in and get our money back. Because for a while, the money to pay us off was lost because of a hack on our computer system.
Now, wait a minute. The money to pay you off. What money was she paying you off on?
We had a small, what I remember, a small little loan. It was like a small little loan to pay us back.
That $230,000 loan.
I don't remember exactly what it is, but there was a small amount that was given to Mr. Dalton, Dr. Dalton, and that we wanted it back. But I don't know if there was any loan documents per se. That's what I wasn't part of that.
Okay.
I was part of recovery of the funds, initial funds that were given to him. And those funds that she mishandled so poorly that we had to bring First American in under the CPL letter that was issued demanding for indemnification of all the funds immediately.
Okay. Do you know if my client, Mr. Hyder, had anything to do with any of that?
I didn't know who he was.
Okay. What else other than the mishandling of the disbursement?
So the settlement process was painful because she wouldn't follow direction. Communication was painful. Mishandling the funds. The post-closing with all this landmines of liens, just atrocious. Had to get First American involved. And then that's it right now. I mean, that's at that stage. You know, later stages, there's more.
Okay. Yeah, I think that's all I have for Mr. McGuire.
Thank you, Mr. Kendall. Ms. O'Neill, do you have any questions for Mr. McGuire? Ladies and gentlemen, I know it's 5, but I think we can wrap up this witness and break for the weekend then. I'm seeing some nodding heads, so we'll wrap up.
I promise I'll be short.
Ah,
I promise. Can you pull me up Exhibit 3, please? Hello, Mr. McGuire. You know I'm Elizabeth O'Neill. We've met before. show you a document that's been marked as Exhibit 3 and already admitted into evidence, and I'm going to represent to you that this is an email Crystal Kimbrough sent to Abe Backman on May 25th, 2018. See there in the second sentence of the email, it says, at the time of the transaction, the buyer requested his loan terms be confidential, so I cannot provide the buyer's settlement statement to you. I am not authorized to disclose the buyer's loan terms or anything related to their loan. Did you ever give instructions to Ms. Kimbrough to keep the terms of the Fowler loan to my clients confidential?
No,
Did you ever instruct Ms. Kimbrough to withhold from the Vacnins the buyer's side of the HUD one?
no,
Did you at any time have any conversations with my clients, John Dalton and Brian Dalton, about cutting Mr. Hyder out of a deal?
no,
Did you at any time ever have any conversation with my clients, Brian Dalton and John Dalton, about about preventing him from getting any money
no,
or extinguishing a lien he might have on the property?
no.
I'm going to show you two more documents, which I should have sitting on my desk so I can hand them to you. These are already in evidence, and I'm just going to hand them to you so you don't have to look through books. These are exhibits 46 and 25. So take a look at those for me, please. Did you draft these documents?
No, I didn't.
Those are all my questions. Thank you.
25 and
46?
you're not, were they already in?
They're already in.
They're already in, so he just didn't have to plow through the binders to do that. Okay, all right.
I'm just 506 on Friday.
Thank you so much. Mr. Kendall, any redirect for Mr. McGuire?
No.
Ladies and gentlemen, if you have any questions for Mr. McGuire, now's the time to write them down and pass them to the right, to the deputy. Thank you, sir. Mr. Kendall and Ms. O'Neill. Mr. McGuire, in your experience handling real estate transactions, do you have a perspective on the importance of doing some cleanup work on a large parcel like the Verbena parcel after your client acquires it, but before it gets sold, if the goal is to sell it? Does that make sense?
You're asking two different questions.
Okay, I'm only trying to ask one. So I'm just trying to frame it properly. In your experience from your profession, does it occur that someone who would buy a property like the Verbena property that was in a dilapidated state might engage in some cleanup work before selling it if the sole goal is to sell it, not to rehabilitate it and have people occupy it, et cetera?
Yeah, when you close a transaction, specifically, when the transaction was painful, your radar's up as an attorney. So my radar was up that something's wrong on the title. So I was really concerned based on the whole process. So
what I don't want you to do, and my question wasn't meant to do this, is to have you disclose things you may have shared in confidence with Dr. Fowler, but just generically. Okay.
Yeah, this is all generically what I do.
Okay.
I mean, I'm hired to make sure we have clean title. And so that's what I do for a living. And I just didn't think it was clean. So based on the performance of the attorney, so I did a check down after the fact and found these errors. And so it's not the fact that you're trying to sell the property. It's just really, it's like bookends. You close it and then you want to make sure the title's clean. And then you're set for a period of time to either develop it or do whatever.
Okay, I understand your answer and my poor phrasing. I'm focused on the actual real estate. Having a client engage in cleaning up the physical property because it poses a hazard or it wouldn't be sightly to the people who might want to buy it. Is that something that happens, that a client buys a big old parcel that's in disrepair and engages in some cleanup, not a full rehab, but some cleanup before marketing it?
Yes, Your Honor. Yeah, because there's a lot of, like, as soon as you buy the property, there's instant liability. So if it's in dilapidated state, you must clean it up, you must secure it, and you must get it to where it's not going to be a liability to you.
Okay. You defined for the jurors what you meant by a friendly foreclosure, the open communications, et cetera. Does that term friendly apply in any way to this concept you described of cleansing the title, or that's the result of the foreclosure?
It's two separate things. It's bifurcated. The foreclosure is just an awesome tool to basically cleanse the title. It's just one of the best tools we have in Georgia to cleanse the title. The friendly part is the fact that you've got open communication. You're not worried about the person destroying it on their way out, that type of thing. Versus a normal foreclosure, the key is you're concerned that they're going to, do all kinds of damage, rip out the toilets, rip out whatever. We don't have toilets in this case, but I mean, I'm just making that as an example. And the more communication you have, the easier it goes. The property comes back in a good state and it's not been torched.
Okay. Can we put up the February 10th, 2018 email. I don't know the exhibit number, but it's in, I believe it's a plaintiff's exhibit so that they can put it up. If not, I'm going to ask Mr. Kendall's team to put it up. But there's a question about language in there, and I think it would be helpful for
February 10th, that's going to be.
February 10, 2018 is what the question says. It's an email from Mr. McGuire to Dr. Dalton.
73.
Okay.
We have. Yeah, put it on. He's got it up.
Great. So the question, and you'll be able to read the specific language in a minute, Mr. McGuire, but there's reference in the second paragraph, both the second and the third to Donnie's parcel, and then Robin, Dr. Fowler, receiving emails that include Verbena and Donnie. And the question is, what do you mean about the need for, two questions. What do you mean about the need, what was meant about the need for Donnie's parcel?
This particular parcel has so many, it's broken up. There's it's like you've got a plat, you got individual lots, and then there's another plat, if I remember, across the street. And then Donnie had this, basically it's kind of like a bookend. I mean, to be able to develop it, you needed to buy Donnie's parcel because he fits like perfectly within one section of it. Because if you're going to develop the whole thing, you've got to have his piece, and then you've got to also acquire some more land around.
You close that sentence with the clause, only you can deal with Donnie. What did you mean? The you would be Dr. Dalton. What did you mean by that? As opposed to you, Sam McGuire, dealing with Donnie or Dr. Fowler?
I don't have any relationship with Donnie. And so Donnie was introduced to me through the transaction as a business partner, and I wasn't part of that.
Okay. Had you ever met Mr. Hyder?
No, sir.
So it sounds like you were aware, and this is the question, that your client, Dr. Fowler, was acquiring a large piece of property that was, as you put it, missing a parcel because Mr. Hyder owned a contiguous parcel.
The spirit of this email, and to answer your question, was we did not want to foreclose. Our solution was, the key is, instead of making the cookie a certain size, let's make the cookie bigger. But this cookie was going to be too big. It's going to cost too much because you needed to acquire Donnie's parcel and other parcels, as well as it's going to take a significant amount of money to invest in it. And so that was kind of the spirit of trying to go down that road to see if it was possible.
Okay.
And,
I want to rewind the clock a little bit, though, because I didn't ask my question well. At the time that Dr. Fowler was deciding to loan the $2 million, and we saw your document about the setting up that loan, do you know if he, Dr. Fowler, was aware that the security for that loan, the property that D2 had, did not include what you later came to be describing as Mr. Hyder's parcel?
I can't speak on behalf of Robin.
Okay. What about you? What did you know?
I didn't know anything.
You were asked to put together the loan agreement.
Yes, sir.
Okay.
Yes, sir.
That makes sense. Mr. Kendall, any additional questions based on this exchange with Sam McGuire?
No, yeah.
Ms. O'Neill?
No, Your Honor.
Mr. Kendall, is Mr. McGuire free to go both today and released from the subpoena?
He is.
All right. Thank you, sir, for your time. All right, ladies and gentlemen, before you stand up, let me get all of this out. It's not very long. First, thank you for your time and attention so far this week. We've made great progress, and we are back on schedule, having gotten through Mr. McGuire today. It does look like we'll be going into Tuesday, as you think about what you want to take care of this weekend. So thank you. Number two, you're home away from home. Next week is 8F. You move one courtroom down. You have been residing in Judge Brasher's courtroom, and he's the presiding judge next week. You can't be in there because people are going to be coming in with all sorts of issues, and it would be interesting, but it would be disruptive. So when you report on Monday, go to 8F as in Frank. It's the last courtroom on this hallway. So just like you've been doing, just go a little bit farther. And the deputy will retrieve you from 8F when it's time to come in here. Number three, on Monday, get here at 9:30. You're welcome to get here earlier, but we have some things that I know we need to take care of. And people are going to get here early, but they will take longer than 9 a.m. And I get agitated as you're being made to wait, but there are important things we need to work through, and they will take at least through 9:30. So you don't need to be here till 9:30. Some of you like to get here at like, dark 100. You can do that again. Just go to 8F. Don't come here or to 8E. And then finally, don't take your notepads home. Those should stay with your stuff. So if you're putting stuff in your bag, you're welcome to leave your bag right here. Don't leave it. In fact, you should, if you have things in 8E, you should get them and bring them here to 8D that you want to leave behind, because 8E is going to be put to other purposes starting on Monday. But then when you claim 8F, you can start leaving your stuff there again. But the gist of that was, don't take your notepads home. That's for you to use and review when you're here working on the case. Finally, and almost as important as the thank you, please no outside research. You've got a whole weekend to say, I still am not so sure what a friendly foreclosure is. Don't type that phrase into Google. You got your answers. A friendly foreclosure means whatever you heard here in court. That's what it means. No outside research. Don't talk to other people about the case because you don't want to inadvertently elicit that know-it-all telling you, friendly foreclosure. Funny you should mention that because they don't know what this case is about. Any logistical questions? Be safe. Go Hawks. We'll see people Monday morning, 9:30. Appreciate it. So based on my instructions, they may be coming back in here to bring things from E to D. If there are a lot of things we need to talk about outside their presence, we should wait till the deputy comes back. Ms. O'Neill, do you have anything that we're going to need to talk about before your side leaves for the weekend? Mr. Kendall?
No, sir.
Mrs. Hyder, I'm sorry that I'm going to be keeping your husband away from you some this weekend while he's at that warehouse. But I'm sure he will spend some time there looking for those documents. I apologize that that's going to interfere with family time. All right. We'll see everyone. Ms. Kimbrough was instructed to be here by 8:45 on Monday. So you all should be here by 8:45 because she's going to have a few questions to answer under oath without the jury in the room. That's why I'm having the jury show up at 9:30. I've got proposed jury instructions from both sides. Ms. Niles has been massaging those, and we'll see if we can get a draft jury charge to people maybe late Monday. We'll see.
We are, and I indicated this yesterday, we are going to send revised ones. It's not seeking to damages, so we'll get those out this weekend. If there's anything else that you wish to change, we'll file.
So you don't need to, we've pulled punitives out. You don't need to resubmit one that says, no, we don't want that. Those are gone. We're not putting anything in about tortious interference. You don't need to revise that. The only thing your side or Mr. Kendall's side needs to submit would be if you've got something new, not a subtraction.
Okay, thank you.
Sure. And then I look forward to getting whatever case law you do choose to share about the attorney's fees question. We need a redacted version of Defendant's Exhibit 83 at some point for the record and before it goes back with the jury. And I think that covers my list. Thank you, everyone. Thank you, Madam Court Reporter. You too.
Number 83.